Thank you for watching us tonight. Well, the Factor is on live, so we're monitoring what's happening in Leon County right now. We're going to go back and forth. Anything happens there, we'll bring it to you immediately. And the Talking Points memo, first of all, is about what happened today. George W. Bush was within one vote of the presidency, but he didn't get it, and now the country has been thrown into chaos, politically speaking. So what happens now? By a 4-3 vote, the Florida Supreme Court has ruled at many votes in Florida that the machines rejected must now be counted by hand, and counted fast, because on December 12th, Florida must certify its 25 electoral votes. Now, the problem is just who does the counting? Newsweek magazine reports that the counting in Broward County, which delivered more than 400 new votes to Gore, was so arbitrary it was ridiculous. Partisan Democrats were making judgment calls that made Republicans furious. This is what is so unfair about the Florida ruling today. The hand recount is subject to all kinds of partisan shenanigans on both sides. Plus, there's so little time that mistakes are bound to be made. Look for the feds to step in and stop the madness. There was nothing legally wrong with the initial Florida machine vote, and fair-minded people know it. The Florida Supreme Court did not cite any legal precedent to defend their action today, even though the U.S. Supreme Court has demanded one. In fact, in a scathing dissenting opinion, the Chief Justice of the Florida Supreme Court says the decision has no legal basis. Let me repeat that. No legal basis. So I fully believe the feds will reverse the Florida Supreme Court's decision, and the initial machine vote will stand, giving Governor Bush the presidency. Simply not fair to all Americans to have a hand count that cannot possibly be without bias decide this election. Remember, machines have no bias, people do. To be quite fair, it is possible Al Gore did win Florida. We'll never know for sure. But all the evidence points to the fact that no laws were violated during the initial machine count, and that is why the initial rulings upheld it. The Florida Supreme Court, by all accounts, is political, activist. It's, not legislating. It's not deciding law, it's legislating. But the law is not on their side, and I believe that will be their undoing. Let's hope the feds act quickly before the country is damaged any further. And that's the memo. Now for the top story tonight, reaction. First up, Carl Cameron with the Bush campaign in Austin, Texas. And Carl, what I want to know is how the Bush people found Judge Anthony Kennedy so fast. It was like, wham, were they hiding in the garage or what?
Well, one of the things that they obviously recognize that it's Anthony Kennedy who has jurisdiction over the Florida federal circuit courts. So their natural appeal to him for this emergency stay is partly demanded because of the protocol and the structure. It helps them, obviously, in their minds that Anthony Kennedy's questions and his position throughout the arguments before the U.S. Supreme Court seem to lean heavily towards Bush's position.
But the speed that they got to the judge, they were like right there. So they must have been anticipating this, as you had been hinting this week.
Absolutely. I mean, they knew, they took a little inventory of the judges on the Tallahassee, Florida Supreme Court. They had a very strong idea which way this was going, and had pretty much predicted that they were going to lose. So they had all of their appeals and all of their stay requests, et cetera, pretty much written. All they had to do was drop them. One presumes that they had a good idea where they could find Justice Kennedy, too.
In the next 2 hours, we have a couple of things that could happen. Judge Kennedy has the power, as Judge Napolitano, who we're going to talk to in a couple of minutes, pointed out, to stop this whole thing in its tracks. And he's got the paperwork right now. Is that correct?
That's right.
All right. They also...
He could do it unilaterally.
Yeah.
He could do it by himself, or he could confer.
Stop the madness. Stop the madness. But also in Atlanta, the federal court there has the paperwork already, and they could issue a temporary stay to stop the hand count and stop all the state activity, correct?
Yeah, the Bush campaign let us know several weeks ago when they said, look, we need to be in the appeals court and in the U.S. Supreme Court depending on how this goes. That was a signal back then that they were using placeholders for this eventuality.
All right, so we got two things in play that could happen at any moment. So I want all the viewers to stay tuned to The Factor and the Fox News Channel. If the Supreme Court Justice Kennedy rules, he could stop it. If the federal court in Atlanta rules, they could stop it in its tracks. One more thing, Carl. We heard Jim Baker citing the Chief Justice of the Florida Supreme Court saying this decision has no legal basis. Is that the prevailing wisdom here? Because it doesn't seem that these four judges would put themselves in that kind of jeopardy.
Well, you know, Justice Wells, the Chief Justice of the Florida Supreme Court, couldn't have written it any better for James Baker's actual speech. They were delighted by this. One senior Bush insider said that they were frankly a little surprised that the three justices they did get went with the Bush position. They were not entirely, they were almost expecting a 7-0 blowout.
Really?
So the fact that they got 3 was a good sign. Now they believe that that will be a huge signal to the U.S. Supreme Court, and ultimately they have the Chief Justice of the Supreme Court of Florida arguing their case
on their
for
side.
them.
Yeah, on their side. Okay.
Absolutely. Sure.
Carl, please keep us posted. We're going to come back to Carl Cameron if anything at all happens. He'll be standing by till about 4 in the morning, I think, Carl, so have a lot of fun out there. Now let's go to Jim Engel in Tallahassee, Florida for Gore reaction. Now, initially they had to be euphoric, Jim, but now you got any, you know, as we told Carl, as Carl told us, I should say, that Judge Kennedy could stop this in its tracks and the Atlanta judges could stop it.
Well, they were euphoric when it first happened, but they knew very well that the Bush people were going to appeal. And Justice Wells, the opinion you were talking about, the dissenting opinion from Chief Justice Wells, was very strong on this point, and he, in fact, predicted, Bill, that this would, in fact, be overturned. He says, I believe the majority's decision cannot withstand the scrutiny, which will certainly immediately follow under the United States Constitution. That means the U.S. Supreme Court. He also criticized the whole notion that the majority had undertaken here, saying that there is no meaningful standard that they're really laying out
no
here.
Legal
and
basis.
That they have created a they've created a constitutional crisis. Obviously the majority, as you suggested a moment ago, they did base their decision on lots of legal precedent and their interpretation of the law. The difference is Chief Justice Wells says they're wrong about the law and they're wrong about Florida statutes.
You know, both camps have got to be on edge. Nobody's celebrating tonight. Jim, we got to run because we got lots of stuff going on here. I want to introduce Judge Andrew Napolitano, a Fox News legal expert who is with us in the studio because we might have to cut out and go to Leon County and see what they're doing there. But, Judge, you've got your folder here and you've been reading the decision. I mean, you're really a smart guy. But I don't want to go through all the minutiae here, all right? Bottom line on this, what do you think is going to happen? And then we'll bring you back to explain why.
The Supreme Court of the United States will, either through Justice Kennedy alone or through a majority, stay the counting of the ballots and reverse what the Florida Supreme Court did.
All right, so right now in Leon County, they're talking it over, but this will probably never come to pass, at least for a while. They'll stop that and shut that down, in your opinion.
Yes, Justice Kennedy will either do it tonight or tomorrow morning, again, alone, or a majority of the United States Supreme Court will do it. And again, as Carl told us, he can do it all by himself, or he can confer with the other 8.
Do you think Kennedy's got the brass to do that by himself?
Yes,
Do you really?
do.
All right, let's take a break, and then the judge will explain why Justice Kennedy is man enough to make this. Boy, what a decision that is. And we'll have more on this, so please stay tuned. Anything could happen at any moment. Factor will be right back.
If making money were simple, we'd all be millionaires. Let's face it, money decisions are tough decisions. You need to know what's going on here and how it will affect your finances, your future, and your family. We cover the markets in plain English so that when the bell rings, you can understand what happened and decide what's right for you. We bring Wall Street to Main Street so maybe you can live on Easy Street.
Fox News Channel, Primetime Power. Neil Cavuto, Brit Hume, Shepard Smith. Powerful coverage. Wall Street, Washington, the world. Bill O'Reilly, Hannity and Colmes, Paul Lazan. Powerful insights, confronting the politics, the newsmakers, and the issues. Primetime Power, fair and balanced. Fox News Channel, the most powerful name in news. We report, you decide. Fox News Channel Daytime. You want to make the right choices. We give you the power to decide for yourself. Fair and balanced. The most powerful name in news. Fox News Channel. We report, you decide. You Decide 2000. Exclusively on the Fox News Channel. Powerful coverage from America's election headquarters. Review. Shepard Smith, Bill O'Reilly, Hannity and Colmes, Paul Lazan. Fair and balanced reporting from America's election team, giving you the power to decide. You Decide 2000. From the most powerful name in news, Fox News Channel. We report, you decide.
Opinions. I have them, you have them. In fact, on any given subject, there are as many opinions as seats in this theater. And that's good, people speaking out, sharing ideas. But opinions are not the same as facts, and you should know the difference. And that's why at the Fox News Channel, we label all opinions right on your TV screen. And that should help you form your own opinion, so you can decide what's right and what's wrong. You are looking at live pictures of the Leon County Court in Tallahassee, Florida, and they're deliberating on how the ballots will be counted, who will count them, where they will be counted, all of that stuff. We will bring you any live action that happens. We'll cut right into the factor, but we'll continue now with Fox News legal analyst Judge Andrew Napolitano. You know, it's really interesting because this Florida Supreme Court, the four guys who voted for Gore's way had to know that all hell's going to rain down on them.
Yeah. You know, I don't want to speculate. I don't want to question their integrity. I think they probably did it because they believed they were doing the right thing under the law. But I think they made the law up. And the Chief Justice says it in his dissent. There's no foundation on the law of Florida as it existed on November 7th, 2000 for what they did.
But that's exactly what the U.S. Supreme Court said. Show us the law. Instead of show us the money, Jerry Maguire, they said show us the law.
They did not do it. They mentioned once, and they quoted verbatim, the federal statute saying you can't change the rules after 6 days before, and then they didn't address it. They didn't do anything with it. They just cited it.
This is what I don't get, and I'm sure everybody watching tonight who's been following this case, we don't get. We have the U.S. Supreme Court saying to the Florida Supreme Court, hey, we don't see the law.
Right.
You got to show us the law.
Right.
Then they go back, and they issue this decision, and then the three justices who dissent say, there's no law. So where are these other four guys coming from, or people coming from? Where's the law?
Well, I said it earlier, I think this is a thumb in the eye of the Supreme Court, of the United States Supreme Court.
Wow.
They are not going to send this back to Tallahassee again.
No.
Hey, guys, we gave you your chance. This is it. You're going to create chaos throughout the state of Florida. What votes are to be counted? Where are they counted? Who's going to count them? What's the standard? What type of a Chad do we count? And the U.S. Supreme Court's going to put a stop to this.
Now, right now, Judge Kennedy's probably watching The Factor along with everybody else, and he's listening to you right now. And you said before we went to the break that you think this man has the cojones? Is that what, I mean, you know, to make this decision by himself? Well, this is huge.
Justice Kennedy is part of the center-right group on the court. His questions to Professor Tribe and to Ted Olson during the oral argument 10 days ago showed a real deep concern with whether the Constitution was being followed, that is, whether the Supreme Court of Florida was usurping the legislature, and whether this federal statute, which says you can't change the rules, had been violated.
But for him to do it unilaterally, to stop it, to put all the pressure on him, you know how these judges are, Judge. You know how they are. They don't like to fight that kind of scrutiny.
When you're on the Supreme Court, when you're the highest law in the land, when you're infallible because you're final, when you have lifetime tenure, you do these things from the point of view of history. He'll know he's doing the right thing for history. Not for the moment, but for history.
He might call the other guys and say, look, you know, what are we going to do?
He eventually has to call. The stay that he issues...
Temporary.
Right, has to be temporary.
Right.
So ultimately, he must call them. But the Bush people have a good argument. Here's Governor Bush's argument in a nutshell. If the recount starts, this may so undermine public confidence in my being elected president. It will be irreparable harm.
Well, that's what the Atlanta federal judges are hearing tonight as well, and they may rule before the Supreme Court rules.
They may very well do it.
All right, Judge, you're a genius. Thanks a lot for coming in. We appreciate it. You've been working all day, and we really appreciate your time. Up next, we'll have reaction from the U.S. Senate. Two powerful senators will be here as the factor continues.
We object to that as well, Your Honor. Okay, well, without being too formal, what I'd like to do is, I assume everybody at these tables has read the opinion and knows what's going to be required. It seems that there's two different things. One is what we're going to do with the Dade County ballots that are here already.
No.
You know, we agree on just one thing. A good argument's the best way to get to the core of an issue.
Wait a minute, I don't agree with that. A discussion's the best way. You have to explain, reason, justify your position.
Everybody on TV is discussing things, Alan. That's boring. If you want to find out what people really think, you need a good argument.
No, a discussion's better.
An argument.
A discussion.
We can agree on this. It's your turn to pick up the check today.
Well, I'll argue that one.
Alan, let's see if we can discuss this.
Remember him? He was such a jerk.
A complete jerk, but so cute.
So wrong.
Yeah, but
everybody told you.
I know, but I didn't want to hear it.
You listen to me.
That's different. I trust you. When you tell me something, I know it's the truth.
Well, in that case, trust me. That was one ugly dress.
Fox News Channel, powerful all day. John Scott, Bridget Quinn, David Asman, bringing the world to you, making the issues clearer. Powerful hour to hour. Linda Vester, Shepard Smith, Neil Cavuto. Breaking stories, aggressive coverage. Powerful all day, fair and balanced. Fox News Channel, the most powerful name in news. We report, you decide.
胸騒ぎの夜、フォックスが待っている、エンターテイメントが待っている。夜9時、ロディオショーに命を懸ける男たち、人命救助 SOS。夜10時、凶悪犯罪捜査ファイル。夜11時、警察24時。夜12時、巨大な嵐が街を飲み込んだ。追跡、生死を分けた大暴風。夜9時、悪魔に狙われたジャイルズ。バフィー恋する十字架。夜10時、マジックの裏側公開第2弾。破られたマジシャンの掟パート2。夜11時、厄介な被告に手を焼く弁護人ザ・プラクティス。夜9時、陰謀に巻き込まれた少女を救えトゥー同じ顔の悪魔。夜10時、腹部を食いちぎられて死んだ元サーカス団員 X ファイル。夜11時、殺人現場を映し出すホームページミレニアム。胸騒ぎの夜、フォックスが待っている、エンターテイメントが待っている。人命救助 SOS 凶悪犯罪捜査ファイル。全米警察24時追跡生死を分けた大暴風。バフィー破られたマジシャンの掟パート2ザ・プラクティス。2 X ファイルミレニアム。吹き抜けるハリウッドの風、今日本にもうフォックスしかない。
A moment ago.
Well, was that a statewide standard?
No, it was not, Your Honor. It was only. That's why I say the only standard in place that we're aware of was that one regulation.
You are listening to arguments in Leon County, Florida, in front of Judge Terry Lewis. This man speaking right now is an attorney for George W. Bush, and the judge did something very interesting. He asked both the Bush and Gore attorneys to make suggestions on how he should rule about the hand recount. They're going to make those suggestions to Judge Lewis, then he's going to deliberate for a few moments, come back and tell us what he's decided. All right, let's come back to the factor now. In the Impact segment, every American has been affected by the Florida Supreme Court ruling, whether they know it or not. So what do our leaders think? Joining us now from Washington is Republican Senator Tim Hutchinson from Arkansas, and here in the studio, Democratic Senator Frank Lautenberg from New Jersey. Reaction to the ruling, what do you think is going to happen now?
Well, Well, to create a new one raises the same issues. If there is no standard, then what the standard is chads that have been punched through.
I think maybe it's a matter of semantics. I think the standard is what the Supreme Court says it is, because that's what I'm bound by. Well, what you're looking at is what criteria can be used by the people who count it to determine or to apply that standard.
And that's an excellent way to put it. And we have evidence in the case through fact and expert witnesses that bear on the criteria that ought to be employed. And we'll make our legal arguments later, but just in terms of the practicalities of what people ought to be doing if they're going to be looking at ballots, we think that Your Honor needs to not hear all the evidence over again, but at least be directed by the parties to the evidence that we both think is relevant on this issue, so that Your Honor can fashion criteria that people will be able to use. Otherwise, we're going to have people, I don't know how many people, what Your Honor is going to order, applying a purely subjective sense of the voter's intent. There were canvassing board members to just give an example of the testimony at trial, there were some canvassing board members who said that the only time that they could discern voter intent was if there was a ballot and there was a pattern of dimples or imperfections indicating that somebody tried to vote but failed because they didn't follow the directions and they put the ballot on top of the machine instead of inserting it in the machine. And they said if they, this was, for example, Judge Burton from Palm Beach. He said that if he could see a pattern like that, then he, in his mind, felt comfortable saying that this voter intended to vote but simply failed to punch the chat all the way through. He said that in his mind you could not ascertain.
Bush Attorney Phil Beck arguing for a go-slow approach in the start of a manual recount statewide. We're going to continue to monitor this hearing. We're going to take a quick break. When we come back, more of this hearing from Leon County in Tallahassee.
Off.
Well,
he's furious. Sure. That's why he recused
because
himself.
He was wrong in his
I don't know
decision.
about that. And he may be proven right by the U.S. Supreme Court.
Well, it's going to be interesting, but the one thing we know that this race is still alive.
It's alive. Oh, yeah. I mean, and our ratings are getting bigger, and the country's getting hurt more, and that's what teased me off, Senator. I just hate what it's doing to the country.
The country is going to survive this. The country is works very well.
Bitterness.
No, my gosh. Listen, if we could go back and make friends with the Germans after World War II, in which I served, and make friends with the Japanese after World War II, the fact of the matter is that these things come together, and we're much stronger than either one of the examples.
Do you agree with that, Senator Hutchinson? I think the bitterness here is just mounting and mounting and mounting.
The country is being hurt. The country will survive, but there's going to be more uncertainty after this recount, if it's allowed to start, than there was after the original certification. And yes, Frank and I will get along and we'll move forward, but there's going to be the bitterness after impeachment is going to be mild compared to what we have after this.
There'll be some anger.
Yeah, and not only that, but the folks are getting hurt with the economy, and we saw the futures. I know the Florida Supreme Court held back until after the stock market closed. I know they'll never admit it, but they did. 2 minutes after the market closed, they made their decision, and the futures went like this. And, it's enough already. Isn't it enough already,
Bill,
though?
One thing, the market was not affected by these delays. The market was affected.
Senator, have you seen your 401k lately?
Alan Greenspan made a statement about
every time Al Gore's mug goes on the air, the Dow goes down 100 points. Come on.
No, when Al Gore's mug went on the air, the market went up 500 points from where it was a couple of years ago.
All right. And what do you think, Senator Hutchinson? I mean, Senator Lautenberg's smarter than I am.
But apart from the stock market, there is no doubt that we're 3-4 weeks behind in a transition to a new administration. That is going to hurt whoever is
yeah, but I'm not worried about those guys. They know what they want to do. They'll be able to run up a huge expense accounts at the taxpayers' expense.
Well, right now it's not at the taxpayers' expense.
Right. That's an interesting point, that they both raised money, Gore and Bush, privately to fund all this chaos. Now, but last question for you guys. Isn't it the responsibility of the U.S. Supreme Court, Senator Hutchinson, I'll let you, and I'll give you the last word, Senator Lautenberg, to stop the madness now? Stop it, rule definitively. Let's get this done.
I see only more chaos if they don't step in and end it, and I hope they do it. I hope we have a stay and a quick decision overturning the Florida Supreme Court, and I think we will.
All right.
Well, I think it'd be awful difficult to say to those people whose votes were not counted properly, to say, listen, we're going to have the court take over and decide that your vote was not one to be counted.
Gentlemen, we appreciate a very, very busy night. Now let's go back to Leon County, and you haven't missed anything. If there's anything going on, we're going to break in. And here they're still telling the judge what they think should happen in the hand count that was ruled today by the Florida Supreme Court. Let's listen in.
60 votes out of 100 for Al Gore, 30 votes out of 100 for George Bush, and 10 undervotes. And those were the certified votes that came in with the machine recount. Now then, when they did, and then they took all the ballots and put them all back together again so that they weren't segregated, Gore, Bush, undervotes. Then when Judge Saul said, bring down the votes, or bring down the undervotes, those ballots, they had to take these ballots and basically resort them. to segregate out the
part of the matter, and that issue still hasn't been resolved after 2 days of a trial and after a circuit court decision and a Supreme Court opinion. We're back to arguing about the same thing that we began the court hearing last weekend with.
All right, David, stand by. I want to go back to that hearing and listen to Phil Beck explain his side of the story.
Undervotes. But they didn't actually come up with votes for Gore and Bush. They didn't keep records of that. They just came up with 17 undervotes. So what we have is a situation where on election night, 7 votes that are now in the stack of undervotes were already counted for somebody, whether it was Al Gore or George Bush. And so now, in my hypothetical precinct, and I hope Your Honor is following this, we've got a problem where 7 votes are going to be counted twice. And I know that Mr. Boies says let's count every vote once, but not even he says we should count them twice. And it's not anybody's fault. It's certainly not Mr. Boies' fault. And it's not really, we're not faulting the people from Miami-Dade. It's just a problem that was discovered when they segregated the votes out again. So we've got this mess on our hands in Miami-Dade. We don't think it's ever going to be possible, frankly, to get an accurate count of undervotes and be confident that you're not counting votes that have already been counted for Al Gore once before. Now, so we've got Miami-Dade. That's a problem we're going to have to deal with. What we've got also, though, is...
You're not telling me what you want me to do. You're telling me why I can't do it.
No, I'm telling you what I think you ought to do, Judge, with the other counties. And that is tell these counties that job number 1 is to segregate the undervotes in a way where they keep records, accurate records, this time around, of how many votes are being recorded for Bush and how many are being recorded for Gore and how many are being recorded as undervotes. Instead of just giving us a new stack of undervotes, what they should do is basically take the votes, the ballots, run them through the machine again, get a new tally. It doesn't mean the new tally is going to be binding on the court or anyone else, but to get a new tally so that we know when we get the stack of undervotes, if it's different from what we got on November 8th, we'll at least know how many the machine thinks voted for Gore and how many the machine thinks voted for Bush, and we'll have 3 sets of numbers that add up to the number of people who voted. And then we'll have some records that we can figure out the significance of later. But if we let the counties go forward and just segregate out the undervotes without keeping those kind of records, then we're going to have a horrible mess on our hands, and we're going to never be able to feel confident that votes are not being counted twice.
Let me see if I'm not quite sure I understand you. When they did the vote, didn't they already segregate out?
No. What happens is they run the ballots through the machine.
Okay.
And the machine does not. The machine just takes the ballots in the order in which they're put in, and they stay in that order. But the machine counts how many of them are for Gore, how many of them are for Bush, how many of them are for more than one candidate, which is an overvote, and how many of them are for nobody, which is an undervote, and it spits out the numbers. Now, but they don't, unless they've already done a manual recount where they've segregated them out, there's no reason for them to put them in different stacks. So they've never done that.
Okay.
Now, what I understand this to be the case in Miami-Dade, that they had software that I'm not sure the other counties even have at this stage, but they were able to run the cards through and do a sorting. And that's the first time it was ever done because Judge Sauls ordered them to segregate the undervotes and send them up here. Now, I don't believe that any of the other counties ever had any reason to do such a sorting.
Okay.
If they've done such a sorting already back on November 8th, great. Then they should keep the ballots exactly as they were on November 7th or 8th, the last time that they were looked at. But we believe that in the vast majority of the counties, no such sorting has been done, and we're concerned that counties are jumping the gun and beginning to do the sorting, and they're going to do it in a way that doesn't create a new tally for Gore, for Bush, for Nader Buchanan, and the rest of the candidates, and therefore we'll never be able to figure out how many of these votes are being counted twice.
When they sort them, how do they tell the ones that were undervoted?
I'm sorry?
When they do the sorting, how do they tell which ones were undervotes?
Well, I'm not sure how the machine can tell which ones are undervotes. I'm not sure how it physically separates them out. That's a question that I don't know the answer to. The way the machine works, if that's what you're asking, is when you punch a Chad out, then what happens is light shines through the ballot. And when the light shines through the Al Gore hole, it's counted as a vote for Al Gore. When the light shines through the George Bush hole, it's counted as a vote for George Bush. And the machine keeps track of how many times the light shined through for Al Gore and how many times it shined through for George Bush. But it doesn't spit out the Al Gore votes on the one side, the George Bush votes on the one side, because after all, there's a whole bunch of races that they're counting for. So somehow or another, Miami did it, but in the process, I don't believe they kept records of what the machine said about the number of Al Gore and George Bush and Pat Buchanan and Ralph Nader votes. And so we're faced with this problem in some of the precincts where there are now more undervotes than there were on election night, which means that these new undervotes were already counted for somebody before, the first time they went through the machine, and now they're going to be counted for somebody a second time. And people are going to have their votes counted twice, which of course
Bush attorney Phil Beck explaining the complexities of counting the so-called undervotes, those votes that didn't register for any presidential candidate. We're going to continue monitoring this hearing in Leon County. Right now, we want to take a quick break. We'll be right back.
Once there was a lawful election in Florida, November 7th, and a certified set of electors, this legislature has no legal authority to go in and superimpose its will over 6 million voters.
All right, but that's debatable. That's your opinion, but that's debatable and at this point.
Well, you know what? It's really not my opinion. It's the opinion of many, many legal scholars around this country.
So it'll be another mess, is what you're saying.
I think we're going to add to it.
Right. All right, Ms. Frankel, we appreciate your time very much tonight. Fed's got to stop it. All right, we're going to take another break. You're looking at live pictures of the Leon County Courthouse hearing, and the Factor will be back in a moment.
Each time you put the ballots through the machine, you get different numbers.
Fox News Live, I'm Patty Ann Brown. Just when it seemed Al Gore's run for the White House was dead in the water, an incredible turn of events gives him new life, courtesy of the Florida State Supreme Court. Court spokesman Craig Waters made the shocking announcement that the 7 judges have called for an immediate manual recount of so-called undervotes in all 67 Florida counties.
This decision is not just a victory for Al Gore and his millions of supporters. It is a victory for fairness and accountability and our democracy itself.
Today's ruling also reduced George W. Bush's lead to 154 votes. The Texas governor had been leading Al Gore by 537 votes. But with today's decision, it's a whole new ballgame. Bush's lawyers say they are appealing today's ruling to the U.S. Supreme Court. The Bush team wants the recounts to stop immediately.
It is very sad. It is sad for Florida. It is sad for the nation. And it is sad for our democracy.
Meanwhile, the Florida state legislature convened a historic special session today. The Republican-led legislature will reconvene Monday for hearings on resolutions that would choose 25 electors who have pledged to vote for Bush. That's the latest. Our next update is at the top of the hour. The O'Reilly Factor continues next.
There's nothing new.
Securing a seat in the World Trade Organization. It wrapped up 4 days of talks with WTO officials Friday in Geneva, Switzerland. Officials say they've virtually reached agreements on a number of copyrights, patent and licensing issues. They plan to meet again in January.
dramatic day in Florida where the state Supreme Court has ordered the resumption of manual recounts in almost the entire state. I want to go to Charles Ziwi, though, as we monitor this courtroom hearing in Leon County. Charles Ziwi standing by in Atlanta, just outside the 11th Circuit Court of Appeals, the U.S. Court of Appeals. Charles, I take it there's been some legal activity going on right around the corner from where you are.
That's right, Wolf. Here at the 11th U.S. Circuit Court of Appeals, James Bopp Jr., an attorney for 3 Republicans from Brevard County in Central Florida, has filed an emergency motion for an injunction to stop any sort of recount from taking place in Florida tonight. The appeals court has ordered the respondents in the case, the canvassing boards of Volusia, Palm Beach, Miami-Dade, and Brevard counties, to respond by fax by 7 a.m. Eastern Time tomorrow morning. At that point, all 12 judges, were told by the clerk's office of the 11th Circuit Court of Appeal, will decide in a conference call probably what they will do, whether they will grant a temporary injunction or whether they will decide not to do anything in this case. Bopp, on behalf of the 3 Republicans, a suit in which Governor George W. Bush intervened as an intervener, claims that, again, repeating claims of a suit that the court set aside or turned aside earlier in the week, claims that the recount is a dilution of voters' interest and is unconstitutional and unfair. Now, what happens from here on out? The court's clerk's office is working late. They tell us that they expect the Bush attorneys sometime within the next hour or so, or sometime tonight, to file a request for a rehearing in the case that the court turned aside earlier in the week. The Bush attorneys say they were not part of Bopp's motion tonight, emergency motion for an injunction here. They say they may, however, ask on their own for an emergency injunction. It gets a little confusing, but the bottom line is that Republicans have gone to the 11th Circuit Court of Appeals and asked the federal court to step in and stop these recounts until the U.S. Supreme Court decides whether it will hear the entire case. Wolf?
Charles Ziwi reporting from Atlanta outside the U.S. 11th Circuit Court of Appeals. Thank you very much. And as we continue to monitor this hearing before Judge Terry Lewis in Leon County, the circuit court there, I want to go to our CNN legal analyst, Greta Van Susteren, who's monitoring it along with us. Greta, as you take a look at these preliminary activities before Judge Lewis and how to resume, when to resume this manual recount, knowing that there's a Tuesday deadline for the state to put together its slate of electors, it doesn't look like there's a whole lot of time to do the job.
No, it doesn't. And the Gore people would much prefer a judge who sort of cracks the whip in the courtroom. If this judge doesn't crack the whip fast, it's not going to help the Gore campaign very much. And of course, the Bush people would like to drag it out. I want to point out one other thing. The Florida Supreme Court, in issuing its order today, said the circuit court shall commence the tabulation of the Miami-Dade ballots immediately. So the judge is under some pressure. He, in his essence, has been ordered to begin it immediately. So this hearing may drag on to the evening hours, but they're going to have to get this started because otherwise they're not obeying the Florida Supreme Court.
But Greta, as we watch Phil Beck, an attorney for Governor Bush, make his case that it's simply impossible to glean the intention of voters even after the Florida Supreme Court came down with its ruling today. And in that ruling, the majority, the 4 justices, said that they have to look at those undervotes, the votes that did not register for either Gore or Bush or any other presidential candidate, by looking at the Florida statute, which says that there must be, quote, a clear indication of the intent of the voter. But as Phil Beck is pointing out, it's very hard to determine with those dimpled and pregnant chads.
You know, I've always been confused by that argument, Wolf, and there's been a lot of debate about whether the standards are different, 1 dimple, 2 dimple, 3 dimple, and should it be precise. But I got to tell you, every day in the week in courthouses across the country, juries are determining the intent of people. It's not so unusual to have someone have the duty to determine the intent. We have that intent to kill, intent to do bodily injury. I mean, people oftentimes have to determine intent. This is not such a, amorphous concept. And what it is a law just gives some people the authority to make the determination based on their best judgment. So I think it's shrewd of the Republicans to do this. I would do this if I were their lawyers, but I'm not convinced that this isn't taking us down some path that the law doesn't require. It just says to determine the intent of the voter, no more.
Some are already criticizing the Florida Supreme Court justices by not getting into more specifics, by explaining in greater detail how they believe the court representatives should determine the intent of the Florida voter.
And that's curious as well, because remember, there's been a lot of criticism about this being an activist court. They're merely to restate the law. That's the law. And to do more would be creating law.
All right, Greta Van Susteren, our CNN legal analyst, thanks for joining us. I want to go back to the hearing now. Phil Beck, an attorney for Governor Bush, continues to make his case.
Undervotes. Those are ballots where nobody punched through the Chad for any presidential candidate. The Supreme Court elsewhere talks about counting all the non-votes. The non-votes is a broader category that also includes the ballots where people punched through for two candidates. There's 175,660 of those non-votes. So we have to sort that through. We think also that it is...
What did the Supreme Court say that I should do about non-votes?
Well, I haven't been able to figure that out, frankly, Your Honor. I just know that they referred to non-votes on page 39, and non-votes, to those who sat through the trial, is a broader category, and those may have to be examined as well to see if you can discern voter intent from the non-votes. There are also those who have said in this litigation that if you're going to start counting dimples as votes, then perhaps you need to look at all the ballots, because if somebody punched through successfully for George Bush, but then dimpled one for Al Gore, then if that dimple counts as a vote on the other ballots, it ought to count as a vote on all the ballots, and that would create an overvote situation. So there's that problem as well. But focusing just now on the undervotes, we think that you need to look at all of the undervotes in Miami-Dade County, including the 20% that were already looked at by the canvassing board. And the reason for that, Your Honor, is that it now becomes a judicial function, or whoever's going to look at it needs to look at all of them, to make sure that they are all treated under the same standard, using the same factors. We have a real serious problem in Miami-Dade County, where we had a canvassing board that applied very, very loose approach of divining voter intent, and they only went through 20% of the precincts. And the 20% of the precincts happened to be overwhelmingly Democratic. That's just the sequence that they did them in. Now, and they came up with a number of votes that they divined, and Al Gore picked up a whole bunch of votes. And now, unless Your Honor looks at that again, we're going to start looking at the other 80%, and someone's going to be using a different approach than was used for the 20% that's heavily Democratic. The remaining 80%, according to the regular votes that came in, was actually 52% Bush, 48% Gore. So if someone is going to use a real meaningful standard for the Republican parts of that county, then those voters, including a lot of Hispanic voters who tended to vote Republican in this last election, are going to have their votes evaluated under a standard that's different than was used for the Democrats. That creates big problems under the Voting Rights Act for a protected group like Hispanic Americans, the Equal Protection Clause for everybody, as well as 3 U.S. Code Section 5. So we believe that the court is required to include that 20% of the Miami votes so that all the votes are counted in the same way. We also believe that Broward, which underwent a manual recount, those votes also need to be examined by whoever the court determines should do the examining using the factors that the court identifies as appropriate. What we had in Broward was testimony in this record that they used different standards at different times during the manual count, and that the standards were much, much looser than, say, the ones that were attempted to be applied in Palm Beach. So Broward is a very heavily Democratic county, voted heavily for Al Gore. It picked up hundreds of votes in this process in front of the canvassing board, using a standard.
Bush attorney Phil Beck making the case for some precision in trying to determine the so-called undervotes, those votes that did not register for any of the presidential candidate. We're going to continue to monitor this hearing in Leon County before the Circuit Court Judge Terry Lewis, but right now we're going to take another quick break.
Grandpa, can I tell you my side?
Oh, yes, go ahead.
When I was playing, Greg just came over and pushed me. I wasn't doing anything.
Okay, Greg, now what about...
What, you got the tickets? You bet I'm there.
I'll pick you up. Oh, wait a second. You know, I can't make it. No, I can't. Yeah, it's pretty important. I gotta go. Okay, I'll talk to you later. There's Daddy's little girl.
You Decide 2000, exclusively on the Fox News Channel. Powerful coverage from America's election headquarters. Review, Shepard Smith, Bill O'Reilly, Hannity and Colmes, Paula Zahn. Fair and balanced reporting from America's election team, giving you the power to decide. You Decide 2000, from the most powerful name in news, Fox News Channel. We report, you decide. Fox News Channel, primetime power. Neil Cavuto, Brit Hume, Shepard Smith, powerful coverage. Wall Street, Washington, the world. Bill O'Reilly, Hannity and Colmes, Paula Zahn, powerful insights, confronting the politics, the newsmakers, and the issues. Primetime power, fair and balanced. Fox News Channel, the most powerful name in news. We report, you decide.
Channel V.
Channel V. Channel V.
Channel V.
Check it out now.
Channel V. 24時間 100% music. US, UK のトップヒット on air. Concert, music news, star 独占インタビュー and more. International music scene をそのまま catch.
What does the V stand for?
It's all about music.
Channel V.
Who has the opportunity to be heard, and we need it transcribed so that ballot by ballot, if there are disputes, those can be resolved. It may be that Your Honor takes an approach of allowing...
All right, you are listening to arguments in Leon County Courtroom on how to count these undercounted votes by hand, and they're trying to convince the judge that they know best. And when we have any ruling, we'll bring it right to you. In the second Impact segment tonight, you can't get more impact than the Florida Supreme Court laid on the entire country today. With us now is attorney Michelle Ankers, who clerked for the Florida Supreme Court for 2 years in the early 90s. So you were telling me that this surprised you, this ruling.
Slightly surprised me. Didn't shock me, but it did surprise me that the Supreme Court was willing to go in there and give the Gore team CPR the last minute right at their deathbed.
Why did it surprise you?
It surprised me because I did not think that the Supreme Court really had a remedy to offer them, like the manual recount. And yet they came up with one and said, this is what you're going to do, Leon
They did
County.
come up with one, but of course it's very controversial because the Chief Justice said they came up with it, but there's no law basis on it. What's your opinion?
I agree that I haven't seen any authority, either in the opinion or in Florida law or in the U.S. Constitution.
You haven't, but nobody's found it yet. Now, the U.S. Supreme Court slapped them once. Now it looks like, to me, in my opinion, they'll overturn this verdict, and then it will embarrass the 4 justices in Florida who ruled Al Gore's way, will it not?
I don't think the Florida Supreme Court can be embarrassed by this opinion. I think it's a well-reasoned opinion. It's at least packed with law.
It's not based on law.
There is law in here, and I think the Florida law, the election code, is what they cite. Now, the U.S. Constitution is what the U.S. Supreme Court will be looking at, but I think that the Supreme Court gave 40 pages of material that cannot be slapped.
Why would the Chief Justice say that it's not based on any legal premise?
I think the Chief Justice was concerned, again, that the U.S. Constitution would eventually override the Florida election code.
Is, in your opinion, the Florida Supreme Court politicized? Are they political activists?
I do not think they're political activists. You might say they're legal activists, but politically, I think that they have no reason. They are very cloistered. They are not as public. They can't come out and defend themselves, but they do have a lot of resources.
6 Democrats and 1 independent, I think it is, or something like that?
But they're also lawyers. They're professionals. They're honorable people, and they're
So you don't think any of that ideology entered into any of this decision?
I don't. I think they had too much law in front of them to have to get to ideology.
Now, Counselor, this is what I don't understand and what everybody watching. If you have 7 lawyers, probably the brightest lawyers in the state, or among them, right?
Right.
How can you have 4 say one thing and 3 say something else?
The same
How can
way
you have that?
you can look at a box of 62 Crayolas and one person says, I think that's cornflower blue, and another person says, no, I think that's royal blue. It's variations on something that can look to be just blue.
All right. Now, that's a good explanation, but the future of the whole country is hinging upon these 4 people who voted for Al Gore, and they are under a cloud of suspicion because of the subversive, I'm going to use the word subversive, opinion of the Chief Justice of the Supreme Court. He wrote an opinion that embarrassed those 4 people. Would you agree with that?
No, and let me say first, I don't think we know that these 4 justices voted for Gore.
Well, they had to. They voted his way to
I thought you meant on their own individual ballots. We don't know how they voted.
No, I don't know about that, but they voted his way in this controversy.
Right, but I think that as Chief Justice Wells said, he respects these people. He respects their decision-making process.
He cut their knees out. He cut their knees out.
He simply says, I disagree, and he says, I don't think that Judge Sauls was wrong. He looked at 2 days' worth of evidence.
I have never, and neither has any of our legal people here at Fox, ever seen a dissenting opinion as scathing as this. Have you?
I cannot say, but I can say that he wanted to make a point. And I think that the Supreme Court, U.S. Supreme Court, if they do decide to overturn the Florida Supreme Court, will just go to Justice Wells' opinion, take it, and adopt it as their own.
It's almost inconceivable now, after the first ruling of the Supreme Court, which said, show us the law. Now we still don't know what the law is that they're not going to overrule, right?
I think that the Florida Supreme Court made an attempt in its first few pages of the opinion to address what the Supreme Court wanted them to address.
Well, it obviously didn't impress the Chief Justice.
Right, and that's why we've got 7 people. Some people are going to disagree. The Chief Justice clearly thought that there was not enough
And you
there.
really believe no politics involved in this, huh?
No politics.
Straight down.
I completely am convinced to that point.
We respect your opinion. Thank you very much. And next, we'll wrap things up with the most ridiculous item of the day and some of your mail.
Well, Al Gore, all the way down the ballot, they will have failed to punch the Chad through, or in almost all of the races. So we believe that if you're going to be looking at dimples, which you should not do, that you should only count the dimples.
Fox News Channel Daytime. The whole story in context. Facts presented fairly. The issues balanced, so you have the power to think for yourself. Fair and balanced. The most powerful name in news. Fox News Channel. We report, you decide. You Decide 2000. Exclusively on the Fox News Channel. Powerful coverage. From America's election headquarters. John Scott. Bridget Quinn. David Asman. Linda Vester, Shepard Smith, Neil Cavuto. Fair and balanced reporting from America's election team, giving you the power to decide. You Decide 2000, from the most powerful name in news, Fox News Channel. We report, you decide.
Channel B.
Channel B. Channel B.
Channel B.
Check it out now. Channel B. 24時間 100% music. US, UK のトップヒット on air. Concert, music news, star 独占インタビュー and more. International music scene をそのまま catch.
What does the V stand for?
It's all about music. Channel B.
Fox presents 科学分析用語危険人物関与目撃証言消去
だが真実はそこにある。X ファイル on Fox。さあスカリー行くぞ。2人の FBI 捜査官が挑む世界の裏側の巨大な謎。
I think that we've succeeded in doing that first and foremost. It's become a lot of other things, but I think it is a scary show.
X ファイル全米のメジャーなテレビショーを連続受賞。
The X-Files has really caught on because I think people around the world have to be scared.
X ファイルその魅力は今も世界中にファンを生み出し続ける。
X ファイルよくできてますよね。もっと続けて。来週はどんな話なんだろう。見ればハマる。
テレビ史上真実が知りたい。かつてない
答えを見つけて
進化し続ける最高傑作。真実はそこにある。目撃者はあなた。X ファイル毎週月曜夜10時 Only on Fox。
Time now for the most ridiculous item of the day. Your humble correspondent's getting a lot of ink these days with both the Factor TV program and the Factor book standing at #1. People magazine has a story coming up on me in next week's issue, and the Wall Street Journal ran one today. In the People story, our pal, Washington Post writer Tom Shales, calls me an empty-headed blowhard and my commentary shallow and knee-jerk. Okay, fine. Mr. Shales also recently attacked the entire Fox News channel in the trade publication Electronic Media. Seems he's on a jihad against us. Again, fine. But when we invited Mr. Shales on the program to discuss his point of view, well, he's just too busy. Always. Hey, come on, Tom. I'm just an empty-headed guy. You can destroy me with one pen tied behind your back. It's ridiculous you're hiding from the Factor. And finally tonight, the Mail. Richard Smith, Caracas, Venezuela. O'Reilly, you're starting to lose your impartiality. You want the machine vote to stand in Florida. You can't have Republicans making hand marks on absentee ballots. Eldon Neufeld, Lancaster, California. O'Reilly, please don't say you're fair and balanced. You are liberal and have far more liberals on the air than conservatives. Not true, Mr. Neufeld. We balance it out. George Ligori, Staten Island, New York. I'm disappointed in you, O'Reilly. How can you complain about your heating bill? You're making big money while I work the night shift in a post office mail factory. When I'm home, I wear a sweater to keep the heating bills down. So do millions of Americans, Mr. Ligori, and I'm criticizing the government on behalf of all of them. This is not about my heating bill. This is about poor leadership and the working man getting hosed again. Julie Melody, Brighton, Michigan. O'Reilly, you hit the nail about the lack of leadership in this country. This is our real crisis. Catherine Myers, Akron, Ohio. Mr. O'Reilly, I was appalled by your comment regarding Bill Clinton's adultery with Monica Lewinsky. You said he's a man, and this has been going on since the dawn of civilization. How dare you insinuate that kind of conduct is acceptable? How dare I, Miss Myers? Here's how I dare. I didn't insinuate any such thing. I said you can't impeach a president for immoral behavior, only for illegal behavior, which Mr. Clinton clearly engaged in by lying under oath. It's very important to put all of my comments in their proper context. Rosemary Geese, Gladstone, Oregon. O'Reilly, men will be men. I may never watch The Factor again. Bob Thomas, La Crosse, Wisconsin. O'Reilly, how dare you allow the Fox News to preempt The Factor for live coverage of those local trials in Florida? You know, I love these how dare you letters. Mr. Thomas, I just work here. There are others who can override my wants. The Factor's just like the real world. Ed Ginsburg, Bayside, New York. O'Reilly, I was looking forward to The Factor when Fox cut away to the Night of the Living Dead, Part 20. Enough already. I'm with you. Sharon Norris, Holden, Missouri. Bill, I must protest. You're responsible for getting me to think. I was very happy being complacent, and now I have to analyze everything. But you'll be a better citizen for it, Sharon. And Don Campbell, El Cerrito, California. O'Reilly, I went to a large San Francisco bookstore to buy the Factor book, and they couldn't find one for me. Are you being boycotted here? Possible, Mr. Campbell. Some folks in San Francisco don't like me very much, even though I like them a lot. Anyway, I'm sending you a signed book, and you can spread the word around. And if you'd like to sound off, the email address is O'Reilly@FoxNews.com, O'Reilly@FoxNews.com. U.S. Mail. The Factor, Fox News Channel, 1211 Avenue of the Americas, NYC 10036. And then there's the website.
I want the people to know that they still have 2 out of 3 branches of the government working for them, and that ain't bad.
And we're going to keep rerunning that Jack Nicholson clip until this dang thing is decided. Get online with The Factor this weekend. All kinds of exciting stuff and a column that I just finished writing about power in the USA. That is it for us today. As always, we thank you for watching. I'm Bill O'Reilly. Hope to see you next time.
Tonight on Hannity and Colmes, Al Gore's appeal to toss out absentee ballots is tossed out in 2 counties.
But the Florida Supreme Court orders manual recounts, bringing Gore's chances back to life.
Tonight, Congressman Alcee Hastings, J.D. Hayworth, they'll all join us. But first, the headlines.
News Live, I'm Patty Ann Brown. After swinging and missing in so many legal battles, Al Gore hit one out of the park thanks to the Florida State Supreme Court. The state's high court reversed a lower ruling and ordered statewide manual recounts of so-called undervotes to begin immediately in all 67 counties. The decision is a major victory for Gore, who has been relentless in the fight to get what he has called a full and fair count of the Florida vote. Today's ruling has also reduced the Bush lead to 154 votes. Bush lawyers say they're appealing to the U.S. Supreme Court to immediately stop the recounts. Well, the ruling could not have come at a more critical time for the Democrats. Earlier today, 2 judges in Seminole and Martin counties rejected a bid by Gore supporters to throw out 25,000 absentee ballots. These were serious setbacks for the Gore team, occurring less than 2 hours before the Florida Supreme Court's announcement. Meanwhile, the Florida state legislature convened a historic special session today to choose a new slate of presidential electors. The Republican-led legislature will reconvene Monday for hearings on resolutions that would choose 25 electors who have pledged to vote for Bush. Our next update is at the bottom of the hour. Now stay tuned for Hannity and Colmes. Sean and Alan will, of course, have more on today's rulings in Florida with party leaders Jim Nicholson and Ed Wendell. That's straight ahead.
That's fine. What you are watching is Leon County Court recount hearing that is taking place in the courtroom of Judge Terry Lewis. This will be going on throughout the evening as developments happen. Of course, we will be checking in and out, and we'll be keeping you updated all throughout the evening. As late as that goes, we will have it for you live here on the Fox News channel. As we now go, there's Judge Lewis. As the camera pans to him, again, he's asking in part both sides how the vote should be counted in reaction to the Florida Supreme Court's ruling that came down earlier this afternoon, and what should the criteria be, which of course is the other big question, which could be determined in the course of tonight's events. And welcome to this special edition of Hannity and Colmes. I'm Sean Hannity. And coming up later in the show, party leaders Jim Nicholson and Ed Wendell, they'll debate the election mess in Florida today. Plus, Indiana Congressman Dan Burton will give us his analysis of the situation. But first, an unprecedented day for the state of Florida and the nation. The Florida Supreme Court ruled in favor of the appeal filed by Vice President Al Gore, breathing new life into his fight for the presidency.
By a vote of 4-3, the majority of the court has reversed the decision of the trial court in part. It has further ordered that the Circuit Court of the Second Judicial Circuit here in Tallahassee shall immediately begin a manual recount of the approximately 9,000 Miami-Dade ballots that registered undervotes. In addition, the Circuit Court shall enter orders ensuring the inclusion of the additional 215 legal votes for Vice President Gore in Palm Beach County and the 168 additional legal votes from Miami-Dade County. In addition, the Circuit Court shall order a manual recount of all undervotes in any Florida county where such a recount has not yet occurred.
The additional 383 votes awarded to Al Gore from Miami-Dade and Palm Beach counties has narrowed Texas Governor George W. Bush's lead in Florida to just 154 votes. Gore advisor William Daley had this to say about the ruling.
This decision is not just a victory for Al Gore and his millions of supporters. It is a victory for fairness and accountability and our democracy itself. Let the count begin, not just of the votes yet to be counted in Miami-Dade, but as the court wisely ruled, in every Florida county where undervotes have yet to be counted. Then Florida and America will know with certainty who has really won the presidency.
Bush legal advisor James Baker also reacted to the decision, quoting Chief Justice Wells.
He further said the prolonging of judicial process in this counting contest propels this country and this state into an unprecedented and unnecessary constitutional crisis. I have to conclude, he said, that there is a real and present likelihood that this constitutional crisis will do substantial damage to our country, to our state, and to this court as an institution.
The Florida High Court, the decision came on the heels of 2 earlier rulings that went in Bush's favor. 2 Leon County Circuit Court judges refused to throw out 25,000 absentee ballots that had been challenged by Democrats in Seminole and Martin counties. And in the latest development, George W. Bush is now seeking an emergency stay from the U.S. Supreme Court. Justice Anthony Kennedy, and they're asking him to block the manual recounts in Florida. So does the future of the presidency lie in the hands of the U.S. Supreme Court or on dimpled Chads? Joining us, Florida Democratic Congressman, our good friend Alcee Hastings. He joins us from Fort Lauderdale tonight. And in Phoenix, we're joined by another good friend, Arizona Republican Congressman, our good friend J.D. Hayworth. I was stunned by the rebuke in the dissent led by the Chief Justice of Florida, Congressman Hastings. And one thing that has not been spoken of yet is the Chief Justice went a little further, and he seemed to me, when he talked about how it was fraught with equal protection concerns in the ruling, when he talked about the separation of powers, when he talked about all the issues, he was teeing it up for the U.S. Supreme Court, giving them all the federal issues and the Federal Appeals Court in Atlanta to do what he thinks they ought to do.
The fact is, Sean, it was a 4-3 majority opinion. But, Sean, let me do something, and I'm sure J.D. joins me in this. And please permit me a moment of personal privilege to pay homage to a great American colleague of mine and J.D.'s who died, a man named Julian Dixon from California, one of the true persons that worked in a bipartisan fashion in the Congress. I think Judge Wells' dissent is going to be looked at very actively by the United States Supreme Court. And I agree with you that it's a decision that is likely to cause them to involve themselves. But the constitutional crisis that he talks about in that opinion may very well be generated by the Florida legislature's actions in the event they determine to certify additional electors if, and I underscore if, Al Gore wins in an undercount.
Let me go to my good friend Congressman J.D. Hayworth. And by the way, Congressman Hayworth, I believe this will go down in history as one of the most reckless, irresponsible decisions we've ever seen by any state Supreme Court in the history of our republic.
Sean, be careful.
Wait a minute, I'm very careful. And I think clearly, based on the dissent, I think the Chief Justice would agree with me when he talked about the constitutional crisis. This decision is inconsistent, J.D., with Florida law, with the U.S. codes, with the U.S. Constitution. It will not stand. I think the Chief Justice is right in that respect.
Let me start with a point of agreement with Alcee far away from the decisions in Florida today. The Congress, Republicans, Democrats, and Independents rise as one to pay tribute to our fallen friend, Julian Dixon, who was a remarkable gentleman.
He was a great man.
Now, let's make no mistake, and I profoundly differ with Alcee with what he just had to say about the Florida legislature. Ladies and gentlemen, we do not confront a constitutional crisis. We instead confront this evening the constitutional process. Article 2, Section 1 of the Constitution makes it crystal clear. The legislature shall determine the electors. I call on the Florida legislature, mindful of its constitutional responsibility, to restore order where instead the Florida State Supreme Court has invited anarchy. Because understand this, under their decision today, not only do they invent votes out of whole cloth, but they also fail to establish standards, so they invite anarchy. I believe that liberty and order must coexist. It is the job of the Florida legislature to follow the Constitution.
Let me bring this up for a second. Hold on. Go ahead, Congressman.
Let me ask you and Sean something. If the West Virginia legislature, which is dominated by Democrats in the majority, was to on Monday begin a process to give Governor Bush's electors that are at the Senate archives right now to Al Gore, even though Governor Bush won the election, would you say that's okay?
Alcee, I appreciate, my friend, what you're trying to do by establishing a false hypothetical. Let's deal with the situation in Florida. Understand clearly, Governor Bush on Election Day won. It was close, but he won. He won in a recount. The Florida State Supreme Court, in an unprecedented act of judicial activism until now, set up other rules by which Governor Bush prevailed, even while some on the Gore side sought to disenfranchise our military men and women from voting and exercising their franchise.
We have to take a break.
Okay.
We have to take a break.
The bottom line is follow the Constitution.
We have to take a break. I agree with that, Congressman J.D. Hayworth. We'll come back in just a moment. Now, before we break, how soon do you think we'll know who won the presidency? Next week, Christmas, Inauguration Day? We should know by then. Log on to foxnews.com. Look for the viewer vote box. It's at the bottom of the screen. You click on it. You'll see a vote button. Vote A, B, or C, and we'll let you know at the end of the show how everyone voted. And the chairman of the Democratic and Republican committees, they're here to do battle tonight. And later, House Reform Chairman Dan Burton will join us. That's all straight ahead. A busy night as we close, looking back again at the Leon Circuit Court. where Judge Terry Lewis is presiding. Both sides being asked how the count should go forward, and we will come back and continue this straight ahead.
In the form of the instructions that were at the polling place, up on the wall, and in the back of the booth. We saw it on television. I don't know if you were paying attention to that part of the testimony. And it's written on the ballots themselves. So the voters are instructed in language adopted by all the local officials across the state who use these machines.
Fox News Channel Daytime. You want to make the right choices. We give you the power to decide for yourself. Fair and balanced. The most powerful name in news. Fox News Channel. We report, you decide.
If making money were simple, we'd all be millionaires. Let's face it, money decisions are tough decisions. You need to know what's going on here and how it will affect your finances, your future, and your family. We cover the markets in plain English so that when the bell rings, you can understand what happened and decide what's right for you. We bring Wall Street to Main Street so maybe you can live on Easy Street.
Fox News Channel. Powerful all day. John Scott, Bridget Quinn, David Asman. Bringing the world to you. Making the issues clearer. Powerful hour to hour. Linda Vester, Shepard Smith, Neil Cavuto. Breaking stories. Aggressive coverage. Powerful all day. Fair and balanced. Fox News Channel. The most powerful name in news. We report, you decide.
No. You know, we agree on just one thing. A good argument's the best way to get to the core of an issue.
Wait a minute, I don't agree with that. A discussion's the best way. You have to explain, reason, justify your position.
Everybody on TV is discussing things, Alan. That's boring. If you want to find out what people really think, you need a good argument.
No, a discussion's
An
better.
argument.
A discussion.
We can agree on this. It's your turn to pick up the check today.
Well, I'll argue that one.
Alan, let's see if we can discuss this.
Come first to Fox News for breaking news, exclusive stories that impact the world, unique, timely interviews that shape our nation. First on the scene with breaking news, continuous coverage from over 70 bureaus around the globe.
We're the only ones here who still have live pictures out.
Reporters, anchors, and correspondents that are first, fair, balanced. Powerful insight, powerful perspective, powerful news. Come first to Fox News for breaking news.
Interveners in this action. We had earlier on in this litigation had asked the court to do a statewide manual recount and had asked the court to take a statewide perspective. If the court looks at page 38 of the Florida Supreme Court's decision, you'll see that the
Welcome back to Hannity and Colmes. I'm Alan Colmes. We're looking at Leon County Circuit Court. They're having a hearing to determine how the vote should be counted, each side, and discussing how they interpret the Supreme Court decision that came down today. This is an attorney for the actual voters. We'll be going in and out of that and showing you what's happening throughout the night in Leon County Court. Keep you abreast of the latest. Later on in this show, the chairman of the DNC and the chairman of the RNC will debate today's rulings down in Florida. And later, House Reform Chairman Dan Burton will tell us how he thinks this election battle will conclude. Back to our debate. Let me go to Congressman Hastings. You know, it seems to me that the U.S. Supreme Court, Congressman Hastings, made it clear to the Florida Supreme Court that they wanted underpinnings. They wanted to be defined by case law, not by not by the Florida Constitution, but as much by the Florida Code and by the legislature. And they did exactly that in their ruling today. Let me just put up a little bit of what was said so our viewers can see it. It said the contestant here satisfied the threshold requirement by demonstrating that upon consideration of the thousands of undervotes or no registered vote ballots presented, the number of legal votes therein were sufficient to at least place in doubt the result of the election. And that was the key phrase, place in doubt, that they said that the circuit court judge, Judge Sanders Sauls, did not take into consideration.
That is correct. Judge Sanders Sauls used a 1974 and a 1981 Florida opinion. But, Alan, you are so correct. The United States Supreme Court sent the matter to the Florida courts on remand and for them to follow the mandate with reference to whether or not it was under Florida law or the United States Constitution. You will see the references several times in the opinion indicating that the Florida Constitution derived its powers from the United States Constitution, and the Supreme Court, the majority, was following it right down the line.
Right. Let me
what Judge Sauls did was use a standard of probability of change in the outcome as opposed to
the language is key. And Congressman Hayworth, they also even quoted the Florida legislature that they may be doing battle with, and they quoted Boardman versus Esteva, a 1975 law that says the legislature is mandated, no vote shall be ignored if there's a clear indication of the intent of the voter. That's what the Florida legislature says. This court did its homework, cited case law, and cited what the legislature itself has done.
This court performed an act of judicial banditry today. Judicial activism run amok.
JD.
Let me make it very clear, and I say these words, and I don't say them with a false sense of bravado, but out of a deep sense of sorrow. What you see is judicial activism run amok, where you try by a clever citation to invalidate the Constitution and the plenary powers of the legislature under Article 2, Section 1 of the Constitution. Further, you disavow 3 U.S. Code Section 5, trying to claim supremacy of Florida law, but make no mistake, this narrow majority, 4-3, 4 very politically active judges today sought through the arrogance of the judiciary to steal votes. This is banditry clad in black.
JD, let me back up your point. Let me back up JD's point, not with my words, but with the words of 3 lifelong Democrats in the dissent by Judge Wells, the Chief Justice. Alcee, he's a Democrat, lifelong, and these are his words. I could not more strongly disagree with their decision to reverse the trial court and prolong this judicial process. I also believe that the majority's decision cannot withstand the scrutiny, which will certainly immediately follow under the United States Constitution, backing up what JD said. My succinct conclusion is that the majority's decision to return this case to the circuit court for a count of the undervotes for either Miami-Dade or all the counties has no foundation in the law of Florida as it existed on November 7, 2000, or at any time until the issuance of this opinion, which brings us back to where Bush now goes before the 11th Circuit and Justice Kennedy, is that they have, again, they're changing the rules after the election. They changed the date. Now they've just eliminated the date in terms of when the recount should start.
Well, now, you all have had your say. Let me see, can I set you straight about something, Sean? Firstly, the law that we follow here in Florida is a poorly constructed law by the legislature. I didn't make it that way, and Alan Colmes
7 days
after
an election? That's not ambiguous.
Excuse me, the fact that it's a bad law doesn't suggest at all that we are not under the aegis of that law at this point in time.
They can't write their own law, Congressman, which is what they did twice now.
Answer me then, my dear friend, answer me, why is the manual recount provision in the statute in the first place?
Congressman Hastings, we thank you. Congressman Hayworth, thank you for being with us tonight.
Follow the Constitution and uphold the rule of law.
I think we will. Still to come, another recount has been ordered in Florida, but will that be the final word on this election? DNC Chair Ed Rendell will debate RNC Chair Jim Nicholson. That's straight ahead on Hannity and Colmes.
What? You got the tickets? You bet I'm there. I'll pick you up. Oh, wait a second. You know, I can't make it. No, I can't. Yeah, it's pretty important. I gotta go. Okay, I'll talk to you later. There's Daddy's little girl.
You Decide 2000, exclusively on the Fox News Channel. Powerful coverage from America's election headquarters. John Scott, Bridget Quinn, David Asman, Linda Vester, Shepard Smith, Neil Cavuto. Fair and balanced reporting from America's election team, giving you the power to decide. You Decide 2000, from the most powerful name in news, Fox News Channel. We report, you decide. Power. You want to make the right choices. We give you the power to decide for yourself. Power. 24 hours, 7 days a week. Nobody gives you more original live programming. The power of news to keep you up to date. Shows that go in-depth. Issues in context. Topics that matter to you. The power of Fox News Channel. News and information, fair and balanced. The most powerful name in news. Fox News Channel. We report, you decide.
胸騒ぎの夜、フォックスが待っている。エンターテインメントが待っている。夜9時、ロディオショーに命を懸ける男たち。人命救助 SOS。夜10時、凶悪犯罪捜査ファイル。夜11時、全米警察24時。夜12時、巨大な嵐が街を飲み込んだ。追跡、生死を分けた大暴風。夜9時、悪魔に狙われたジャイルズ。バフィー恋する十字架。夜10時、マジックの裏側公開第2弾。破られたマジシャンの掟パート2。夜11時、厄介な被告に手を焼く弁護人ザ・プラクティス。夜9時、陰謀に巻き込まれた少女を救えトゥイ同じ顔の悪魔。夜10時、腹部を食いちぎられて死んだ元サーカス団員 X ファイル。夜11時、殺人現場を映し出すホームページミレニアム。胸騒ぎの夜、フォックスが待っている。エンターテインメントが待っている。人命救助 SOS 凶悪犯罪捜査ファイル。全米警察24時。追跡、生死を分けた大暴風雨。バフィー破られたマジシャンの掟パート2ザ・プラクティス。2 X ファイルミレニアム。吹き抜けるハリウッドの風、今日本にもうフォックスしかない。
Do the count in some of the counties that have a large number. So your Honor has to consider how can they delegate to people that necessarily may not have any experience. Let me give you an example. Let's say that Hillsborough County has to manually recount all of their undervotes this weekend. Well, up to now, to my knowledge, they've not had to do any manual recounts. So they haven't trained anybody up till now to know how to do a manual recount.
What you're watching is Leon County court hearing on the Florida recount in response to today's Florida Supreme Court ruling. That is one of the attorneys for one of the voters, and the issue at hand as we step in there and watch what's going on is the issue of whether or not when this deadline will actually occur, and a lot of questions yet to be determined and yet to be answered. And welcome back to Hannity and Colmes. I'm Sean Hannity. We'll have continuing coverage on the Fox News Channel all night, and we anticipate there's going to be a lot of breaking news tonight, so please stay with us. And we're joined by the General Chairman of the Democratic National Committee, our good friend Ed Rendell, and the Chairman of the Republican National Committee, Jim Nicholson. By the way, good to see you both in New York in studio. This is great. I feel like we're back at the convention. There's some really serious issues going on here, Chairman. Changed the deadline now for the third time. The statutory deadline was in place. The Florida Supreme Court wrote a new deadline. Now they put in a third deadline, which basically eliminates all deadlines in this. They changed the election laws that were in place on the date of the election, and they bypassed the constitutional authority of the state legislature. And for these reasons, I am very confident that there will be a stay by tomorrow morning, stopping the madness of this recount of these judicial activist judges in the Supreme Court of Florida.
Well, Sean, you were very confident that they'd never do this in the first place.
I was very confident Bush would win by a bigger margin, to be honest with you.
So your track record is not all that good.
But you know something, because when they vacated the original ruling, they were very clear and very specific and said, you can't do this. And what did they do? They went back and did the same thing. Not only did they write legislation the first time, which is not their responsibility, constitutionally speaking, they now did it again. I see the Supreme Court coming in a very firm way. Go ahead.
Well, first of all, what they did today, I think they should have done 2 weeks ago. They now have given us the clearest indication that votes should be validated and that we're going to be fair and do hand counts in every single county. That's the way to settle this. Why? I don't understand, and I'd ask Jim, why are the Republicans afraid of doing hand counts in every county? And I said a while ago, what standards? The standard is the one given to us by the Florida legislature.
Chairman Nicholson, let me go to the heart of the argument on your side, which is you object to the fact that you say we're changing the rules or the Democratic Supreme Court's changing the rules. Let's look at what the state legislature is doing in Florida. And from today's Palm Beach Post, here's what it says. House Republican leaders are planning to change the rules today so that they can name the state's 25 electors with less debate and avoid the need for Governor Jeb Bush to sign the resolution that could hand his brother the presidency. They're changing the rules in the state of Florida in order to get their own slate of electors in after they've already been certified by the Secretary of State. And indeed, if it turns out that the popular vote went to Al Gore, that's a different slate of electors that were chosen on the date certain, indicated by the Code of Florida. And so you talk about a constitutional crisis, they might be forcing one.
They have a responsibility to see that, to write laws and to see that the laws are upheld.
They're changing the rules.
They're not changing the rules. The rules have been changed by the Florida Supreme Court. Not once, not twice, but 3 times, as Sean just said.
They're changing the rules of debate.
We had an election on November 7th. The votes were counted then. It was close by law. They counted them again. Then in some counties, selectively, with Democrat counters, they counted them a 3rd time, sometimes a 4th time, without standards. But in every case, President Bush, President-elect, I hope, Bush won.
Well, you know, I think a little bit of a Freudian slip. Let's make sure, Ed, you get on President Gore somewhere along the lines here. Well, we're showing you in and out tonight. We're showing you Leon County District Court. They're coming up with a standard. Both sides are battling it out. We're going to come up with a standard and then go to these undervotes in these various counties. Isn't that the fair thing to do?
Well, I think that's what Justice Wells was saying in his very strong dissent, the Chief Justice, by the way, saying that this was going to propel us into a major constitutional crisis, an unprecedented, unnecessary constitutional crisis.
I hate to interrupt you.
Without standards.
We got to take a break. When we come back, we'll deal with the issue of who's counting, what are the standards, changing standards, varying standards, back to Dimples perhaps, but we'll come back, and the debate never stops on Hannity and Colmes. We'll also be joined by Congressman Dan Burton. That's all straight ahead. A lot more to come. Please stay with us on Hannity and Colmes.
Fox News Channel Daytime. The whole story in context. Facts presented fairly. The issues balanced, so you have the power to think for yourself. Fair and balanced. The most powerful name in news. Fox News Channel. We report, you decide.
Opinions. I have them, you have them. In fact, on any given subject, there are as many opinions as seats in this theater. And that's good, people speaking out, sharing ideas. But opinions are not the same as facts, and you should know the difference. And that's why at the Fox News Channel, we label all opinions right on your TV screen. And that should help you form your own opinion, so you can decide what's right and what's wrong.
邪悪な魔力と戦うために選ばれた一人の戦士フォックスが放つニュータイプのエンターテイメントキュートでクールなスーパーヒロイン
お待たせ
バフィー恋する十字架彼女は高校生彼女は恋する少女彼女はヴァンパイアスレイヤー
I'm Sarah Michelle Gellar
だヴァンパイアと戦うことが彼女の使命
運命だったのよ
信じますね
信じますよ
運命の人がいたらいいなっていてほしいです
頭がぶっ飛ぶのが愛
君とは戦わない切ない恋の行方はフォックスが放つニュータイプのエンターテイメントキュートでクールなスーパーヒロインバフィー恋する十字架毎週木曜夜10時宿命の対決か運命の恋か Only on Fox
Fox News Live, I'm Patty Ann Brown, and the latest round goes to Al Gore. A shocker in Florida keeps the vice president in the race for the Oval Office. The state Supreme Court has ordered an immediate hand recount of all so-called undervotes in all 67 Florida counties.
Because time is of the essence, the recount shall commence immediately. In tabulating what constitutes a legal vote, the standard to be used is the one provided by the legislature. A vote shall be counted where there is a clear indication of the intent of the voter.
The court also ruled that 383 votes must be added to Gore's total, throwing into doubt George W. Bush's certified victory. Bush's lawyers say they're appealing to the U.S. Supreme Court to stop the recounts immediately. The ruling also softens an earlier blow taken by the Democrats today. 2 lawsuits filed by Gore supporters were shot down in Seminole and Martin counties. The Democratic lawyers had sought to have absentee ballots in those counties thrown out, but the 2 judges found that the sanctity of the ballots had not been compromised, even though voter ID numbers were added to thousands of Republican absentee ballot applications. Meanwhile, Florida's GOP-dominated legislature has recessed until Monday. They held a special session today to begin choosing Florida's 25 electors. Our next update is at the top of the hour. Now more Hannity and Colmes.
Mention this one thing, and that is, and I'll do it in part because the intervener suggested it as well, and that is the 3,300 votes from Palm Beach. Those were ballots that the Supreme Court said we had not shown that the Palm Beach board didn't do those right. No one ever looked at those as a judicial matter. And if we're going to go beyond the strictures of what the Supreme Court has laid down, we think the very first ballots, and this may have been what the intervener had in mind when he was talking about the need to look at the Palm Beach ballots, the first ballots that ought to be looked at are those 3,300 ballots that are already here. But we don't want to do anything until after everything that the Supreme Court has ordered to be done has been done. Once that's done, maybe there are some things that they're suggesting that we could do. Maybe there's some things that we're suggesting that could be done. But I think that the Supreme Court has made clear that there are certain limited things that have to be done immediately, and those are the things that we would ask the court to focus on at least first. In terms of
what we're watching is Leon County Circuit Court. David Boies, who had a big victory, big if narrow victory, 4-3 in the Florida Supreme Court today. And what they're talking about is how to interpret the Florida Supreme Court's decision. They're arguing that before Judge Terry Lewis. A few more attorneys will be speaking tonight, and then there should be a decision. Fox News Channel will stay with us. We'll show you pieces of it as we go through the evening, and when that decision comes, we'll have it for you live on Fox News as well. So stay with us for breaking news as it happens throughout the night tonight. We now continue with the general chair of the Democratic National Committee, Ed Rendell, and the chairman of the Republican National Committee, Jim Nicholson, as we talk about incredible events that have happened today. You couldn't write a script. They'd never accept this in Hollywood, would they? If you wrote a script, they'd say it's improbable, impossible, it's not realistic.
Always the good guy wins in the end.
Yeah, and the good guy will win in the end.
That'd be Bush, by the way.
But look, this idea about, look, I've always said I would rather have a legitimate George W. Bush in the White House, a legitimate Bush victory than illegitimate Gore victory. And I would hope you feel the same way about your candidate. I don't think that those votes in Seminole and Martin County should be thrown out. I think they should be counted. But I also think that Palm Beach County should be counted. The votes that came back into play, Miami, those votes should be counted. They came back into play today. Don't you feel that we should err on the side of counting all the votes, whether they favor you or not?
They were counted. They were counted, and then they were counted again. And some people just don't vote for president. You know, in Bill Daley's home county, Cook County in Illinois, there were 140,000 votes that weren't counted because at the top line they didn't decide to vote for president. That goes on all the time. It's between 1% and 2% nationally. People have a right to do that. It was a close election. Some people just couldn't make up their mind. They chose not to vote for president.
The weakness in what Jim just said is that, Jim, there's, first of all, number one, these votes have never been counted.
They've been counted twice.
Jim, let me finish. The machine cannot pick up a vote that hasn't totally dislodged the Chad. We've had that testimony from the Votomatic people. Secondly, so they've never been counted because the machine's not capable of picking them up. The Florida legislature, the one that you and Sean want to rely on, says that we should try to ascertain the intent of the voter. They've specifically allowed Florida legislature for hand counts. The standard is you've got to look at the ballot. The only way you're going to be able to tell, you might be right, Jim. Someone may have chosen not to vote, but the only way you can tell is by looking at it. If it's perforated and the Chad is hanging, that person intended to vote. His vote should count. What are you all afraid of?
What are you all afraid of? Let me ask you a question.
What are you all afraid of?
Here's my answer.
Changes every time.
The machines are neither Republican or Democrat. We've watched madness unfold before our eyes and the American people here. We've watched in the middle accounts changing standards, altering standards, criteria for standards that have been in place 12 years being changed after the election has taken place, and Democratic-dominated canvassing boards as the final arbiters outnumbering Republicans 3-1. That system is so fundamentally flawed and unfair, no reasonable person can accept that, and that's what you're asking from us.
Sean, understand,
and that's the problem.
The legislature that you love so much, they specifically passed a law making hand counts available for recounts. In Texas, hand counts are preferred. Wait, let me finish. Let me finish.
Yeah.
The legislature has done that. The law says that we have to have hand counts. You didn't complain when we had 6 Republican counties that did partial hand counts in the second vote.
We're going down old territory. I want to turn to Chairman Nicholson here, because one thing that has gone unnoticed here, the Florida activist Supreme Court legislating from the bench, making up laws as they go along here today. This has gone unnoticed by a lot of people because they added all these votes to the Gore side today. But what they did was against the law. Number one, they added votes of a partial recount in Miami-Dade County. That is against Florida statute. They're not allowed to do that. They just wrote the law there on their own.
Those were all just Democrat precincts that they'd counted, by the way. They hadn't gotten to the Republican precincts.
And the fact that they feel that not only did they miss the first statutory deadline for recounts, they missed the second that they had set up. They had to put aside or set aside their own new deadline to accept the votes in Palm Beach County. And nobody, you talk about the rule of law, you're talking about judicial activism to an unprecedented level.
Breathtaking. I mean, that decision is breathtakingly arrogant. I mean, they did that once, and the Supreme Court wrapped their knuckles, said they didn't abide by their own statutory system. They didn't abide by the Constitution.
It will happen between now and tomorrow morning.
I know you hope it was what they said. That's not what they said.
And then they told the Secretary of State that she had to have it certified by a certain time. They recounted again. She certified. And Governor Bush won. Now they want to change the system, and they said, go count all these.
We'll talk about who wants to change the system. We thank you guys. Thanks very much.
Why don't you guys want to count the votes?
We're going to take a break. The debate continues. The debate goes on even during the commercial breaks. The debate continues. Now, remember, you can still make a choice in tonight's viewer vote. How soon do you think we'll know who won the presidency? Go to foxnews.com. Make your choice. We'll have the results at the end of the show. And later, what role will the Florida legislature play now that we're back to the recount drawing board? We'll speak with the Florida House Majority Leader and a Democratic representative who's also a Gore elector. And straight ahead, Congressman Dan Burton weighs in on today's controversial decision. Stay with us on Hannity and Colmes.
You know, some mornings this is just too much. Especially when it's cold and nasty outside. But you're my pal. You're always there for me, unlike some people. And I'm not gonna let you down. Come on, man, let's go outside. So, Cosmo, got any big plans for today? There you go.
And Grandpa, that's the whole story. That's what happened.
Okay. Katie, now you tell me what happened.
Well, but Grandpa, I just told you.
Well, it's only fair if we hear her side.
What, you don't believe me?
Oh, now wait a second. It's important to hear both sides of the story so that we can understand everything that happened.
Grandpa, can I tell you my side?
Oh, yes, go ahead.
When I was playing, Greg just came over and pushed me. I wasn't doing anything.
Okay, Greg, now what about...
Mother Nature takes her toll, raging against the elements. Fox News Channel is there, bringing you the updates. From the eye of the storms to the aftermath of destruction, make Fox News Channel your only source for complete and up-to-the-minute reports.
Power. 24 hours, 7 days. The most powerful name in news brings you the world. Fox News Channel, the power to bring you the people and places, from mega markets to emerging nations, reports that make a difference. Power to cover the events that shape the planet, the global forces changing your life. The power of Fox News Channel. News and information, fair and balanced. The most powerful name in news, Fox News Channel. We report, you decide.
Fox, Monday.
20年前国内を震撼させた男が帰ってきた。
犯人はもう次の獲物を狙ってる。
今度はインターネットで
現実の世界で襲う前に仮想の世界で接触している。
公開殺人が
犯行を続けると思うか。きっとやる。
ミレニアム月曜夜11時 on Fox。
is too high, and if the number were closer to 40,000, which is what I think it is, I think that is something that could be done in the period of time if you had enough teams doing it here. I guess the only other thing I would say is obviously we don't have any objection to having observers. In the Supreme Court's Beckstrom case, what happened there was that the circuit court had the clerk of the court review the ballots with a representative from each side present.
Had the clerk of the court?
In that case, it was the clerk of the court. That was the 1998.
That is Gore attorney David Boies, and what could only be described as a riveting exchange in Leon County Circuit Court as they continue to go back and forth debating how this, quote, recount will get underway based on the Supreme Court of Florida's decision earlier today. We're now joined by the chairman of the House Committee on Government Reform, Indiana Congressman, our good friend Congressman Dan Byrne. Good to see you in studio, too, by the way.
Yes, sir, yeah.
Welcome aboard.
Have you been this close to a liberal before?
You.
Occasionally. Occasionally.
When we get to the heart of this case, we're dealing, and why I think fundamentally the U.S. Supreme Court will get involved, and certainly there's a potential for the 11th Circuit Court to get involved here. They've now offered a third deadline. Change the rules after the election has taken place. These are all federal matters, and more importantly, they've undermined the constitutional authority, Article 2, Section 1, that grants the Florida legislature the authority to pick the electors and surrounding rules that they set up and design in the state.
I agree wholeheartedly that the state legislature probably should step in if the U.S. Supreme Court doesn't put a stay on the order made by the Florida Supreme Court. And I think they will. And I think that the U.S. Supreme Court will reverse that. And I would assume that if it's done by Monday or Tuesday, that the state legislature in Florida won't have to do anything.
Yeah, look, we can, I guess, predict all we want whether or not there'll be a stay issued this week, and I think there's a likelihood of that because of the way they vacated in their last ruling what the Florida Supreme Court was involved in. But we're watching, and we'll be carrying it for everybody on Fox News. You know, there was when you look at the dissent, the stinging rebuke I felt that Chief Justice Wells was giving his fellow jurist there. You know, when he talked about equal protection laws, when he talked about the separation of powers, when he talked about these matters, in my estimation, what he was clearly saying is, here it is, guys. It's on a tee. Knock it out of the park. These are federal issues.
Well, there's no question.
It is their jurisdiction then.
Yeah, they've gone into the legislative realm. They're making law instead of interpreting law. And I think the Supreme Court's going to say to them, hey, we sent this back to you once, and we're going to send it back to you again. And I think that'll be the end of it.
And this is, as conservatives, when we talk about judicial activism, we talk about legislating from the bench. Isn't this our great fear, what we're watching unfold in Florida, the Chief Justice referring to the chaos, constitutional crisis created by people that aren't doing their job, that are legislating from the bench? Isn't that, maybe is this another civics lesson in all this?
That's right. We're supposed to have 3 co-equal branches of government. And what we've seen in recent years, and this isn't the only case that
he brought up the separation of powers issue.
And what you're seeing is you're seeing the courts stepping in, and they're moving into the legislative arena and making law. And that's something that we can't continue to see.
Congressman, if I hear legislate from the bench, I just want to count how many times I'm going to hear that
That's
tonight.
what they're doing.
Look, they keep in this
if it walks like a duck and talks like a duck, quacks like a duck.
Look, I've read this very carefully. I've tried to dissect it. They keep mentioning 102.168 of the Florida Code, which has to do with how electors are chosen and how we go about contesting elections. And they are very strictly adhering to what that law says. And where it says, if anything is placed in doubt, if the result of an election is placed in doubt, which is something Sanders Saul seemed to ignore in the circuit court. He left out that part in his decision.
Alan, I love you. How can it be in doubt? It's been counted once, twice, partially a third time. Right. I mean, how many times you know what Gore wants to do? He wants to just keep counting and keep running this out until he finally finds enough votes to win.
Let me respectfully show you a different opinion from today's decision by the Florida Supreme Court. Here's what it says. A lawfully commenced manual recount in Dade County was never completed, and recounts that were completed were not counted. Without examining or investigating the ballots that were not counted by the machines, the trial court concluded there was no reasonable probability of a different result. On this record, there can be no question that there are legal votes within the 9,000 uncounted votes sufficient to place the results of this election in doubt. He had those ballots delivered, that U-Haul truck that now I think has been sold on eBay.
And they're going to send it back,
and how, you know, and he never examined them during this trial. Does that make any sense, to have all this evidence there and never look at it?
Well, I mean, they had been counted. You keep saying that they haven't been counted. There's evidence that they weren't looked at thoroughly. They were. They were two times.
This court is saying otherwise. And
well, I know that's what the majority opinion.
That's the majority opinion.
Listen, you've got 67 counties. You've got 67 possible different methods of counting those ballots. Nobody knows. I mean, are you going to hold them up to the light?
Well, that's what we're saying now. We're going in and out of. David Boies is now speaking in Leon County Circuit Court, and they're adjudicating this. They're arguing. They're trying to decide just what that standard should be, assuming both sides can agree with Judge Terry Lewis, rather, on what that standard should be. Wouldn't that be fair if they both decide on what the recount standard should be? The Supreme Court has decided they're going to recount all those undervotes all over the state now. That's never been a part of any of the cases. They pulled that out of the air.
Ultimately, will Congress get involved?
I think that's a real possibility, and if it does get to the United States Congress, I think George W. Bush will be the next president.
Congressman Burton, good to see you. Welcome to New York. And,
thank you, buddy.
Come back and see us again. We love to have you.
Nice to meet you in person.
Good seeing
you.
And coming up, well, what will the Florida legislature be doing? Will they be moving forward in its quest to name the state's electors for George W. Bush? They began their special session today. Or will they hold off now that the recounts may resume? We'll talk to Majority Leader Mike Fasano and another state legislator when we get back on Hannity and Colmes.
Remember him? He was such a jerk.
A complete jerk, but so cute.
So wrong.
Yeah, but
everybody told you.
I know, but I didn't want to hear it.
You listen to me.
That's different. I trust you. When you tell me something, I know it's the truth.
Well, in that case, trust me. That was one ugly dress.
No. You know, we agree on just one thing. A good argument's the best way to get to the core of an issue.
Wait a minute, I don't agree with that. A discussion's the best way. You have to explain, reason, justify your position.
Everybody on TV is discussing things, Alan. That's boring. If you want to find out what people really think, you need a good argument.
No, a discussion's better.
An argument.
A discussion.
We can agree on this. It's your turn to pick up the check today.
Well, I'll argue that one.
Alan, let's see if we can discuss this.
You Decide 2000, exclusively on the Fox News Channel. Powerful coverage from America's election headquarters. Review: Shepard Smith, Bill O'Reilly, Hannity and Colmes, Paula Zahn. Fair and balanced reporting from America's election team, giving you the power to decide. You Decide 2000, from the most powerful name in news, Fox News Channel. We report, you decide.
Hey, kid, come on over here. I want to show you something. I want you to listen to me now, okay? Because you got to get this read or else you're never going to make it. Now, if it goes over too much away this here, it's no good. If it falls over this way too much, it falls all over you. You got to make sure you got balance.
Balance?
All right.
Come first to Fox News for breaking news, exclusive stories that impact the world, unique, timely interviews that shape our nation. First on the scene with breaking news, continuous coverage from over 70 bureaus around the globe.
We're the only ones here who still have live pictures out.
Reporters, anchors, and correspondents that are first, fair, balanced. Powerful insight, powerful perspective, powerful news. Come first to Fox News for breaking news.
Channel V.
Channel V. Channel V.
Channel V.
Check it out now.
Channel V. 24時間 100% ミュージック。US、UK のトップヒット on air。Concert、Music News、スター独占インタビュー and more。International music scene をそのまま catch。
What does the V stand for?
It's all about music.
Channel V.
That we say it's a lower number and that they take no position on that. You're going to have to resolve that. Your Honor, the Supreme Court says on page 39, when talking about Miami-Dade, about the counting machine registered these as non-votes, and they've never been manually reviewed. We think you have to look at all the non-votes, not just the subset of undervotes. Mr. Boies argued the...
This is the circuit court in Leon County. Phil Beck, attorney for the Bush campaign, arguing before Judge Terry Lewis, who seems like he's just about to stop proceedings, and in a little bit he'll come up with a decision, and we'll have it for you live on Fox News. The issue has to do with how they're going to count the votes and if there's going to be a certain standard applied to all the undervotes in the various counties referred to in the Florida Supreme Court decision today. We're now joined by Representative Mike Fasano, Florida House Majority Leader in Tallahassee, and Representative Bob Henriquez, the Democratic Vice Chairman and a Gore elector in Tallahassee. I welcome you both. Representative Fasano, your party coming under a great deal of fire because of getting together and this talk about choosing your own electors under the U.S. Code. I'm just going to put up for a second what the U.S. Code says, and I want to talk to you about it, where it says, whenever any state has held an election for the purpose of choosing electors and has failed to make a choice on the day prescribed by law, the electors may be appointed on a subsequent day in such a manner as the legislature of such state may direct. The issue that my side argues is that there was a prescribed day and they were chosen, and as we saw from the, it's actually David Boies said, it was like a photo finish. We're just trying to figure out which person finished. They were chosen on the date certain.
Well, Alan, were they? You know, when the Florida Supreme Court created a new law a couple of weeks ago, it went before the U.S. Supreme Court and it was sent back to them vacating that decision. Therefore, no certified results under the U.S. Supreme Court may be in the archives as we speak right now, because they asked the Florida Supreme Court to relook at their decision and justify why they extended a deadline. So I don't know if we have 25 electors or not. And what the Florida legislature is trying to do is to be sure that we do have 25 electors on December 18th.
Representative Henriquez, welcome to the program. I'm Sean Hannity. Sir, before we get into that issue of your special session, I want to ask you a question. If this recount, in fact, sir, goes forward, and let's say you go into some Bush counties, Republican counties, and the canvassing boards 3-0 Republicans, and we go into these questionable ballots, does it concern you that Republicans will be the final arbiters of whether or not a vote is a vote when it comes to the questionable ones?
No, absolutely not. I think that we've been consistent in our call to have all of the votes that were cast legally counted.
Yeah, but the final determination will be 3 Republicans, no Democrats deciding. Would that bother you?
That doesn't bother me a bit. Again, I have great faith in the people that volunteer, or the people that are elected, the people that take the oaths of office, all the way from the canvassing boards, all the way up to the Supreme Court. We just want to have the votes counted in whatever manner, and at the end of the day, then we will have a president.
We're going to take a short break. We'll continue the debate on the other side of this break. More powerful debate ahead. Stay with us on Hannity and Colmes.
Fox News Channel, Primetime Power. Neil Cavuto, Brit Hume, Shepard Smith, powerful coverage. Wall Street, Washington, the world. Bill O'Reilly, Hannity and Colmes, Paul Lazan, powerful insights, confronting the politics, the newsmakers, and the issues. Primetime Power, fair and balanced. Fox News Channel, the most powerful name in news. We report, you decide.
Channel V.
Channel V.
Check it out now.
Channel V 24時間 100% ミュージック US、UK のトップヒット on air Concert, music news, スター独占インタビュー and more International music scene をそのまま catch
What does the V stand for?
It's all about music!
Channel V
Fox presents
科学分析プロー危険人物関与目撃証言消去
だが真実はそこにある X ファイル on Fox
さあスカリー行くぞ
2人の FBI 捜査官が挑む世界の裏側の巨大な謎
I think that we've succeeded in doing that first and foremost. It's become a lot of other things, but I think it is a scary show.
X ファイル 全米のメジャーなテレビ賞を連続受賞。
The X-Files has really caught on because I think people around the world have to be scared.
X ファイル。その魅力は今も世界中にファンを生み出し続ける。
X ファイル？
よくできてますよね。もっと続けて。来週はどんな話なんだろう。見ればハマる。
テレビ史上真実が知りたい。かつてない
答えを見つけて
進化し続ける最高傑作。真実はそこにある。目撃者はあなた。X ファイル。毎週月曜夜10時。Only on Fox。
4:30 in the morning, which is fine. But we need to know what we want to do, who you need up there, and if it's just going to be legal argument, what time you would want anybody. We'll do whatever you want. You've heard enough from all...
Brief moment of humor in the Leon County court hearing on the Florida recount in response to the Florida Supreme Court's ruling earlier today. And we continue with Representative Mike Fasano. He's the majority leader in the House in Florida, and also joining us, Representative Bob Henriquez. Representative Henriquez, you know what the problem here is? Who does the counting? What are the standards? Are they changing standards? Are they varying standards? What was the criteria? What constituted a vote before the election, and did it change after the election? Don't any of those issues bother you, Representative?
No, again, I believe that we're having a hearing right now to set standards as prescribed by the Supreme Court ruling. Right. We'll set those standards, we'll count the rest of the ballots, and we'll be done with this. The constitutional crisis will be avoided. Everything else that we're talking about will be a moot point. Right. We'll have a president.
Let me jump in if I can.
That's fine. If it's
Judge Lewis has just taken a brief recess, as you can see there, as he leaves the courtroom. Now, he will come back with a decision, and when that happens, we will bring it to you live right here on the Fox News channel. And I go to you, Majority Leader, Representative Fasano, if I can. The changing standards, varying standards, who does the counting, Democratic-dominated canvassing boards. You know, that's one of the main arguments the Bush camp has been making from the very beginning. Machines are neither Republican nor Democrat, and they are objective. These standards are subjective and selective, and clearly, in my view, it violates Florida state law in a lot of different ways, not the least of which is that they're not a full recount in the counties.
Absolutely, Sean. And then, as you know, they have changed the standards since day one. And not only has that happened, but the Florida Supreme Court has changed the standards.
Twice.
They've changed law. They've made new law.
You know what's really amazing?
And in fact, we're watching tonight in a courtroom deciding on standards after an election has taken place. Remember, the Constitution is clear that you will go by the standards and the law that was prescribed in the election.
We only have a moment left, Representative Fasano. According to today's Palm Beach Post, you're changing the standards, you're changing the rules in your state house by planning to appoint your own electors. You're having less debate. You're doing a concurrent resolution to name the 25 electors, and that's changing the rules. So you're doing the very thing in your state house that you're accusing the courts of doing, that liberal Florida Supreme Court you say you don't like.
We only have a second.
You want to respond to that, sir?
Real quick, we only have a 15 seconds.
Let me tell you, we're not changing any rules. We're not changing any laws. The Florida Supreme Court has changed the law not once but twice. And the U.S. Supreme Court has, in fact,
Mr.
told them
Henriquez,
that
you guys have 10 seconds. They're changing the rules of debate, aren't they,
Gentlemen,
Mr. Henriquez?
we're out of time. We're just going to have to leave it there. But Representative Fasano, good to see you. Thank you, sir. You're doing great work down there. Representative Henriquez, thank you for joining us tonight on Hannity and Colmes. That is our show for tonight. By the way, here's our answer to the Vote.com question. How soon do you think we'll know who's won the presidency? Here are the results. 62% say next week. I hope you're right. 10% Christmas and 28% by Inauguration Day. And that is it for us tonight. A special edition of Hannity and Colmes Sunday night, 9 to 11. The Edge is up next. Please join us. See you again. Thank you for being with us.
Tonight, advantage Gore? Well, the Florida Supreme Court rules in the VP's favor and orders immediate manual recounts. This on a day that began with double Bush victories in Martin and Seminole counties. So in January, who will live here? The Edge begins in 90 seconds. Fox News Live, I'm Patty Ann Brown. Just when it seemed Al Gore's run for the White House was dead in the water, an incredible turn of events gives him new life, courtesy of the Florida Supreme Court. Court spokesman Craig Waters made the shocking announcement that the 7 justices have called for an immediate manual recount of so-called undervotes in all 67 Florida counties. Not surprisingly, the Gore camp hailed the ruling.
This decision is not just a victory for Al Gore and his millions of supporters. It is a victory for fairness and accountability and our democracy itself.
Today's ruling also reduced George W. Bush's lead to 154 votes. The Texas governor had been leading Al Gore by 537 votes. Bush lawyers say they're appealing today's ruling to the U.S. Supreme Court. The Bush camp wants the recounts stopped immediately.
It is very sad. It is sad for Florida. It is sad for the nation. And it is sad for our democracy.
Meanwhile, Florida's Republican-led legislature convened a historic session today. It will reconvene Monday for hearings on resolutions that would choose 25 electors who have pledged to vote for Bush. Our next update is at the bottom of the hour. Now stay tuned for The Edge with Paula Zahn. And good evening, everyone. Thank you very much for joining us here tonight on The Edge as we wrap up yet another eventful week. I'm Paula Zahn. This has been an incredible day in the quest for the White House. What seemed like a sure Bush victory changed dramatically when the Florida Supreme Court ordered a manual recount statewide. Let's go right to Tallahassee, where Jim Engel is standing by with more of the details. Go to it, Jim. It's
well,
all
there's
yours.
a lot to... There's a lot from today. I'll tell you, the Supreme Court came out 4-3 vote, said they were reversing the lower court's decision and that they were ordering an immediate recount, not just of the 9,000 undervotes. Those are the ones that do not have a clear vote for president. Ordering a recount of not just the 9,000 in Miami-Dade, but in every county in the state which has not yet done a manual recount of undervotes. So that is the process that is now begun. There was a hearing this evening that began about 2 hours ago. It has just gone into recess to start to work out the details on how you do that. Now, before that even began, Judge Sanders Sauls, the man whose decision was reversed, recused himself, so they had to pick another judge. So they now have another judge, Terry Lewis, who is in there, has been in there for a couple hours talking to the lawyers. They've taken a break. They're trying to iron out what happens next. The court has ordered this massive recount of votes, but how do you count them? What are the standards to be used? And that is what the lawyers from both sides are now arguing over. The Republicans say, more or less, I'll cut to the chase, they say more or less, let's use the standard that was used in Palm Beach, where people look at a ballot, they look at the entirety of the ballot, and if all the other races are punched out and the presidential race is not punched out, even if there's some stray mark on there, that makes it clear that the voter knew what he or she was doing, knew how to punch out the chads, and did not, meaning they didn't intend to vote for president. Now, in Broward County, that same ballot would have been counted for a vote. If they'd punched out the chads for Democrats down the ballot, that would have been counted as a vote for Gore on the theory that if they voted a straight Democratic ticket, they intended to vote for Gore. Now, what the Republicans are saying is not the Broward County standard. You've got to go with the Palm Beach standard. The Democrats are saying, hey, the Supreme Court has decided this thing. They said use a standard, see if you can determine the voter's intent. We don't really need to go any farther than that. That's good enough. The Republicans say, no, 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 you've got a huge amount of subjectivity here. You have got to set out a clear standard, and you're going to have probably 63 counties going over their votes, and in some cases it won't be judges because the judges won't have enough time. It'll be a number of other people to whom this job has been delegated. So there has to be a clear standard set out from the bench, or else you're going to have problems. They're trying to work all that out. It would not be hard to count the estimated 45,000 undervotes just if you were just counting those votes. The problem is if you have to decide how you're going to count them. That is the tough part. That's what they're wrestling with now, Paula.
All right, help us with this, Jim. You just mentioned the 45,000 ballots out there constituting undervotes. There seems to be some conflicting views about what portion of those might be counted in Tallahassee and what portion of those might be counted in the individual counties where the votes were cast. What is your understanding of what is about to happen, if it does happen?
Well, the problem is the court here, obviously the court here has the authority to count them all, but they don't have the capacity to count them all. They may or may not be able to count the 9,000 votes in Miami-Dade. Just before the court recessed a few moments ago, the judge said, well, what do you think about having Miami-Dade count those votes in Miami-Dade? To which the Republicans said, wait. These votes were brought up here so the court could count them. There's already a concern that the court will not have enough time to count these in a timely fashion. Now, the reason they were going to let all the other counties count their own votes was precisely because of that. There is a concern that the court only has so many people it can assign to this, and of course you're going to have observers watch. You're going to have all sorts of people looking over their shoulders. You're going to have people making a record of it so objections can be raised. It is not going to be that easy to just sit down, take a look at them, say, yeah, here's one for Gore, there's one for Bush. It won't be that easy, but the court will not be able to do it all. They're going to have to rely on the local canvassing boards. But again, they have to be given a clear and specific standard, the Republicans argue, or you'll have votes all over the state being counted by a variety of different standards, and that, they argue, would be against, among other things, would be against the Voting Rights Act, which is one of the most important pieces of federal legislation ever passed, and one that judges nor anyone else want to tread on for fear of getting reversed somewhere up the line, most likely the U.S. Supreme Court, Paula.
Well, I guess, Jim, there's no doubt as to what you'll be doing this weekend. Working again. Thanks for your clarity, as always. And now we're going to move on to Carl Cameron, who is equally clear on what is going on down with the Bush camp. Hi, Carl. What news do you have from there tonight?
Working. Well, it's not at all clear as to whether or not the U.S. Supreme Court will be working today or tomorrow, because the Bush camp had the sneaking suspicion, in fact, they'd all but predicted that they would suffer this defeat in the Florida State Supreme Court today. And for the last couple of days, they had been preparing a number of appeals for the possibility that they would suffer this setback and would have to appeal this ruling from the Florida State Supreme Court up the line. They have taken 3 steps today. First, they have set forth an appeal to the 11th Circuit Court of Appeals in Atlanta, asking for an emergency hearing for their appeal to block the recounts, which was rejected earlier this week. At that time, the Florida 11th Circuit Court of Appeals had said they were going to turn back Bush's appeal to stop the recounts, because at that point, there was no indication that Governor Bush had suffered, quote, irreparable harm. What the Bush campaign is now arguing is that the Florida Supreme Court has put them in a position to suffer irreparable harm. They therefore want an immediate emergency hearing to argue against the recounts. That's the first thing that they've done. The second thing that they have done is formally appealed to the U.S. Supreme Court to have the Florida State Supreme Court overturned and block the recounts in that way. And finally, and perhaps the most immediate effect, is their request from U.S. Justice Anthony Kennedy asking him to grant an emergency stay, in other words, block the recounts entirely. Mr. Kennedy has in fact received that request, and he has at his disposal a couple of options. Justice Kennedy can act unilaterally and block the recounts and stop things forthwith, or he can choose to confer with the rest of the U.S. Supreme Court. Were that to happen, there's a couple of additional steps that could take place. They could grant the writ, which would mean that there would be a hearing, in which case both the Bush and Gore lawyers would have to file written briefs followed by oral briefs. That could be done all in one day, presumably even Saturday. But as each step takes place, more time is consumed. And if a stay is granted, the manual recounts that are about to get going, if, as Jim Angle has just said, they can work out the details, that would then be halted, again, eroding what precious time is left before the deadline, Tuesday the 12th, wherein Florida's electors have to be approved and determined to be, quote, regular. If they are determined to be regular on the 12th, then they can go to the Electoral College on the 18th. Lots of legal wrangling. The bottom line for the Bush perspective, horribly disappointing. Many Bush supporters around the country bitterly angry, but none of them particularly shocked by this decision. They had looked at those decisions from the Florida Supreme Court over the past couple of weeks, had sort of branded them liberal activist judges. They had expected a setback. They have now received it. They put the wheels in motion to stop it. Paula?
As always, good to have you with us. Late on the edge, Carl Cameron, making some sense of some very confusing details. Have a good weekend. Coming up, we are going to hear from Montana Governor Mark Rasko, who will fill us in on more of the Bush strategy. Keep it right here on The Edge. We will be right back.
If making money were simple, we'd all be millionaires. Let's face it, money decisions are tough decisions. You need to know what's going on here and how it will affect your finances, your future, and your family. We cover the markets in plain English so that when the bell rings, you can understand what happened and decide what's right for you. We bring Wall Street to Main Street so maybe you can live on Easy Street.
Power. You want to make the right choices. We give you the power to decide for yourself. Power. 24 hours, 7 days a week. Nobody gives you more original live programming. The power of news to keep you up to date. Shows that go in depth. Issues in context. Topics that matter to you. The power of Fox News Channel. News and information, fair and balanced. The most powerful name in news. Fox News Channel. We report, you decide. Fox News Channel Daytime. You want to make the right choices. We give you the power to decide for yourself. Fair and balanced. The most powerful name in news. Fox News Channel. We report, you decide.
What? You got the tickets? You bet I'm there. I'll pick you up. Oh, wait a second. You know, I can't make it. No, I can't. Yeah, it's pretty important. I gotta go. Okay, I'll talk to you later. There's Daddy's little girl.
Opinions. I have them, you have them. In fact, on any given subject, there are as many opinions as seats in this theater. And that's good, people speaking out, sharing ideas. But opinions are not the same as facts, and you should know the difference. And that's why at the Fox News Channel, we label all opinions right on your TV screen. And that should help you form your own opinion, so you can decide what's right and what's wrong.
Vote of 4-3. The majority of the court has reversed the decision of the trial court in part. It has further ordered that the Circuit Court of the 2nd Judicial Circuit here in Tallahassee shall immediately begin a manual recount of the approximately 9,000 Miami-Dade ballots that registered undervotes.
And welcome back. That was Florida Supreme Court spokesman Craig Waters. We continue now with our special coverage of Florida's decision. Joining me now is Bush advisor, Montana Republican Governor Mark Rasko. Good of you to join us on a Friday night. Welcome, Governor.
Thank you very kindly, Paula.
Carl Cameron just set out for us some of what the Bush strategy is in the 11th Circuit Court of Appeals and the U.S. Supreme Court. What do you think is the likelihood of actually getting this recount to be stopped if it starts at all?
Well, in our judgment, of course, it's a brazen judicial adventure that was taken by the Florida Supreme Court. They've just virtually reinvented the entire election code of the state of Florida, which is a serious, serious constitutional problem under our Constitution, which in essence reserves that authority to the legislature and even under federal law.
So are you basically saying you believe the law is on the Republican side and with any good help from the 11th Circuit Court of Appeals, this recount will stop, or you don't think it'll start at all?
Well, the part of the process that we've set in motion is to appeal to the court to stay the process there, the recount process, until such time as the court has an opportunity to address all of the issues involved.
And how optimistic are you at this point that they will rule in your favor?
Well, this is a stunning abrogation of the law and an invasion of the United States Constitution. So my belief is that the possibilities of this are very, very strong because it's so critically important to avoid infringing upon the constitutional prerogative that's reserved to the Florida legislature. So I believe that the United States Supreme Court will favorably consider that request.
If they don't, what will you do?
Well, then we'll have to address these issues in the hard way in front of the court to begin with, which we're doing presently, as you know. Try to point out the absurdity of the expectations that have been laid upon the court. How, in the name of God, the Florida Supreme Court could have ordered all of this up without giving any directions in terms of standards or how to do it or where to go, how many counties to be engaged in this process. It's just absolutely remarkable to me in my 27 years of being engaged in practice all around the country, including before appellate courts. I've never seen such an extraordinary abrogation of the law and such a example of judicial invention.
Yeah, let's talk about those standards for a moment, because I have been told that some Republicans would find the Palm Beach standard acceptable. That is, where you'd look at a ballot, and if you see that someone has voted down a straight party line and there was no vote cast for president, you certainly wouldn't count that ballot. Would that be acceptable to you, statewide?
Well, in my view, Paula, the standard easily stated, which is to ascertain the intent of the voter, is so incredibly difficult to translate into reality. I sat for 3.5 days in the Broward County Courthouse in Fort Lauderdale and watched this process. And you have to remember that, first of all, you have people who have passions and prejudices and are partisans that are engaged in this process. Secondly, they're not always going to apply the same standard from ballot to ballot. And what they're trying to do in a mystical sort of way is determine whether or not a person they've never met may have intended to vote in this particular race. And as a consequence of that, it's just an untrustworthy way to go about thinking of electing a president of the United States of America. And they change from ballot to ballot is the interesting process, because they're human. They get tired, they get exhausted. It's almost physically impossible to expect that a judge is going to be able to review 43,000 ballots, but I believe that's what the law requires.
All right, Governor, one quick answer to this. I know you say that you feel that the Florida Supreme Court violated the Constitution here, but with a 4-3 vote, what role do you think politics actually play?
Well, I wouldn't accuse the court of playing politics. What I simply say is that the law is clear, and they have exceeded even their own expectations that they created in their previous decision by this one.
What would be their motivation for doing that?
Well, I think that they're moved by a desire to try and produce a result that's impossible under the circumstances to be obtained. There was no evidence or proof that was introduced in the lower court to call for this kind of a judgment. And they just simply have moved in a direction that is in violation of the law, as the Chief Justice of the Supreme Court there in Florida pointed out. They're just simply wrong. And I think that the United States Supreme Court will recognize that quickly.
And I will be watching right alongside you and the Democrats to see what might transpire in the hours to come. Governor, thank you again for joining us tonight on The Edge.
Thank you, Paula, very much.
Our pleasure. Coming up, our team of Republican and Democratic legal experts will square off. Keep it right here on The Edge, a debate around the corner.
You know, some mornings this is just too much. Especially when it's cold and nasty outside. But you're my pal. You're always there for me, unlike some people. And I'm not gonna let you down. Come on, man, let's go outside. So, Cosmo, got any big plans for today?
Fox News Channel, Primetime Power. Neil Cavuto, Britt Hume, Shepard Smith. Powerful coverage. Wall Street, Washington, the world. Bill O'Reilly, Hannity and Colmes, Paul Lazan. Powerful insights, confronting the politics, the newsmakers, and the issues. Primetime Power, fair and balanced. Fox News Channel, the most powerful name in news. We report, you decide. Power. 24 hours, 7 days. The most powerful name in news brings you the world. Fox News Channel, the power to bring you the people and places, from mega markets to emerging nations. Reports that make a difference. Power to cover the events that shape the planet, the global forces changing your life. The power of Fox News Channel. News and information, fair and balanced. The most powerful name in news, Fox News Channel. We report, you decide.
胸騒ぎの夜 フォックスが待っている、エンターテインメントが待っている。夜9時、ロディオショーに命を懸ける男たち、人命救助 SOS。 夜10時、凶悪犯罪捜査ファイル。夜11時、全米警察24時。夜12時、巨大な嵐が街を飲み込んだ。追跡、生死を分けた大暴風雨。夜9時、悪魔に狙われたジャイルズ。バフィー恋する十字架。夜10時、マジックの裏側公開第2弾。破られたマジシャンの掟パート2。夜11時、厄介な被告に手を焼く弁護人ザ・プラクティス。夜9時、陰謀に巻き込まれた少女を救えトゥイ、同じ顔の悪魔。夜10時、腹部を食いちぎられて死んだ元サーカス団員 X ファイル。夜11時、殺人現場を映し出すホームページミレニアム。胸騒ぎの夜、フォックスが待っている、エンターテインメントが待っている。人命救助 SOS、 凶悪犯罪捜査ファイル。全米警察24時、追跡、生死を分けた大暴風雨。バフィー、破られたマジシャンの掟パート2、ザ・プラクティス。2、X ファイル、ミレニアム。吹き抜けるハリウッドの風、今日本にもうフォックスしかない。
This decision is not just a victory for Al Gore and his millions of supporters. It is a victory for fairness and accountability and our democracy itself. Let the count begin, not just of the votes yet to be counted in Miami-Dade, but as the court wisely ruled in every Florida county where undervotes have yet to be counted. Then Florida and America will know with certainty who has really won the presidency.
And welcome back. That was Gore campaign chairman William Daley. We continue now with our special coverage of Florida's decision to try to make sense of today's historic legal roller coaster. We have put together an esteemed panel. Joining us from Washington, Laura Ingraham, former U.S. Supreme Court clerk to Justice Clarence Thomas, Democratic attorney Stan Gildenhorn, Georgetown law professor Paul Rothstein. There's Paul. Okay, we jumped ahead a little there, a little too quickly. And here in New York with me is election law expert John Corbone. Good to have all of you with us tonight.
Good to be here.
All right, Mr. Gildenhorn, what are the chances of this recount actually starting?
Well, I guess Judge Lewis is going to work on that right now, at least with respect to the ballots over which he has control. You know, it seems to me that if Canada can count 13 million hand ballots in 4 hours, the 67 counties in Florida can also count the undervotes in their counties. This can be done. I would suggest it can be done by Tuesday, provided that the vote begins tomorrow, provided that Justice Kennedy does not halt the vote or the 11th Circuit does not intervene.
Laura Ingraham, what do you think the chances are of this actually starting and being done with by Tuesday?
The same chance as it being 95 degrees here tomorrow. I mean, not much of a chance. I mean, Paula, when you step back for a second, we talked a month ago about how amazing it is that the presidential election could be determined by one state, Florida. Then we said how amazing it could be that the presidential election could be determined by 3 counties. Now we have a presidential election that may be determined by one judge, Terry Lewis. And when it's not just a matter of counting votes, it's a matter of counting votes without standards, counting votes without clear standards for observers or objections by Democratic and Republican observers on the scene. How we actually conduct this county by county. Will there be one uniform standard, or will we continue to have this crazy quilt of standards across Florida? So instead of clarifying what has been an incredibly mucked up process, this Florida Supreme Court decision creates, you know, a little shop of horrors down in Florida that I think the U.S. Supreme Court is going to slap down and slap down really hard.
All right, well, Professor Rothstein, I want you to react to what Chief Justice Wells said in his dissent today, and we're going to try to get this up on the screen so everybody can read it. Quote, I also believe that the majority's decision cannot withstand the scrutiny which will certainly immediately follow under the U.S. Constitution. My succinct conclusion is that the majority's decision to return this case to the Circuit Court for a court of the undervotes from either Miami-Dade County or all counties has no foundation in the law of Florida as it existed on November 7th.
Well, there are two different models here, really. One subscribed to by that justice and also by Judge Sauls in the lower court, and one subscribed to by the majority of the Florida Supreme Court. The one that Judge Sauls and this Judge Wells that you just read subscribed to is a model of administrative convenience, that we defer to acts that have already been done by county canvassing boards and certifications that have already been done, and we only overturn them if some high burden of proof has been met. The majority of the Supreme Court of Florida subscribed to a model of let us try to ascertain the intention of each individual voter. It may be overly optimistic that that can be done, just as the other view is overly oriented to administrative efficiency. But both of them are a reasonable way, it seems to me, to put together the disparate provisions of this statute, which is a hash. I do not believe that the United States Supreme Court has enough members who believe that it is somehow federally unconstitutional for the court to interpret legislation. I don't think the United States Supreme Court will slap it down. This court was just doing what courts always do, and if you condemn it, you're condemning the judicial process.
John Carbone, where do you think the U.S. Supreme Court might figure into this? Will they slap it down if they take it?
I think they will. I don't think Professor Rothstein is directly on point on there. You can play a piece of music, you can interpret a piece of music, and you can change a piece of music from what the composer originally did. And I think we have the Chief Justice Wells telling us they've changed the music. This isn't an interpretation, this isn't a little variation, this is a major change. And
he went so far as to say that this could cause a constitutional crisis.
Exactly, and I think he's right. And what he's also saying is, as Laura pointed out, is that they have set no new standards. Who observes? How is it done? Where is it to be done? And we're back to that very, initially someone said that we can count in Canada. Canada has a standard. Canada has a much different standard machine, unlike what Florida's done. Florida's standard is still it's in the eye of the beholder as to what the intent of the voter is.
Laura, jump in there quickly, and then we're going to have to take a break.
Yeah, Paula, just one line that we haven't quoted yet from the opinion, from the dissent, where Justice Wells says, we must have the self-discipline not to become embroiled in political contests whenever a judicial majority subjectively concludes to do so because the majority perceives it's, quote, the right thing to do. So this dissent is stinging beyond belief, using words like equal protection violation. We have equal protection claims. We have separation of power problems. I've never seen a dissent quite like this.
All right, Laura, Stan, Paul, and John, please stand by.
No. We agree on just one thing. A good argument's the best way to get to the core of an issue.
Wait a minute, I don't agree with that. A discussion's the best way. You have to explain, reason, justify your position.
Everybody on TV is discussing things, Alan. That's boring. If you want to find out what people really think, you need a good argument.
No, a discussion's better.
Argument.
A discussion.
We can agree on this. It's your turn to pick up the check today.
Well, I'll argue that one.
Alan, let's see if we can discuss this.
Fox News Channel Daytime. The whole story in context. Facts presented fairly. The issues balanced, so you have the power to think for yourself. Fair and balanced. The most powerful name in news. Fox News Channel. We report, you decide.
Fox presents.
邪悪な魔力と戦うために選ばれた一人の戦士。フォックスが放つニュータイプのエンターテイメント。キュートでクールなスーパーヒロイン。
お待たせ。
バフィー、恋する十字架。彼女は高校生。彼女は恋する少女。彼女はヴァンパイアスレイヤー。
I'm Sarah Michelle Gellar。
ヴァンパイアと戦うことが彼女の使命。
運命だったね。
信じますね。
信じますよ。
運命の人がいたらいいな、いてほしいです。
頭がぶっ飛ぶのが愛。
君とは戦わない。
切ない恋の行方はフォックスが放つニュータイプのエンターテイメント。キュートでクールなスーパーヒロイン。バフィー、恋する十字架。毎週木曜夜10時。宿命の対決か運命の恋か。 Only on Fox。
News Live, I'm Patty Ann Brown. After swinging and missing in so many legal battles, Al Gore has hit one out of the park, thanks to the Florida State Supreme Court. The state's high court reversed a lower ruling and ordered a statewide manual recount of so-called undervotes to begin immediately in all 67 Florida counties. The decision is a major victory for Gore, who has been relentless in using the legal system to get what he has called a full and fair count of the Florida vote. Today's ruling has also reduced the Bush lead to 154 votes, placing in doubt his certified victory. Bush lawyers say they're appealing to the U.S. Supreme Court to immediately stop the recounts. The ruling could not have come at a more critical moment for the Democrats. Earlier today, 2 judges in Seminole and Martin counties rejected a bid by Gore supporters to throw out 25,000 absentee ballots. These were serious setbacks for the Gore team, occurring less than 2 hours before the Florida Supreme Court's announcement. Meanwhile, Florida's Republican-led state legislature has convened an historic special session today to choose a new slate of presidential electors. Lawmakers will reconvene Monday for hearings on resolutions that would choose 25 electors who have pledged to vote for Bush. Our next update is at the top of the hour. Now stay tuned for more of The Edge with Paula Zahn. Paula has more on the rulings.
The trial courts in both the Seminole County case and the Martin County case have determined that despite irregularities in the request for absentee ballots, neither the sanctity of the ballots nor the integrity of the election has been compromised.
And welcome back. That was Leon County Court Clerk Terry Cass earlier today, with a twin pair of victories for Governor George W. Bush. That didn't last long. We continue now with our legal panel to make sense of today's twists and turns. Welcome back to Laura Ingram, Stan Gildenhorn, Professor Paul Rothstein, and John Carbone. All right. Granted, you all are very smart people, but John Carbone, you told me last night that you believe Judge Saul's decision was bulletproof. What happened? You weren't alone. There were a lot of people who shared that same view.
We thought his findings of fact would have sustained any overturn, and they did, because it's what the court has said is it wasn't his findings of fact, but applying the law, he misstated the law, and he should have gone for the recount and allowed the recount to go forward. That's probably a stretch, but it certainly has made Al Gore the comeback kid.
Stan, how do you think this is going to end up?
Well, now you're asking the $64 question, Paula. I mean, this could literally go all the way to the Congress of the United States. But I'm not satisfied, as many have stated, that the Supreme Court is going to slap down this decision. I haven't had a chance to read the whole decision. I've scanned it as much as I can on the internet. But I think it's a well-reasoned decision. And I think it's grounded in Florida law, both statutory and Florida case law. I don't think there's a federal issue here. And as we know...
In fact, the Chief Justice, though, Stan, and you told me in the green room you hadn't read the decision at all.
No,
so I don't know what this...
I scanned it, Laura.
Okay, you scanned it. Okay, that's different from what you said before. But
he didn't inhale.
The United States Supreme Court decision of Bush versus Palm Beach Canvassing Board just issued, in fact, does conflict with this majority opinion, as the Chief Justice says in his dissent. Because, as you know, Stan, the Supreme Court ruled that Article 2, Section 1 requires that the state legislature set the rules for determining who shall be named electors in the state. And that means that not the Circuit Court and not the Supreme Court can set standards for what votes will be counted. And what's going to happen tomorrow?
Laura, I think you're overstating. Laura, you're overstating.
All right, let's let the professor straighten out our classroom here this evening.
Laura, you're overstating what the United States Supreme Court said. They actually didn't decide that. They didn't, just a minute, they didn't decide that issue at all. They said we want some more information before we reach the question as to whether what the Florida Supreme Court is doing exceeds what a court is allowed to do with legislation, in interpreting legislation. So a couple of the justices in oral argument hinted that there was a point at which a Supreme Court like Florida may exceed a constitutional bounds, but they didn't say where that point was.
And this is it. This is exactly what they were trying to avoid.
You know, merely because they didn't make reference to a federal constitution or federal statute doesn't mean that the outcome of the case doesn't affect a federal right or a federal claim. And I think, you know...
I don't disagree with you on that. I think you've got a point. On the other hand, the Supreme Court has said to Florida in the remand a fundamental question. Can you please tell us, did you decide this case based upon solely Florida law and Florida case law, or did you consider federal issues? And I think the Supreme Court today of Florida answered the Supreme Court of the United States and said this is absolutely based upon Florida statutory law as well as case law.
Let's remember, it was both a vacation and a remand. They vacated what they had ordered. Now that we're back to looking at what the remand is and what the result will be, they may even say that it is based on Florida law, but again, the result could be something which is more than Florida law. And I don't think they couched it that carefully. And I think that Chief Justice Wells was very clear that it's going to afford not only a political constitutional crisis, but it is ramming it back to the Supreme Court. It was a very genteel remand from the Supreme Court.
Paula, one thing we should remember is there's so many great lines from the dissent, and I know I'm just quoting from the dissent, but we've already heard from the majority, where Justice Wells says...
At least for a minute we did.
Well, exactly. Where Justice Wells writes, page 55 for those law geeks out there who printed off the internet, laying aside the constitutional infirmities of this court's action today, what the majority actually creates is an overflowing basket of practical problems. He then goes on and says, this contest simply must end. That's the Chief Justice, a Democratic appointee, Chief Justice of the Florida Supreme Court.
Professor, hang on. Order in the courtroom, order in the classroom. Professor, why don't you close out this segment and tell us what your interpretation is and your reaction to Chief Justice Wells' dissent. In that particular part,
last week, Laura thought Chief Justice Wells was a villain. Now he's a hero.
Yeah, I changed my mind. I'm a woman. I can do that.
Okay, well,
I changed my mind, and that doesn't mean
I think it shows that he's honestly trying to call the shots the way he sees them. And to use the music analogy that John used, the Supreme Court today was just singing the aria with its own rubato and its own legato and its own lacrimoses, its own sobs in the middle of lines.
It's the unfinished symphony.
That clarifies it.
Certainly the unfinished symphony. And
a dissonant one as far as you are concerned, right?
It's atonal music.
Being a cellist, I get that.
Its own tempo, its own slowing down and speeding up.
All right, Laura, you get to provide your interpretation of all that.
Yeah,
Musical language on the other side of the break. We've got to take a short one. Our debate will continue on the other side. We'll be right back.
There's nothing new going on in Washington. No new issues, scandals, or controversy, because Washington has always been a hotbed of egos, emotions, and intrigue. The only difference now is that the press and media are all over it, with more cameras and more reporters than ever before. But how can you be sure you're getting the whole story, fair and balanced? Well, watch the political fireworks here and catch the best show around.
Grandpa, that's the whole story. That's what happened.
Okay. Katie, now you tell me what happened.
Well, but Grandpa, I just told you.
Well, it's only fair if we hear her side.
What, you don't believe me?
Oh, now wait a second. It's important to hear both sides of the story so that we can understand everything that happened.
Grandpa, can I tell you my side?
Oh, yes, go ahead.
When I was playing, Greg just came over and pushed me. I wasn't doing anything.
Okay, Greg, now what about...
Remember him?
He was such a jerk.
A complete jerk, but so cute. So wrong.
Yeah, but everybody told you.
I know, but I didn't want to hear it.
You listen to me.
That's different. I trust you. When you tell me something, I know it's the truth.
Well, in that case, trust me. That was one ugly dress.
Monday.
20年前国内を震撼させた男が帰ってきた。
犯人はもう次の獲物を狙ってる。
今度はインターネットで
現実の世界で襲う前に仮想の世界で接触している。
公開殺人が
犯行を続けると思うか。きっとやる。
ミレニアム月曜夜11時 on Fox。
back. We continue now with our legal eagles, Laura Ingram, Stan Gildenhorn, Professor Paul Rothstein, and John Carbone. Okay, Stan, quick question for you. We understand the Bush camp is going to try to get the 11th Circuit Court of Appeals to stay this recount, and in the process, they're going to have to prove that irreparable damage was done to their campaign. Now, isn't that a pretty convincing point when Mr. Gore gained some 383 votes in a partial recount today? Don't they have a pretty good point?
So. I don't think it's an irreparable harm to Mr. Bush. I don't think it's irreparable harm when a court has ordered votes to be counted. In this case, the 11th Circuit rejected the Bush appeal, and by the way, Bush was the first person to go to court, not Gore, but they rejected that based upon the fact that the governor had sustained no irreparable harm. I don't know why today's Florida Supreme Court decision is any different. What is the irreparable harm to George Bush by today's Florida Supreme Court opinion? I don't see any.
Laura,
I'll answer that. The irreparable harm is obviously recounting votes with disparate standards, changing standards, county by county.
Yeah, but Laura, the 11th Circuit didn't have the problems with that before. Why not?
No, but Stan, obviously facts have changed. I mean, things have changed. We have a ruling from the Florida Supreme Court, which in fact, the Chief Justice, as I read before, had said this raises equal protection concerns that he believes will be overturned by the U.S. Supreme Court.
I understand what the Chief Justice believes. He is a minority member of this Supreme Court. He is in the minority.
He's a member of a three-team minority, a three-person minority.
That is correct, and his wisdom is no greater than anybody else on that Supreme Court.
If we had a
because he's the Chief Justice, doesn't make his decision any better than anybody else.
It's a funny argument of irreparable harm that they've made. They're arguing that Bush is the certified winner, and now to have recounts that show that he really isn't the winner is somehow irreparable harm. It is harm.
Well, Professor, I mean, how would you define that? That wasn't a good thing that happened to him today.
But if it shows that he didn't really win the election, I don't think you can call that some kind of redressable.
The harm arises a little bit different. He was declared the winner by the Secretary of State. Now you have this Florida Supreme Court ordering that partial recounts in limited counties be included in the total, not awaiting the final recount that they've ordered statewide, but immediately directing.
What's the harm?
The harm is that the declaration of the Secretary of State.
It shakes public confidence in the previous certification, but isn't that a good thing?
No, Professor, it interferes.
Constitutional crisis is a great thing, Professor.
The court is trying to make certain that the people of Florida's votes are counted. It's that simple.
No, what the court made sure was that a partial hand recount was
all right, you know what? I'm going to cut all you off because I want you to answer this very quickly. You help us better understand what Leon County Circuit Court Judge Terry Lewis is going through tonight as he tries to establish standards by which some 45,000 ballots representing the undercounted ballots will be looked at. Professor?
Well, Paula, it's the same old story they were as they were struggling with before, and I agree with Laura actually here that the Supreme Court of Florida sidestepped the hardest issue, which is what should the standards be? It's the same old issue that's been the big issue the whole time. Do you count dimples? Do you look to see if there are other dimples before you count dimples? And the Supreme Court of Florida sidestepped it.
Well,
and I think they caused harm.
Well, there's a good reason, Paula, the Supreme Court sidestepped that because Article 2, Section 1 says it's the state legislature's role to set rules that govern the selection of electors, not the
do any of you, hang on. All right, do any of you dispute that, Stan?
That's ridiculous.
That's what the Chief Justice ruled in his dissent.
The Florida legislature has established rules for the conduct of an election.
Right,
it's
and they're
called
not being
an election, and then a report by each county to the Secretary of State, and then a certification by that Secretary of State. The Secretary of State has certified. The question is whether her certification is valid or invalid, and that is the issue that we are being debating right now in all.
I want to give you all a chance to give me a closing thought. Professor Rothstein, how does this all end up and when? And I want you all to just give me like a 15-second soundbite here.
Well, what I was going to say is that if the Florida legislature says you should determine the intention of the voter, it is not judicial legislation to figure out standards for determining that. It's just filling in what the legislature wants.
That's not what Chief Justice Wells ruled in his dissent, Professor Rothstein.
Laura, how are you seeing this being reconciled?
The Supreme Court, I think, is going to have to step in. I'll bet Professor Rothstein a dinner that he's wrong on this. The Supreme Court will step in. It'll slam down hard the Florida Supreme Court on this.
They might. I'm not saying they won't.
All right,
they might.
Stan?
Yeah.
All right, Laura, the Supreme Court may very well step in, but if they do, they have to look at themselves in the mirror. This is the Supreme Court that has said constantly, we will not interfere with state action and state decisions.
No, but they protect federal rights,
particularly when state courts are interpreting state law, and that's exactly what they've done here.
John Carbone?
When the Supreme Court steps in, even Justice Thomas, who was silent in the last
You
hearing,
are saying when.
When they step in, even Justice Thomas, who was silent the last time, will speak loudly about what the Florida Supreme Court has done. Look, the only person who hasn't popped up here yet is Bill Murray from Groundhog Day. It just keeps going over and over. And next, John Belushi from 1941 lives and over till it's over. I mean, the comeback kid thinks he's got it, but ultimately it's going to end up probably in the Supreme Court and maybe in the House. In either case, Gore doesn't win.
I'm not saying they won't.
Al Gore might have 9 lives, but he doesn't have 10. Paul?
I'm not saying they won't step in the Supreme Court.
You said that earlier, Professor.
No,
I
didn't. They won't reverse. They may not reverse it on that ground.
He's welching on the bet, Laura. Welching on that bet.
No, you're
Love
misinterpreting.
the passion of my legal Eagles tonight.
You're over-interpreting now.
Oh, well.
That's not me. That was Lori who was making that accusation of.
Okay.
Thank you all for joining us tonight. That was a very, very good team, and I think you gave us a much better understanding of what we might be facing in the hours to come. Appreciate you all being with us. We're going to take a short break and continue on the other side of the break. Will a constitutional chaos, or will it be created by the decision today? We'll be back.
Opinions. I have them, you have them. In fact, on any given subject, there are as many opinions as seats in this theater. And that's good, people speaking out, sharing ideas. But opinions are not the same as facts, and you should know the difference. And that's why at the Fox News Channel, we label all opinions right on your TV screen. And that should help you form your own opinion, so you can decide what's right and what's wrong.
Hey, kid, come on over here. I want to show you something. I want you to listen to me now, okay? Because you got to get this ready, or else you're never going to make it. Now, if it goes over too much way this here, it's no good. If it falls over this way too much, it falls all over you. You got to make sure you got balance.
Balance?
All right.
Fox News Channel, powerful all day. John Scott, Bridget Quinn, David Asman, bringing the world to you, making the issues clearer. Powerful hour to hour. Linda Vester, Shepard Smith, Neil Cavuto. Breaking stories, aggressive coverage. Powerful all day, fair and balanced. Fox News Channel, the most powerful name in news. We report, you decide.
You know, some mornings this is just too much. Especially when it's cold and nasty outside. But you're my pal. You're always there for me, unlike some people. And I'm not gonna let you down. Come on, man, let's go outside. So, Cosmo, got any big plans for today? There you go.
What, you got the tickets? You bet I'm there. I'll pick you up. Oh, wait a second. You know, I can't make it. No, I can't. Yeah, it's pretty important. I gotta go. Okay, I'll talk to you later. There's Daddy's little girl.
Channel B. Channel B.
Check it out now. Channel B. 24時間 100% music. US, UK のトップヒット on air. Concert, music news, スター独占インタビュー and more. International music scene をそのまま catch.
What does the V stand for?
It's all about music. Channel B.
Governor Bush is in fine spirits and quite prepared to see this through to its ultimate conclusion, because he feels very confidently that he has won this election and won it more than one time. As a matter of fact, right here in Florida, over a count, a recount, a manual recount, and perhaps another recount.
And welcome back. That was former Secretary of State James Baker from earlier today. So will Congress be asked to decide who the next president will be? Joining me now from California is Representative David Dreyer, and here in New York with me, Representative Anthony Weiner. Good to see the two of you.
Great to be back.
All right, Congressman Dreyer, what are the chances that this is going to end up in the hands of Congress and it, in fact, will be you guys that decide who our next president will be?
Well, let me say that I certainly hope that it doesn't, but I will tell you, Paula, that the decision that was made today will probably go down as one of the poorest, worst decisions from a court in our nation's history. And
That's not the way my legal panel saw it, and at least 3 out of the 4 of them didn't see it that way.
Well, I listened to some of your legal eagles over the last few minutes, and that's my interpretation of it. I mean, I believe that this really was ill-conceived, and that's not from the perspective of a Republican. If you look at the decisions that have been made, those 4 Supreme Court justices in California, excuse me, in Florida, I'm back in California now, who offered that majority opinion, are out of the mainstream of the Democrats in the state. I mean, remember, Chief Justice Wells is the Democrat who used that expression, you know, you get my drift, when he was talking about what I think was a wrong decision when they moved to November 26th, that deadline. Incidentally, this opinion actually overturns that decision that was made when it calls for Dade, Miami, and other counties to proceed with their count. Let me just say this also. Quickly. If you look at Nikki Clark, if you look at Terry Lewis, and even Sanders Sauls, all Democrats. So what I'm saying, Paula, is that these 4 Democrats who offer the majority opinion are out of the mainstream, and they are hard left, and I think it was a very, very sad decision. And I think that, as has been pointed out, Justice Wells' statements are very, very clear.
Congressman Weiner, Congressman Dreyer just went further than Governor Raska would at the top of the show, and he wouldn't even say to what extent he thought politics affected the decision. But didn't it play a role? Well, you know, I mean, you got 7 judges there, all appointed by Democratic governors, 1 a declared independent. You can understand why the Republican would scratch their head and go, ooh, what's going on down there?
I have to tell you, Chairman Dreyer is a good man, and Secretary Baker is as well, but there has been an enormous bashing going on from the Bush side of it. They love the courts when things go their way. They hate them and call them political when things don't.
It is an activist court, is
you know,
it not?
frankly, I have to tell you something. The Florida legislature wrote a law that said, here's how we're going to do things if we have close elections. And they left it to the courts an enormous amount to interpret the intent of the voters, to do anything necessary to make sure that the will of the people is done. And now the courts are in there cleaning up this mess, and I think doing it as efficiently as they can. You know, Chairman Dreyer is right about one thing. They went further than some of the Gore folks did, but I think they made a right decision to say, let's count the undercount from all around the state. Even in the strong Bush areas. That wasn't something that helped the Gore campaign, and it was something that Mr. Dreyer and his colleagues have been yelling about for months. Well, now they're going to do it. We're going to get a complete count, or at least as close as we can to a complete count. And the one thing that can muddy the waters irreparably is the Florida legislature saying, well, we wrote the law, we told you to interpret the law, but we don't like how you're doing it, so we're going to step in and change the will of the people. That would send it to Congress, and I got to tell you, we're going to side with the people.
But it is their constitutional right to come up with a Bush slate of electors. We'll debate that on the other side of the break, gentlemen. If you would, please stand by. Do not go away, all of you out there.
Mother Nature takes her toll, raging against the elements. Fox News Channel is there, bringing you the updates. From the eye of the storms to the aftermath of destruction, make Fox News Channel your only source for complete and up-to-the-minute reports.
You Decide 2000, exclusively on the Fox News Channel. Powerful coverage from America's election headquarters. John Scott, Bridget Quinn, David Asman, Linda Vester, Shepard Smith, Neil Cavuto. Fair and balanced reporting from America's election team, giving you the power to decide. You Decide 2000, from the most powerful name in news, Fox News Channel. We report, you decide.
Channel V.
Channel V.
Channel V. Channel V.
Check it out now. Channel V. 24時間 100% ミュージック US、UK のトップヒット on air Concert, music news, スター独占インタビュー and more International music scene をそのまま catch
What does the V stand for?
Channel V
Fox presents 科学分析クローバー危険人物関与目撃証言消去
だが真実はそこにある X ファイル on Fox
さあスカリー行くぞ
2人の FBI 捜査官が挑む世界の裏側の巨大な謎
I think that we've succeeded in doing that first and foremost. It's become a lot of other things, but I think it is a scary show.
X ファイル全米のメジャーなテレビショーを連続受賞
The X-Files has really caught on because I think people around the world have to be scared.
X ファイルその魅力は今も世界中にファンを生み出し続ける
X ファイルよくできてますよねもっと続けて来週はどんな話なんだろう見ればハマる
テレビ史上
真実が知りたい
かつてない
答えを見つけて
進化し続ける最高傑作真実はそこにある目撃者はあなた X ファイル毎週月曜夜10時 Only on Fox
And we're back with Congressman Weiner and Dreyer. Good to have you sit through that commercial break with us. Okay, Congressman Dreyer, you never really answered my question. I know you said you weren't crazy about the idea of Congress deciding who our next president will be.
That's the answer I give you, Paula.
But I know, but what do you think the chances are, realistically, of that happening? I know you don't want it to happen.
Yeah. Well, I mean, I don't want the Florida state legislature to have to send electors up. I don't want these things to take place, but I will tell you there is a chance, and we will be prepared if we have to face it. I will say that I'm arguing that this is not, in fact, been politicization except for a small group of people. My point again, Paula, is that the mainstream Democrats, led by Justice Wells, who clearly is a Democrat, and Judges Nikki Clark and Terry Lewis and Sanders Souls, these are Democrats who I believe have really offered a responsible decision, understanding the importance of the 1887 law about changing the rules after the election.
Yeah, but you just like their decisions. You just like their rulings, don't you?
Excuse me?
You just like their rulings.
No, I think that their rulings are appropriate. These are Democrats, is my point. And that's why I'm saying this is not a Republican-Democrat issue, except for a few in the very liberal wing. I hope it doesn't get to the Congress, Paula, but if it does, we will be prepared to deal with it.
Well, tell me what happens once it gets to Congress.
Well, I'll tell you, and I think
and quickly, though, you got to go through this theory.
This is going to be the rubber hits the road question for the Republicans in Congress. If the courts say count, they count, Gore takes the lead, is certified the winner, Gore electors are sent. The Florida legislature said, to heck with you guys, we're sending Bush legislators. The folks in Congress, myself, Mr. Dreyer, are going to have to say, are we going to take the people sent by the electors sent by the people or the ones sent by the legislature?
Okay.
And it's going to be easy for the Democrats. We're going to say support the people, support Vice President Gore.
Yeah, well, you don't have the numbers in the House.
Well, frankly, I believe we're going to have more than a handful of Republicans saying, wait a minute, let's go with the will of the people, even if it is a Democrat.
And that's exactly what we're going to go for.
Name one. Can you name one?
We've had the recount. We've had an additional
Can I name one Republican?
Name one.
I think Mr. Dreyer is one of the most respected Republicans in the House, will support the people, not the Florida legislature.
Is that what you do, Mr. Dreyer?
Of course, I'm going to support the people, and I will tell you that we'll face that decision. I hope we don't have to, but we'll be ready when we do, if we do.
What about Congressman Trafficant?
It's one Republican we got.
Congressman Trafficant? He'll vote with the Republicans, won't he?
He has up to now.
Okay, but what would really happen if you get into this situation where you got this? So the Senate picks the vice president, right? In that scenario?
Yes. Well, yes, and in fact, what you'd have is any member of the House, any member of the Senate can contest the seating of electors in this type of case. Then we go into a joint session of Congress, and we essentially have to decide which panel to sit. And in these types of contests are very rare. It's only happened, I think, once in 1969 when there was an unfaithful elector. And, you know, it got done in an orderly fashion, but the presidency
They voted for Bear Bryant back then.
All right, Congressman Dreyer, you get the last word tonight. Your wish list in about 10 seconds of what you think might happen. And will it happen by December 12th?
I'm looking forward to seeing the Supreme Court step in and obviously make the right decision, upholding Article 2, Section 1 and the 1887 law that says you don't change the rules after the game has been played.
Congressman Dreyer shaking his head no, but you'll have to come back and tell us why you're shaking your head now. Gentlemen, thank you very much for joining us at the end of a very, my pleasure, very busy week. And we appreciate you're all watching us tonight. Please stay tuned to the Fox News Channel all weekend long. We'll have the very latest for you. I'll see you back here Monday night.
Inside the Leon County Public Library, and when Steve and we here on Fox News Channel first reported that the U.S. Supreme Court had issued this stay, I told Dave, and he ran inside, said that he was going to make a phone call, and said that it should have stopped in the matter of minutes after getting word about that U.S. Supreme Court ruling. Again, the judges inside were making about 1,000 ballots per hour. They were making it through the 9,000 contested ballots, the undervotes from Miami-Dade County. They expected to have been finished by about 9 tonight. Again, they are just getting word now, and he said he was going to get some clarification, and then they were indeed going to stop, if that's the case, and stop completely and figure out where to go from here. But we were the ones that told the clerk of courts about the ruling, and he left our side and ran inside to tell them.
Fred, we're looking at some live pictures just to tell our viewers of what is actually going inside. This is the public library, I understand, in Leon County, in Tallahassee, where they were at least counting those Miami-Dade County undervotes, so-called undervotes from the Gore camp. What are they hearing specifically inside now that you've relayed that information? After that information was passed on, did they stop counting? Were they still counting? I saw some people on the cell phone, so they're probably still getting the information passed on to them.
Right, it's going to take a few minutes to filter out exactly what this stay means, but if you look at that live picture, and that's the library right behind me here, Dave Lang, the circuit clerk of courts, ran inside to tell them of the information that we just learned of, and they were going to sift through this and then indeed stop the counting. So those 8 judges that were going through all of those ballots, as you look live now, may be stopping and stepping up from the tables. They're still looking at ballots, I'm understanding, in that live look. So they haven't been told exactly from the U.S. Supreme Court stay. So I guess they're going to continue to look at ballots until they get the official word. We passed on what word we knew.
Give us a sense of the mood, too, there. What was the reaction from David Lang and some of the others that you've spoken with? Shock?
Surprise, definitely surprise, shock. What he said was, oh boy. And then he popped from my side and ran inside behind us to pass on that word. So definitely he was surprised, and whether this is a surprise for both sides, Republicans had thought that this was indeed what was going to happen because they didn't think that this process was fair at all, and that this left a subjectivity to the judges who were looking at all of these ballots, determining the voters' intent on all of those undercounted ballots from Miami-Dade. And of course, we have to point out that all of the counties, the canvassing boards around the state, will now have to stop as well as this word filters through to all of them. It just may be interesting to see how long it takes to actually get all of these places to stop counting.
All right, Brett Baier, thank you very much. We're going to check in with you in a little bit. And now we're going to go to Duval County, where we understand that the vote counters are just getting the information. They are talking about it. Let's listen in.
So stop, Do you want to copy your argument? We'll try to get it for you. We'll try to get copies for both sides.
You're arguably not counting right now. Any reason why you can go through with the short?
Yeah, there's no reason to if there's a stay from the Supreme Court.
Has the county received the stay or a copy of it or anything?
No, that's what I just said. We're going to get a copy of the stay. We're in the process of doing that right now.
How are you doing that?
Got an idea. Yeah. We're in the process of getting it right now. And as soon as we have an opportunity to review it, we'll be back out. It shouldn't take long. We'll be back out and let you know how we feel we need to proceed.
Judge, how did you find out about this? Through the TV? Or did somebody call you?
Actually, my lovely wife called me on the phone. Yeah, and for which she deserves a great amount of thanks.
Your Honor, one last question. Do you expect that we should be hearing something from Judge Lewis, the judge who has supervision?
I know who he is. I have no idea what Judge Lewis is doing, and at this point,
All I'm going to do is look at the stay.
Okay, Judge Short.
So do we.
That's good.
Thank you.
Thank you, Judge.
Well, you just heard some live reaction there going on from Duval County, Florida, where the judge was saying there's still a lot of confusion, still trying to discern and get some more details. But a stunning decision now coming down from the high court in the land, the U.S. Supreme Court, by a 5-4 decision, issuing an emergency stay, which was requested by the Bush camp last night. Some people thought it was a long shot. We've been talking to a lot of legal experts all day, but they did indeed get that emergency stay granted. And we understand that oral arguments will take place on Monday. There will be an hour and a half of oral arguments, so we will be back to the highest court of this land. And at that point, they will talk about this first issue of the emergency stay, and then probably at that point also look at, indeed, the merits of this case. And of course, we were at that high court not only just a few days ago. It seemed a big chaotic scene there. Obviously, all the world was glued to that. And again, that high court there, just a few steps away from Capitol Hill, will be the focus of attention again on Monday with oral arguments set to begin. But a stunning decision coming down. Justice Anthony Kennedy could have made the decision on his own because that request was given to him because he oversees that particular circuit as the 11th Circuit Court of Appeals. He basically could have made the decision, but instead, as many people suspected he would do, he passed it on to the full court. And in a 5-4 decision just coming down minutes ago, first reported by Fox News, indeed, that the U.S. Supreme Court has decided to stop the recount. So another stunning twist to this presidential saga. So now let's go to Steve Centanni, who is at the U.S. Supreme Court, for some more reactions, some more details on that statement, that strong decision coming down from the U.S. Supreme Court. Steve?
Yeah, we don't know why most of the justices ruled the way they did, because there's no language here, there's no opinion from most of them. But there is one from Justice Scalia concurring with the majority here. There have to be 5 votes, as you know, for there to be an emergency stay granted and to stop the vote recount in Florida, which is what they've done. And one of those 5 we know is Justice Scalia. And he's the only one who put forth some language as to his reasoning, why he thinks there should be an emergency stay. He says the petitioner has a substantial probability of success, and that's one of the criteria that's used in deciding whether to grant a stay. On the question of irreparable harm, however, he says a few words are appropriate. The issue is not, he says, as the dissent puts it, whether counting every legally cast vote constitutes irreparable harm. One of the principal issues in the appeal we have accepted is precisely whether the votes that have been ordered to be counted are, under a reasonable interpretation of Florida law, legally cast votes. The counting of votes that are questionable, of questionable legality, says Justice Scalia, does, in my view, threaten irreparable harm to petitioner, that's George W. Bush, and to the country by casting a cloud upon what he claims to be the legitimacy of his election. Count first and rule upon legality afterwards is not a recipe for producing election results that have the public acceptance of democratic stability provides. Another issue in the case, moreover, is the propriety, he says, indeed the constitutionality of letting the standard for determination of voters' intent, dimpled chads, hanging chads, etc., vary from county to county. As you have heard, of course, Justice Lewis, in his decision just last night, let every county decide what standard they're going to use in counting this, and Justice Scalia says that is unfair. Now,
Steve,
4 of the 4 dissenters...
Steve, I want to quickly interrupt you. I'm so sorry, because our viewers are looking at another split screen right now, and on the other side of the screen from me and on the other side of the screen from you, as you were just talking, Steve, there is a live picture right now, and this is coming from Tallahassee, Florida, and this is where they were counting since early this morning the votes from Miami-Dade County, some 9,000 undervotes, and it looks like they have just gotten word, because we were watching a few minutes ago, right when the decision came down from the high court, and they were still counting the ballots, still looking to see if the dimples were there or the voters' intent. But now it looks like they have indeed gotten word. It looks like they have stopped the counting, and we just saw a lot of people on cell phones, so it looks like there's some reaction, some people shaking hands, probably some Bush supporters, some Republicans who are probably pleased with this decision, and a lot of people still trying to shake their heads and determine what exactly does this mean. But obviously it means, as we're seeing from a number of these canvassing boards now across the state of Florida, that it means they have to obviously immediately stop these recounts, especially these undercounts, these undervotes that we've been talking about, some 40,000 across the state of Florida, as they try to figure all this out, and as this case is now going before the highest court of the land on Monday. And now we're going to go to Jim Angle, who's there in Florida. You've been covering this from the very, very beginning. Jim, what is the reaction from down there, and what does all this mean in terms of a timetable now?
Well, as you said, they have just stopped counting here. They were waiting for a call to Judge Reynolds, who is the chief of the circuit courts here, an official call to him saying that the Supreme Court had indeed ordered the recount to stop. He has apparently gotten that call because, as you just saw, they have stopped the counting here. Now, presumably, the calls also have gone to Judge Lewis and out to the canvassing boards. We'll see when they stop, when they get the word, but obviously the recount is in the process of grinding to a halt. Obviously, that throws everything back into limbo. Not that we haven't been in limbo for most of this process over the last month, but once again, we are in legal limbo here as the recount has been suspended, awaiting arguments before the Supreme Court on Monday. Now, as you heard Steve say, one of the key questions here are standards. This was something that came up in the hearing before Judge Lewis after he took over for Judge Sauls, who had recused himself. There was a long discussion about standards. Phil Beck, the Republican lawyer, urged the judge to describe a specific standard. The standard, of course, from the legislature is to determine the clear intent of the vote with, quote unquote, a reasonable certainty. Now, obviously, that sounds like a clear standard. The problem is it is a very subjective judgment about what a voter intended to do. In that courtroom, the Republicans urged the judge to come up with a more specific standard than that, to give some guidance to all of these canvassing boards that would be counting votes. The judge said, look, the Supreme Court of Florida has twice been asked, twice been given the opportunity to set out a more specific standard. Both times, they have declined to do so. And he suggested that he was not going to come in and second-guess the Supreme Court. He wasn't going to go any farther than the highest court in the state in setting a more specific standard. That is what the Republicans are now complaining about, that you have all of these canvassing boards who may be using entirely different standards. And, of course, the argument up until now, Rita, as you know, has been between what one might call the Palm Beach standard and the Broward County standard. If you have a ballot and all of the chads are punched out except for the presidential race, in Palm Beach County, they would look at that and say, look, this person was able to punch out all the chads. The ballot was clearly properly placed in the machine. People knew they had to punch out chads. They were capable of punching out chads. So if they didn't punch out one for the president, that means they didn't intend to vote for president. In Broward County, they would look at the same ballot and say, hey, they punched out chads for all Democratic candidates, so if there's a stray markup by the presidential race, that they must have intended to vote for the Democratic candidate for president. They are presumed to have intended to vote for the president. So two entirely different standards in two counties. That is what the Republicans are complaining about. The Democrats have said, look, this is up to the canvassing boards. They take the Supreme Court, the Florida legislative standard, which is clear intent of the voter, and they apply it to the ballots, and the Democrats were fine with that. The Republicans were not. The Supreme Court seems to have weighed in and said that is one of the things we need to take a look at on Monday. Rita?
And Jim, what about some of the issues raised by the Chief Justice there in the Florida State Supreme Court? So it was really a stinging rebuke that was sent in the dissent portion. This is Judge Charles Wells, who was saying that he believes it could possibly lead to a constitutional crisis if these counts went on, and also said there may be no legal basis. Do you think that that may have had an impact on the High Court?
Well, sir, he more or less predicted that this would invite immediate examination of some constitutional issues, and clearly the U.S. Supreme Court has agreed with him that there are constitutional issues involved here. The Bush campaign had argued early on that this violated, among other things, the equal protection of the Constitution, that some people's votes would be counted in one way, others in another way. Not only that, but Phil Beck, the Republican lawyer, argued in the hearing last night that, look, what you have in Miami-Dade is a situation in which the first 20% of the votes had been recounted, of those undervotes. Now, when you go to count the rest of them, he said, you are now moving from what were essentially Democratic precincts to Republican precincts. It would not be fair or legal, he suggested, to use a different standard when you count the other 80% than you did the first 20%. Moreover, he argued, since you are now moving into many precincts in which you have a large number of Hispanic Americans, to use a different standard could very well, he argued to the court, violate the Voting Rights Act, which is one of the centerpieces of civil rights legislation in this country. So they were raising all sorts of legal questions. Those questions apparently will now be decided by the highest court in the land.
All right,
Rita?
Jim Engel, thank you very much for keeping us posted. And now some new information coming from our producer, Brian Sierra, and also Steve Centanni are both there at the Supreme Court, basically saying that those briefs are due at 4 p.m. on Sunday. This is for the Supreme Court. Again, oral arguments taking place at 11 a.m. on Monday, an hour and a half worth of oral arguments at the highest court in the land. And the dissenters, remember, it was a 5-4 decision. They included Justices Scalia, Justice Stevens, Souter, Ginsburg, and Baier issued a dissent. Those are among the most liberal justices on the high court, so no surprise that they would be issuing a dissent. But again, 5 justices were only needed to have a stay granted, and a stay has indeed been granted. And now we're going to go to another one of the counties where the vote taking was supposed to be taking place, and that is Pinellas County, where William Lajeunesse is standing by. William, I want to ask, first of all, have they gotten word? What was the reaction, and how long has it been?
Well, Rita, about 15 minutes ago, the canvassing board here in Pinellas County in basically St. Petersburg, Tampa area halted counting their ballots. They'd been through about 200 ballots so far. I think 2 votes for Governor Bush and 1 for the vice president. And abruptly they stopped. And I think I'm joined now by Bob Stewart. You also represent Pinellas County. You're on the canvassing board. And what literally happened and why did you stop?
Well, we happened to have the TV on in the background without sound, and all of a sudden we're in the process of counting the 224th ballot, and we hear this sort of applause and moan going on in the audience. Turn to the television set and read the scroll that says the Supreme Court has ordered a stop recount. We immediately recessed, and we've stopped counting.
How do you feel about that? I mean, on one hand, you're going through these ballots and you've got 3 more people now are valid votes. On the other hand, it's very chaotic and you realize that.
We were geared up and ready to go. I mean, we were looking at an all-nighter here, I'm sure, because we had about 4,200 votes to count. We were only 224 there. So in that sense, there's a little disappointment in that we set the process in place, we identified the standards, and we'd started the mission. But on the other hand, the Supreme Court said stop, and that's what we've done.
The arbitrariness of the different counties around Florida, really coming up with different standards to measure voter intent. You were fairly restrictive here, and that really concerned you, didn't it?
Well, it did, and that was the most important part of our assignment, quite frankly, was to determine whether this ballot counted or this one didn't, and why. And I think that our canvassing board, we had reached a standard that we were going to measure those ballots against. And as you can tell, with 224 ballots, we've only came up with 3 that we were going to count that were originally no counts.
When it actually came time to come up with a standard, however, there was some discussion because the presiding judge here said, hey, I think I'd like to go with a very liberal, vague, rather, what the Supreme Court gave us. And you said, no, I'm not going to go forward because I think we need a standard in place before we start counting.
Absolutely. Otherwise, it was there would have been pell-mell, and there would have been no basis for substantiating a yes or a no vote on a given situation. So I think we went on the conservative side of it. I felt very comfortable doing that, and obviously the majority of the board felt that way.
And how do you feel one way or another whether or not Florida goes ahead with the electors it has, the legislature, or unless the Supreme Court, the temporary injunction goes away and you continue counting again? How do you feel about it?
Well, my personal feeling is that I hope that our legislature can stay out of this, that it doesn't have to get involved and bring Governor Jeb Bush into this process. If we're told to recount, we'll be back here doing it as soon as we get the go. Otherwise, it's over with.
Good. Thanks very much, Bob. I appreciate it very much. Well, Rita, that's it from here. Obviously, they're officially awaiting the word, but obviously they have stopped counting ballots for the time being, and probably at least until Monday, and that's it. A lot of people are here, though. They geared up. There was a lot of discussion. There was about 100 ballots counted before there was actual disagreement about whether a ballot should be admitted or not. It's very hard to say, but I think people will probably be breaking up here after commiserating for probably another hour. Rita?
Now, I know you just talked with a vote counter there. Have you gotten any reaction from any of the partisans, any of the Democrats, any of the Republicans?
You know, we attempted to try to talk to them, but they're trying to let their spokespeople in Tallahassee handle that. So we'll be working on that as we just got the word down really a few minutes ago as well. And we've been working to get things ready for the shot.
Indeed. Breaking news. William Lajeunesse, thank you very much for that update. And now let's, of course, go to the place where all the action is happening right now. The U.S. Supreme Court, which just handed down that shocking, very stunning decision, and very good news for the Bush camp. Steve Centanni, what do you have for us?
Rita, just a 4-page ruling that came out a little while ago, a major victory for George W. Bush in his appeal to the U.S. Supreme Court. A setback again for Al Gore, who was fighting this appeal and saying no stay needed to be granted. The High Court, of course, granting an emergency stay, stopping the recounting of votes in Florida. It is a 5-4 ruling with Justices Rehnquist, O'Connor, Scalia, Kennedy, and Clarence Thomas finding that there ought to be an emergency stay granted. Justices Stevens and Souter, Ginsburg, and Baier dissenting, and we have some language from both sides. Justice Scalia, in concurring with Justice Kennedy, is saying that the petitioner has a substantial probability of success when the case is argued on its merits, and that, I should add, remind you, is going to be on Monday, December 11th at 11 a.m., an hour and a half of arguments, 45 minutes from each side, just like we had a week ago Friday on the original Supreme Court case. Now, in his language supporting this ruling, he went for the stay, Justice Scalia saying the counting of votes that are of questionable legality does, in my view, threaten irreparable harm to the petitioner, George W. Bush, and to the country by casting a cloud upon what he claims to be the legitimacy of his election. But oddly enough, very similar language is used in the dissent, which is authored by Justice John Paul Stevens. He says preventing the recount from being completed, which is what's happening now, will inevitably cast a cloud on the legitimacy of the election. So both sides claiming that the legitimacy of this process is being jeopardized here, and it'll just have to be ironed out when they sit down and hear the arguments on Monday morning and then hand down their ruling probably sometime shortly thereafter. But going back to Justice Scalia, he says in supporting this grant of an emergency stay that another issue in the case, he says, is the propriety, the constitutionality of letting the standard for determination of the voter's intent vary from county to county, which is what you heard Judge Lewis order last night, that every county was going to be able to decide whether or not to count a dippled Chad or a hanging Chad or any other kind of hard-to-read ballot. He says it'll vary from county to county, and that may be of questionable constitutionality. He says if petitioner is correct that counting in this fashion is unlawful, and the petitioner, I should remind you, is George W. Bush, if it is unlawful, permitting the count to proceed on that erroneous basis will prevent an accurate recount from being conducted on a proper basis later, since it's generally agreed that each manual recount produces a degradation of the ballots. Every time it's handled, more of those chads fall off. It becomes harder and harder to count, which renders a subsequent recount inaccurate. So he says we ought to stop, leave those ballots alone, and figure all this out before we go forward with any further hand recounts, because he says that could jeopardize the whole process. Now, in their dissent, there's some interesting language in there as well. Time does not permit a full discussion of the merits, say Justices Stevens, Ginsburg, Baier, and Souter in their dissent. These are the four who thought the hand recount ought to continue right on through the weekend until it's done. They say it is clear, however, that a stay should not be granted, which it has now been granted, unless an applicant makes a substantial showing of a likelihood of irreparable harm. And George W. Bush did claim that there was a likelihood of irreparable harm. They don't buy that argument. In this case, they say, the dissenters say, applicants have failed to carry that heavy burden. Counting every legally cast vote cannot constitute irreparable harm. How can you harm somebody by simply counting votes, they're saying. On the other hand, there is a danger that a stay, stopping the count, may cause irreparable harm to the respondents, the respondent in this case being Al Gore, because of the risk that the entry of the stay would be tantamount to a decision on the merits in favor. In other words, it would harm Al Gore. So you have a clearly divided court, just like we did last time they heard the arguments. They were deeply divided as well, but then finally came out with a decision just to send the whole thing back to the Florida Supreme Court to answer some unanswered questions, which they have yet to do, I might remind you.
All right.
So we will be hearing this on Monday morning. Rita?
We definitely will. And Steve, we want to explain to our viewers that picture that you're seeing now, that is a lot of people cheering. I believe that's outside the courthouse. Yes, indeed it is. In Tallahassee, Florida, where people are cheering outside the courthouse, obviously. Bush supporters who are very pleased with this decision coming down, which we just heard more details about from Steve Centanni, in which the highest court in the land, the U.S. Supreme Court has now just issued that decision just a short bit ago, as first reported here by Fox News, in a 5-4 decision, a dissenting opinion, obviously a divided court, many of the liberals in the court against this, but a 5-4 decision basically granting that emergency stay to stop the recounts immediately. And we can hear some, lot of natural sound, a lot of cheering. Let's listen in a little bit on that. Okay, we've lost a little bit of sound there, but a little bit ago we were hearing them cheering. There it is. You can hear a little bit of gnat sound in the background. Now we're looking at some pictures from reporters. And now we want to go to our reporters who have been covering both the Bush and the Gore camps. Let's first go to James Rosen, who's in Washington, to see if we can get some reaction. Obviously, some very disappointed people indeed with the Gore camp. I would assume the vice president and his camp are very disappointed and probably surprised by this decision as well.
Well, Rita, the Gore campaign is telling our Fox News troops on the ground in Tallahassee that it will not have an immediate reaction to the stunning reversal it was just handed by the United States Supreme Court. However, it says that the campaign will give us a heads up as soon as they know that they're going to release some kind of official statement. Of course, it does not take any leap of the imagination to imagine that the Gore campaign is disappointed here. Right now, they've got two fundamental decisions to make, the Gore campaign here. Number one, what to say, and number two, who should say it. Should it be William Daley? Should Vice President Gore himself come out and make some kind of statement? We'll get the answers to those questions soon. I do imagine, however, Rita, that in framing their response, they will probably be very reliant on the exact language used by the 4 dissenting justices in this opinion, who said that the decision to suspend the hand recounts departs from all traditions of law, essentially is what was said in the dissenting opinion. It's very bad news, not only that this happened for the Gore campaign, but the fact not only that they are going to hear Governor Bush on Monday and his appeal and hear oral arguments on it, but the fact that they said that the hand recounts should not continue even while that's going on. That's very bad news for the Gore campaign, because it suggests that ultimately this High Court of the United States is going to rule that the whole process of the hand recounts was for naught from the beginning, and therefore that Governor Bush should be certified the winner in Florida. That is the suggestion, probably, of this stopping of the hand recounts the way it did. Rita?
James, let's also talk about the clock running out, because not only does it sort of take the wind out of their sails, but basically they've got a timetable now. I mean, there was a rush by this circuit court judge, by Terry Lewis, who had told all the counties, look, you have to hurry up and get this done. He set the deadline for 2 p.m. tomorrow. Now it has totally changed. The whole ballgame has changed by this emergency stay issued now by the U.S. court. And now, does this basically change? Are they now even capable, should even this not go through, and say the court decides ultimately, no, we will, now we will hear the case, but say they do rule against Bush inevitably, do they still have this timetable? Can the Gore camp beat this timetable with the clock running out?
Possibly, Rita. The only timetable that really matters here are two. January 5th is when Congress counts the official electoral votes. On January 5th, that is when Congress is going to count all the electoral votes from all 50 states. Florida does very badly want to be represented in that count on January 5th, so that's one hard deadline mandated by the federal Constitution. Another is that the president's and vice president's terms expire on January 20th. That's the real ultimate deadline here. However, none of this is good news for the Gore campaign. The only reason why the U.S. Supreme Court would stop the hand recounts while it's hearing the case is because it feels they are harmful to Governor Bush. And that's, in fact, what the 5 justices who signed off on this ruled, that this is harmful to Governor Bush. And so that is the worst news of it all here for the Gore campaign. It was one thing for the U.S. Supreme Court to say, fine, we will hear what Governor Bush has to say, and we'll hear arguments on this on Monday. It's quite another thing for them to stop the hand recounts, and that is suggestive of very bad news still to come from Vice President Gore.
All right. Thank you very much, James Rosen. One last thing I want to ask you. I know you were not clear on what kind of response we're going to get from the Gore camp. Is there any sense we may hear from the vice president himself?
The stakes are now so high with the U.S. Supreme Court ruling the way it has today that I think it's very likely we will hear from Vice President Gore and that he will not leave this to surrogates. Of course, however, that's speculation clearly labeled as such here.
Indeed. And as we know, James, he has been really laying low the last 4 days. We have not seen him, for 4 or 5 days. He has not made a public statement. Yesterday we heard from Bill Daley, again today from Bill Daley. So, but maybe on such a strong decision coming down now from the U.S. Supreme Court, we may indeed hear from him.
You got it, because he now, more than ever now, has to rally public support for keeping this dream alive. Now that the Supreme Court has ruled the way it has, and everyone's so very much cognizant of the deadlines you've been mentioning, now more than ever the Vice President may use his personal prestige to keep his troops rallied behind him. But we shall see shortly.
All right. Thank you very much, James. I have a copy of the decision that came down from the High Court. I just want to read a quote to our viewers. It says, quote, "It suffices to say that the issuance of the stay, the emergency stay to stop the recounts, suggests that a majority of the court, while not deciding the issues presented, believe that the petitioner has a substantial probability of success." So that is a very strong statement there, basically saying that there is a probability of success coming forward for Governor Bush, pointing out that he is ahead in the vote count right now, although it is a slim margin, just about 100.5 votes at this point with the new decision that came down just yesterday from the Circuit Court Judge Terry Lewis. And now, fair and balanced, we want to go to the Bush side. We want to go to Carl Cameron, who has been covering the Bush camp now for over a year. What is the reaction coming from them, Carl?
To my being covering them for over a year, probably tedium and tiresome.
Insanity. I bet they are absolutely thrilled with this decision, Carl.
Well, I don't think so, actually. I think that they would say they are best characterized as relieved, but not entirely surprised. And I think that it perhaps bears reminding that it has long been predicted by all sides, the Gore campaign, the Democratic National Committee, the Republican National Committee, and the Bush campaign, that ultimately this would end up in the U.S. Supreme Court and probably not even be resolved there. That it is entirely possible that the Florida legislature will have to take action in its emergency session scheduled for Monday, and that they will, in fact, approve a slate of electors for George W. Bush that ultimately could be resolved in the U.S. Congress. So with all of the various different courts of last resort in Florida exhausted, it was inevitable that this would be brought through the appellate process in the federal court system and land in the U.S. Supreme Court. There was some question really as to whether or not the U.S. Supreme Court might not take this, but it's worth noting that in the dissenters, among them Justice Stephen Baier of Massachusetts and Justice David Souter of New Hampshire. Justice Souter is a former New Hampshire Supreme Court justice and has a tremendous bias toward local courts. And there was a lot of argument on behalf of the justices in the oral arguments previously existing, wherein they were, and this was as expressed by Justice Ginsburg, that they have to hold the local courts in high regard and respect. Justice Baier is a bit of an administrator and a bureaucrat by his own admission and has always had a bias in favor of the deadlines and took issue and was concerned by the Florida Supreme Court's movement of the original deadline for Katherine Harris, the Secretary of State in Florida, from the certification deadline when she moved it, when the court in Florida moved it ahead. So these two dissenters, coming sort of from cross purposes here, but they are by many insiders of the court viewed as sort of swing votes in all of this, showing their inclination to support local courts, but recognizing that there remains a whole number of issues on both the law and the facts wherein the Florida court is in a bit of trouble. The Bush campaign recognized that this was always going to be in this way, and about 3 weeks ago, the governor basically told his legal team that they should be prepared to appeal this all the way to the U.S. Supreme Court without any compunction whatsoever. So what they had done in the early part of this week was essentially re-argue their case in the appellate court and re-argue their case in the U.S. Supreme Court, anticipating that ultimately they would suffer the setback that took place in the Florida Supreme Court the day before yesterday, or yesterday. So with that said, the governor also let it be known to his political lieutenants that he was prepared, if necessary, to fall back on the Republican majorities in both the Florida legislature and the U.S. Congress should his electors, the certified electors, be jeopardized by some Florida Supreme Court decision. There has been a lot of talk about whether or not there's been sort of inappropriate coordination between Republicans in Austin and Republicans in Florida's legislature. The fact of the matter is, these are political pros on both sides, and they don't have to actually communicate with one another directly as to what would be in their party's best interests, that being, of course, that George Bush be the president. And just as there isn't necessarily any direct orders between Gore and the various different civil litigants for the Democrats in Florida who were suing about Seminole County and Martin County, they don't have to give marching orders because everybody knows what's in the best interest of that party, have Al Gore be the president. So clearly there is relief that the U.S. Supreme Court has taken up this case. They believe that the decision in the Florida Supreme Court, as expressed in the dissent by the Chief Justice Wells, is essentially verbatim what Ted Olson will be arguing before the U.S. Supreme Court on Monday. That is that there is no basis in law on what the Florida legislature has done, and that there is no basis in fact, and that the overturning of Judge Saul's case, which was, of course, originally the devastating setback to the Gore candidacy, was ultimately a decisive, deliberative decision that is almost impossible for anybody going based upon the facts to overturn. With all that said, Rita, they recognize in Bush country that there is an argument in the simplest level for the Democrats to say, look, we had a close race, we ought to recount. And as James Rosen was talking about right now, the question becomes whether or not there's time with this recount stayed for that recount to actually be accomplished.
Indeed, the clock is running out. Carl Cameron, thank you very much for reaction from the Bush camp. And now let's go for a reaction from the Gore camp. Let's go back to Jim Angle in Tallahassee. What are you hearing there, Jim?
Well, Rita, the first thing we want to do is talk about the fact that we had seen people stop counting, but that was apparently in anticipation of the official word. And a few moments ago, the official word came from Terry Cass of the Tallahassee court system. Let's watch.
Okay, we've just received a call from Judge Terry Lewis. We have stayed the recount at this point until we hear from the U.S. Supreme Court based on that U.S. Supreme Court decision that was handed down today.
Well, there you go, Rita. This is like a football game in which one side throws a Hail Mary pass and gets a touchdown a minute before the end of the game, and the other team comes back and scores on the next set of downs. So a lot of excitement here from both sides. You heard the same kind of cheers when the Supreme Court ordered an immediate recount here in Florida. Now you hear the cheers on the other side as the U.S. Supreme Court orders the recount to stop. Now, the Democrats are saying that they are disappointed by that. That's no big surprise, obviously. They're saying that they thought they were making real progress, and they claim to have picked up 36 votes in either full or partial recounts in 9 counties. 9 counties, they claim to have picked up 36 votes. Now, this is obviously the Republicans had argued last night that no one should be releasing partial results from these things for obvious reasons, but the Democrats, for their own reasons, obviously are putting out the numbers saying, hey, we're gaining ground here. Now, the Democrats also say that they look forward to arguing before the Supreme Court, that they have confidence in their case because it is founded on the fundamental principle of one person, one vote. They're obviously going to go back and argue this vigorously in the Supreme Court, and as you heard Steve Centanni and others report, they will be preparing their briefs. These lawyers haven't gotten much sleep down here, Rita. They didn't sleep much last night. Looks like they're not going to sleep much tonight either, because they'll be working on new briefs for the U.S. Supreme Court. Other than that, things have stopped. Everything has ground to a halt. There is no more recounting. Now I suspect we'll spend the rest of the day listening to the two sides argue over what happened in the recount so far and whether or not it was fair to begin it to begin with.
All right, Jim Angle, thank you very much. And we're now going to go to a live picture from Pinellas County where they had started the recount just a short time ago, and now they have just gotten word they are looking at the court order. You can see right there that bald gentleman with the beard. He is the head of the canvassing board down there in Pinellas County. We were hearing him earlier trying to decide how to read the decision coming down from the Florida State Supreme Court, and now he's trying to read this court order coming down from the U.S. Supreme Court just a short time ago. But they have clearly stopped the counting there. We were watching them all morning. In fact, Fox News have been taking a lot of pictures of them live all morning there in Pinellas County, which is right near Clearwater, just to give you an idea geographically where it is. There were 4,226 undervotes believed to be there out of 407,000 ballots total in Pinellas County. And the Pinellas County Canvassing Board was actually doing the recounts, trying to determine exactly which
President Clinton is leaving office in just about 6 weeks. He has worked on this issue over the past 7 years, said that he was going to give it his all during his remaining days in office. He has developed definitely a strong relationship with both Mr. Barak and Palestinian leader Yasser Arafat. In fact, Mr. Clinton talked with Mr. Barak as early as just about a week ago, encouraging the Israelis to move forward with that fact-finding committee, which is basically looking at the causes of the violence. So again, right now, an open question at the White House, what these developments will mean for reducing the violence and getting the parties back to the peace table. Jim?
All right, Kelly Wallace reporting the latest reaction there from the White House. Now we are going to shift gears. We are going to tell you about another breaking story. This one coming from Pakistan. We're going to go to Islamabad and Hannah Bloch for the latest on a story there of the jailed Prime Minister Nawaz Sharif.
Thanks, Jim. The government of Pakistan has just issued a statement saying that the former Prime Minister Nawaz Sharif
High Court just last week, and we were there outside the courthouse. All the eyes of the world were on that U.S. Supreme Court, and a lot of people never thought that the case would come back again. But indeed, the U.S. Supreme Court is granting George W. Bush's wish. He is getting these recounts stopped immediately. And now we are going to go to Doug Kamek, who is a Bush attorney. Doug, you have to be very happy with this decision, and I want you to be honest with me. Were you surprised as well?
Yes, I was surprised. It's extraordinary when the Supreme Court of the United States grants a stay because the standard is so extremely high. You have to show irreparable harm, and you have to demonstrate the substantial probability of success on the merits. As the order indicates, the Supreme Court has found both of those things. I think that's very encouraging for Governor Bush. And while I'm surprised that the court took the action, I think it is legally correct.
What was the reaction from the Bush camp? Have you spoken to any of the folks within the inner circle or some of his closest advisors? I know you yourself have been advising the camp as well.
It has been too soon to be in touch with anyone other than to try and just grasp the significance of the court's opinion, and as a result, I haven't had that opportunity.
Is there anything you can read by the fact that they did already issue the stay? A lot of people thought maybe they would not grant the stay, but maybe they would still hear the merits of the case. Is there anything to discern by that? Is that obviously clearly a good sign for you that they decided to act so soon?
Well, it clearly is a good sign because we now have two good signs. That when the Supreme Court of the United States earlier this week vacated the first Florida Supreme Court opinion, they were very genteel. They were very temperate in their language. They said, please understand that this is an area that's governed by the United States Constitution, Article 2, Section 1, which requires you to pay special attention to the law given to you by the state legislature. I think this follow-on grant today indicates that the Florida Supreme Court in all likelihood failed the test. They were given a second chance, and as my kids would say it, they were given a do-over, but they messed it up again.
Well, now the U.S. Supreme Court, the first time they were given this issue, they decided not necessarily to hear or not hear the case. What they basically did was send it down to the Florida State Supreme Court and said they wanted a clarification. Now this time, they're actually stepping in, taking their own action and saying we are granting this stay to stop the recounts. Is there any sense that they decided to act much more actively this time because now the recounts were indeed underway? There was an action taking place.
Well, yes, because there was an irreparable harm that was starting to accrue by this constitutional violation to Governor Bush. He has been certified the winner in Florida by the fact that he won on election night and won on the recount, and he won on the recount of the recount. And that certification would lose its conclusive effect, its safe harbor, as everyone refers to it, under federal law, if, in fact, this dispute was not settled by Tuesday, December 12th. So the impetus to act this weekend and to have the hearing on Monday is to comply with the clear federal deadline, and if that compliance had not been met, Governor Bush would have been deprived of a benefit that he's entitled to by virtue of winning the count in Florida.
Now, the decision by the High Court was a 5-4, still a split decision. So you still have a bit of a hurdle to get over. You've got some tough justices. You've got David Souter, you've got John Paul Stevens, you've got Ruth Bader Ginsburg, and you've got Stephen Breyer. So this is not over yet. There's still a big challenge, don't you agree, for the Bush camp, for both sides, really?
It is a challenge for both sides, and both sides will be splendidly represented, I assume, by Larry Tribe, the professor from Harvard, as well as by Ted Olson and the representatives, as you mentioned, of the Attorney General's office, as well as the Secretary of State. Those arguments will be well presented, but even though the hurdles are high, what this stay means is they know a federal question has been clearly presented now. And that's what was giving a doubt or hesitancy to Justice Ginsburg. She wanted to wait until it was clear in the last argument that the state had really stepped over the line. And while she's in dissent on the stay, because she would have, I think, wanted to hear the merits before granting a stay, I would think we're going to pick up some ground with Justice Ginsburg, possibly Justice Stevens, because both of them indicated in the last oral argument how important having a national process of integrity is, and the Florida Supreme Court judgment yesterday had placed that in doubt.
Now, tomorrow the briefs are due at 4 p.m. Eastern time from both sides, also the oral arguments on Monday. Give us a sense of what the Bush camp will be presenting, both in written form and then in oral arguments.
Well, in written form and oral argument, I think you're going to see some similar arguments that you saw last time. They coincide around a provision of the Constitution, Article 2, Section 1, that says it's the state legislature that governs. And so one of the things that the briefs will clearly include is a demonstration of how the Florida Supreme Court changed the law, that they really didn't justify the extended deadline to November 26th that the Supreme Court of the United States had asked them to justify by vacating, that they had disavowed the clear discretion given to the canvassing board as to whether or not to undertake recounts, and they literally transferred that authority from the canvassing board to the circuit courts, a clear change in the structure of the law. That, as you've been discussing all morning, what's the standard to recount and who has the authority to set the standard? Well, the logical answer to that is the Florida legislature sets the standard, but the court, which in its first opinion, that is the state Supreme Court, said we'll leave it up to the legislature, yesterday came up with a rather amorphous standard at a level of very high generality, voter intent, which was being applied differently in different places. And that raises other constitutional questions. So you will clearly see arguments that are structured around the Equal Protection Clause, saying that if you live in different places in Florida, different standards were being applied to your ballot, and the Due Process Clause insofar as all of this is being done retroactively, changing the rules after the contest has been fought.
Now, today we were looking at live pictures up until when this decision came down from the High Court of all these canvassing boards looking up at the ballots, trying to discern the, quote, discernible, clear intent of the voter. And one person said, we're using the common sense standard. Do you think the arguments presented by the Bush camp, indeed, that there is this ambiguity, do you think it was just reinforced by some of the pictures that we saw this morning?
I think anyone who's ever seen people holding ballots up to the Tallahassee sky have to be convinced that there is no standard out there, and that raises really a serious question. I mean, we like to believe that we're superior to machines, but in this particular instance, after you've done 2 machine counts, those ballots aren't the same ballots any longer. They've been handled several times as the factual proof before Judge Sauls proves. It takes just a slight action of the hand to make an indentation or a dimpled chad, and that may not indicate anything other than that the ballot has been bent. I think that in and of itself, the pictures of people looking at those ballots suggests how we have to return to the count that we had on election night in accordance with the law that existed on election night.
And Doug, what do you think this decision coming down from the High Court, what do you think this does for the Gore camp legally and also politically?
Well, politically, I think they're pretty good at spinning, and I think they will be out there.
I think both camps are pretty good at that by now, don't you think?
Well, in fairness, you're probably right, but I think they will take this to say, well, we would have won this election but for the interference of the court. I hope people will keep in mind that the court has an obligation to defend the text of the Constitution and the federal interest here, and also keep in mind the pictures we were just talking about. I wasn't actually convinced that the court should grant the stay because I thought the Florida process was going to fall of its own weight, that we would watch it all weekend and these poor, tired, weary souls applying different standards in different places would be throwing up their hands all across the state of Florida, and that in itself would have been good enough proof that Al Gore just simply didn't get the votes on election night. But be it as they may, the Supreme Court of the United States thought the federal question so important that they couldn't wait. I think...
Douglas, I'm sorry to interrupt you. I just want to tell our viewers the picture we're looking at right now. This is former Secretary of Defense Dick Cheney, obviously Governor Bush's running mate, who is returning to his transition office there in McLean, Virginia, which they have set up in the picture a little bouncy. Let's go back, if we could, to Doug Kamek. The picture a little bouncy there from the cameraman, but we just got the arrival of Dick Cheney, who is heading back to the transition office, obviously getting this good news. And sorry to interrupt you. You could continue your thought.
Well, I'm sure he is delighted to get the good news, and I'm sure both campaigns will be putting the best face on this as they can, but both will also be concentrating now on the law. And one of the things that I think is useful with regard to the U.S. Supreme Court is that, yes, it's somewhat closely divided today, But what the people saw on Monday, in its opinion, and what they saw in the previous oral argument in the Supreme Court, was men and women of supreme intelligence who were asking legal questions, not political questions. They were not giving bumper stickers about all the votes should be counted or the machines have already given us the right result. They were asking, what does the Constitution require? What does the federal statute require? And I think that's where the briefs will be headed tomorrow. That's where the arguments will be concentrated on Monday. And I'm fairly confident, if I'm reading the Constitution at all correctly, that that's going to mean that we're going to have to return to the rules in place on November 7th and the result that we got out of that process.
What is basically the effect on the country now that basically the presidential election hinges on one vote coming down from the U.S. Supreme Court?
Well, every vote counts, as we've been saying, and we said all along in the campaign that the Supreme Court was going to be a considerable issue. No one knew exactly how considerable. But, you know, the real words that I think are the telling words are the words of the Chief Justice of the Florida Supreme Court. Here's a man that has spent a lifetime in the law, and his judicial pen was writing with very dispirited language. He really regretted that his court was placing in jeopardy the outcome of a national election, the integrity of the judicial process, and I think he is breathing, I don't want to put words into his mind, but the words that he put on paper, I think suggest that he's breathing a sigh of relief today, that part of the law is clearly messy and clearly depends on argument and people seeing things in different ways, but it ultimately depends on what's written down in advance. John Locke, a political philosopher in the 17th century, long ago said the only reason we surrender our liberties is because the law is written down and it's known in advance. And the harm that the Florida Supreme Court had was that it was changing the law as it went along, trying to do an equitable thing perhaps, but an equitable thing after the fact is inequitable and treats people differently in ways that the law doesn't envision.
All right, Doug Kmek, Bush attorney, we very much thank you for taking this time and explaining it and explaining the Bush position on things. And now we are going to head down, thank you, now we're going to head down to Pinellas County, where we've been looking at some live pictures all day long, and now we're going to William LaJeunesse there. William, I understand the folks there have had now a chance to sort of read through this 4-page order from the High Court. What's the sense now? Have they been able to decipher it all?
Arafat, to give him most of the territories in Judea and Samaria and the West Bank.
And it said you have to stop. So they stopped the mechanical, basically recount, so to speak, that was going on, or the culling of the ballots, if you will, to kick out the undervotes. That stopped, as well as here where they were looking at those ballots individually. I think you looked at about 227 ballots. Is that right? I'm joined now by Deborah Clark. She is the election supervisor here in Pinellas County. We're talking about basically St. Petersburg and Tampa. And Clearwater.
No, Clearwater, but not Tampa.
No Tampa. Okay. Well, Deborah, you tell me what happened.
Well, as best I can, as you said, we received notice on TV, and we had been advised by the Division of Elections to keep our television set on today for the most current information from the Supreme Court. And they did notice us that the U.S. Supreme Court had ordered a stay in the recount. So we waited, we recessed, got a copy of the order. It does indeed stay that recount, and it orders the briefs due to them, I think, at 4 o'clock tomorrow, Sunday, and they're scheduled to have a hearing at 11 o'clock on Monday.
So do you think you're going to be back here?
Well, if we are, we're certainly not going to have as much time, so our plan will have to change. At least we had time today to establish some preliminaries, the standards for counting. So the hours we were here today were not wasted, in my opinion. We will expand the number of counting teams if we do resume on Monday or Tuesday, because we'll have a lot less time to count.
You came up with a protocol that you thought was acceptable. You negotiated on it. There were some objections, some people in the audience and so forth. Do you feel comfortable comfortable with what your interpretation of a voter intent was?
Yes, I do, and I'm very proud of the canvassing board members. As you said, we did have a lot of discussion. One of the members even wanted to create certain situations on ballots, and that was good for us to look at. I think we had reasonable standards, and I think we were consistent in our decisions that we made today.
As you know, there was a part of the order that came down from the Supreme Court deals with the fact that there are so many different counties and so many different standards, and that arbitrariness actually helped the justice to make a decision in this case to actually issue the injunction. Does that strike you as an election supervisor around the state, different standards?
Well, I'm not real comfortable with it, and I can tell you that I was as concerned the last couple of weeks watching counting teams on TV as were other citizens. I think there do need to be standards. I'm disappointed that the state Supreme Court, when they ordered us to do this manual count, did not include very specific standards. I think that would have helped.
Were you embarrassed for some of your colleagues on the east coast of Florida?
No, I never try to second guess anyone. I never try to play Monday morning quarterback, because unless you're in that person's shoes, you don't know what decisions you would have made, and you're asked to make very quick decisions sometimes, so I don't judge other people.
Do you feel that the punch card system here, because there's 25 counties roughly in Florida that use a punch card or a modified punch card system, and most of the undervotes came from those areas. Do you feel that this way of voting is going to be blamed?
Well, I think this is one excuse that there will be. I think people will need to find reasons, and this is definitely one of them. I would like to point out, though, that the high number of undervotes is because the larger counties in Florida use punch card, and that's where you have your highest numbers of undervotes. You need to look at percentages. You need to look beyond just the numbers. There are weaknesses in the punch card system. We need to be very careful, though, that we don't make rash decisions and move ahead of ourselves before we really understand the other systems that are out there. I'd like to see us get the very best one there is.
A few other things. You mentioned to me a moment ago you were uncomfortable watching some of your colleagues on the East Coast about them holding the ballots up to the light and a magnifying glass. Why did that make you uncomfortable?
Well, I think any time that you take that long to look at one card, what made me more uncomfortable than holding the cards up to the light was one of the judges in one of the counties actually would remove his glasses and get a magnifying glass out and look. And if you have to look to that degree, then to me there has to be some subjectivity and guesswork involved, and that's what makes me uncomfortable.
Actually, in this particular case earlier today, the Democratic Party did ask for any marking showing intent of voter. That was proposed and you rejected it. Why?
Well, I think the board had to make decisions that were comfortable for us, and certainly anyone who was observing this recount has the right to protest any or all of our decisions to the circuit judge up in Leon County. But the canvassing board has to make decisions we're comfortable with.
Deborah, thank you so much. We do appreciate it. It would have been a long night, and you're saved from that.
Yeah, well, I'm sorry we won't have more time together, but I'm sure you understand.
Thanks very much.
You're welcome.
Rita, that is back to you. I mean, basically, we had here roughly about 4,000 undervotes. It looks like that for the time being, they're going to be canceled, and they've stopped. Again, they looked at about 227 ballots out of 25 precincts. Total number of votes counted, 3.
All right,
Rita?
only 3. Thank you very much, William Lajeunesse. Now we're going to show you a live picture from Tallahassee where we are indeed awaiting a press conference. We're expecting that James Baker, who has been Governor Bush's key advisor and spokesman throughout this whole ordeal for the past 32 days since the election, that he is expected to speak. We're expected, obviously, to hear some very thrilled comments from James Baker, who I'm sure is very pleased with this decision. Yesterday, we did hear from him last night when the Florida State Supreme Court came down and had some very strong language. He said he was extremely disappointed with that court and felt that there were indeed some federal issues involved that the high court should take up, and now his wish has been granted. They are issuing that emergency stay, as we've been reporting, on a 5-4 decision to stop the recounts, and then in addition to that, they will hear the case as well. Briefs will be filed tomorrow by 4 p.m. and then oral arguments 11 o'clock. In addition to this, we're also awaiting David Boies, who is Gore's lead attorney, his basically spokesperson throughout this whole ordeal. David Boies, a very skilled attorney who represented Microsoft and a number of other cases, Napster as well, has been forefront in American politics and in all the political scenes since. And now we are going to go to Tallahassee, not too far from where you're looking there, to Brett Baier. I understand, Brett, you have some unofficial results from the Miami-Dade recounts, right?
Yes, Rita, we just talked to Barry Jackson. He was one of the Republican observers inside as the circuit court judges were looking at all of the ballots, the 9,000 ballots. They made it through about 4,000 ballots, and this is according to the Republican observer. He says there were 92 votes for Bush, 50 votes for Gore, 137 challenges, and 3,236 no votes. So basically, in that preliminary unofficial tally there, Governor Bush picked up 42 votes. That's in 167 precincts in Miami-Dade County. That is unofficial, of course, from one of the Republican observers. But if it is indeed accurate, that hand recount was not going the Gore campaign's way as it continued. They made it through about half of the ballots, as we said. They were thinking they could finish by 9 p.m. tonight, but of course, everything has been put on hold, frozen by that United States Supreme Court stay. The clerk here came out, the court administrator, Terry Cash. She read that stay and said that the ballot counting was going to stop, and there were big cheers out here from Bush supporters outside the Leon County Library. But again, the unofficial tally had Governor George W. Bush picking up 42 votes so far in that count. Rita?
Hey, Brett, a quick question. First of all, Gore reaction. You talk about the Bush folks reacting and cheering. What about the Gore folks out there? What kind of reaction did we hear from them?
There were very few Gore folks out here, actually. The few who were here were very quiet about this decision. So it was mainly the Bush campaign people with signs cheering when Terry Cass made that announcement, and obviously cheering when they heard that Governor Bush unofficially was picking up votes instead of losing them in Miami-Dade County.
And I want to ask you real briefly about him picking up the votes. Were those in Republican-heavy districts or Democratic, or is there a sense of if that would have been a sign of the times had they finished the full recount?
I couldn't tell you. It's 167 precincts, but they didn't get specific as to which one. Rita, we'll go back to you.
All right, great. Now we're going to go live to James Baker. Let's listen in.
Good afternoon, ladies and gentlemen. I have just spoken to Governor Bush, and of course we are pleased by the United States Supreme Court's decision this afternoon to stay the mandate of the Florida Supreme Court and to grant our petition for a writ of certiorari. This means that the partial manual recount system created yesterday by the Florida Supreme Court will not now proceed. As the three dissenting justices of the Florida Supreme Court emphasized, their four colleagues risked violating federal law and the United States Constitution by developing an alternative and flawed recount system. The United States Supreme Court's action confirmed the foresight, I think, of Florida Chief Justice Wells, who stated that the decision of some of his colleagues, quote, cannot withstand the scrutiny which will immediately follow under the United States Constitution, close quote. Therefore, we're very pleased that we will have the opportunity to argue the merits of our case before the United States Supreme Court on Monday. I'll take a few questions. Yes, sir. Of course not. They haven't ruled on the merits. This is a stay, but it is a stay, and they have granted a writ of certiorari. They have asked for briefs, and they will hear oral argument on Monday morning. David?
In the dissent to the stay, several justices seem to have made clear that in their mind, this was tantamount to a ruling. Do you agree with that?
I don't really want to put an interpretation upon the brief statement granting the stay or the dissent from the granting of the stay. I think that's something that we will make our case on Monday before the full court, which is, I think, is the appropriate thing to do. Yeah, just one last question.
Can you tell us what it's been like for Governor Bush these past 24 or 48 hours?
It's not been just these past 24 or 48 hours, David. It's been ever since we began this process, this odyssey on November the 8th. It changes from day to day. It's one day you're up, one day you're down. It's taken a lot of twists and turns. But it's very, very gratifying to us, I know to Governor Bush, to all of us, that the United States Supreme Court has now for the second time indicated a willingness and an interest in hearing this very, very important case and this very, very important federal issue. There's nothing that would have a more significant national nexus than the election of our national leadership. Yes.
Early reports actually out of single candidacy have Governor Bush doing much better than people expected. I mean, is it
the issue is not whether we were doing better than expected in the earlier counting. In my view, the issue is still what it was several weeks ago when we met here in this very room and we talked about the requirements of federal law that say that fairness requires that the rules be played under, that the game be played, under the rules that existed on the date of the election. And it is simply not fair, nor is it appropriate under federal law, and nor is it constitutional for those rules to be changed after the game has been played. Yeah, Chris.
Very much. Can you give us a little bit of a behind-the-scenes feel of what it's going to be like between now? You have a very short time until tomorrow when you have to file those briefs. What's it like for your legal team, which I know has already been quite exhausting?
Our legal team has done an extraordinarily good job with many, many tight deadlines. It would not be accurate for me to say that they are not, that they have not had a lot of activity, and yes, they are. Some of them are tired. That's a fair statement. I'm sure there's some tired lawyers on the other side because we have had to respond to many, many deadlines on short notice. We now have some more lawyers coming in, just as the other side does. But I'll say the same thing I said last night. I really think it's not. I really think it's sad that we seem to be deciding a national election for President of the United States in lawsuits and in courthouses after the election outcome has been certified. This is the first time, I think, in modern history that has happened. But our folks are ready to go. We have a fine, we think, petition for a writ of certiorari before the court today. Most of the arguments that we will be making in our briefs are in that petition for certiorari, an application for stay, which was worked on throughout the night last night. So we'll be ready on Monday morning, and we're extremely gratified that the United States Supreme Court has once again recognized or seen what we think are some very serious deficiencies in the way the process has been conducted down here. It's just simply not fair to change the rules after the game has been played. Thank you very much.
Your most recent conversation.
An upbeat James Baker, who is the Bush Recount advisor and key spokesperson that we have seen throughout this whole ordeal, basically saying, quote, "It is sad that we're deciding the presidential election in the U.S. courts after the election outcome," and basically maintaining the Bush camp's position that they have said all along, that they believe it was a federal issue when these recounts were ordered. Very disappointed by the decision that came down from the Florida State Supreme Court, and now happy with this new decision that has come down from the U.S. Supreme Court, issuing an immediate stay and stopping the recounts in all 67 counties in Florida. We're now going to go to Jim Angle, who's in Tallahassee. Jim, I do want to ask you first off, what sort of message does this send? This was obviously a split decision, 5-4. And what is the sense that maybe one of the sides could peel off one of these votes? Clearly, it's an indication where possibly these justices do stand on the merits of the case, obviously.
Well, one tries to anticipate what the Supreme Court, any Supreme Court, will do at his or her peril. Obviously, you have 5 people who thought there was a serious constitutional problem with the way this recount was going forward, based clearly on the Republican argument that different standards in different counties is unfair and unconstitutional and requires the Supreme Court to take a look at that process and figure out if, in fact, it bears up to constitutional scrutiny. Now, it is interesting, Rita, that in the count as it proceeded so far, as you heard Brett Baier report earlier, we had 2 entirely different reports. The Democrats were telling us that Al Gore had picked up 36 votes in 9 fully or partially counted counties, but in here at the count in Tallahassee, which was of the 9,000 undervotes in Miami-Dade County, we're told that George W. Bush got 92 votes, Al Gore got 50. There were 130 337 votes challenged and 3,236 votes that were deemed to be no vote at all. So you can sort of get a sense of the way the process was unfolding. Now, the interesting thing about that is that the Gore forces had been arguing to recount those votes from Miami-Dade all along. What some other analysts have been saying was what has happened is that in the first 20% they counted, these were largely Democratic precincts, and that it was possible in the other 80% of the undervotes, which were coming from more Republican-leaning precincts, that George W. Bush might actually do better. Well, so far, that appears to be the case. Rita?
All right, Jim Engel, thank you very much, and thank you to all our reporters covering this breaking story. And just to give you one other final recap here, the U.S. Supreme Court, in a 5-4 decision, just came down a short time ago, deciding that it will indeed grant that stay, stop the recounts in all 67 counties in Florida. And stay tuned to Fox News Channel, because we will have more details on this throughout the day. You're looking at a live picture. We're still waiting to hear from David Boies, the lead attorney for Vice President Al Gore. Stay tuned.
Was on. Now the recount has stopped. By order of the United States Supreme Court, the recount has been called to a halt. Right now we're going to go to Duval County. Judge Brent Shores is holding a news conference. He was supervising the recount until the Supreme said stop.
Skillians, excuse me. Concurring opinion about voter intent and dimpled chads, hanging chads, etc., and different standards that may be enforced in different counties. The bottom line is that this case is set for oral argument on Monday, December 11, 2000, at 11 a.m. before the United States Supreme Court. It's clear to me and to the board from reading this opinion that further action is stayed. It is our intention at this time to secure the ballots and to take no further action at this time pending an order from the United States Supreme Court.
Your Honor, has the board considered continuing with the segregation of the ballots, not moving forward with counting, but continuing with the segregation? We believe under the terms of the stay order, a segregation of the ballots is certainly permissible and has not been excluded by the stay order. We think that would be beneficial, since the segregation would allow the canvassing board to be ready to count when the Supreme Court determines that the count can proceed, which we expect to happen soon after the oral argument on Monday afternoon.
If I could address that, I would like to. Not only did we read the Supreme Court opinion, we also took a look at the emergency application filed by the Bush campaign, the response of the Gore campaign, and the supplemental authorities. My reading of this opinion, of the Supreme Court opinion, is the same as Judge Shores with regard to the effect of the stay. My reading of this disagrees with you that we are allowed to continue in any manner. Based on Judge Scalia's language and based on the language in all of these documents, that is an integral part of the recount process, and the legality of that process needs to be established. One of the points raised in the supplemental authority to the U.S. Supreme Court was the very question of legal standards in the separation process, and something we were not informed of this morning, for example, was that in 20 precincts in Dade County, this very same software resulted in more undervotes than there were in the original counts, which addresses the concern that I had this morning on what are the standards, what is the accuracy, what is the reliability of simply separating and identifying the undervote. Therefore, I respectfully disagree under my reading of this law. I believe stay means stay, and I think we have to wait for a court order for further instruction.
Right, and I would say in addition to that, and I agree with what Mr. Mullaney says, stay not only means stay with regard to this, but I think the suggestion that we go ahead and do anything with regard to these ballots only compromises these ballots in case we are ordered to come back and take further action. So I think the prudent thing to do is what we're going to do, and that is to secure the ballots.
We were watching a news conference in Duval County where the judges who are supervising the recount are explaining to the observers why they are stopping entirely, not continuing with segregating the ballots or doing anything further with the ballots until oral arguments before the U.S. Supremes on Monday. That news conference is ending. Meanwhile, in Tallahassee, David Boies, representing the Gore team, is about to begin a news conference. The Gore team won big yesterday, and today we will find out if he thinks they lost or if a stay is sort of a draw between camps. The Boies argument before the courts up until now has been that it is important to do the counts while there is time to do the counts. What the U.S. Supreme Court majority said is it's more important to decide if the count is going to count, if the recount is going to count. Are we going to use these tallies that are being done now in Florida, or were being done before the stay, as the final certification for the presidential vote in Florida? Or are we going to say no, that these hand recounts by a variety of standards from county to county are not going to count? The U.S. Supreme Court, at least in its majority, felt it was better to decide first whether a recount tally was going to be the final count, and not have a number hanging out there, either Bush up by a certain number or Gore up by a certain number, and then the U.S. Supreme Court have to decide that is not going to count. Here is David Boies entering the news conference room, about to begin a briefing with the media. That is Ron Klain,
Good afternoon.
a Gore attorney. Let's listen in.
We're obviously disappointed in the Supreme Court's decision to grant a stay against the manual recounts here in Florida, and we're disappointed for several reasons. First and foremost, we were actually quite pleased with the progress being made at the counts underway here in a number of counties. Our latest information shows that 13 counties had completely or partially completed their recounts, and in those counties, Vice President Gore and Senator Lieberman had gained a net of 58 votes. 5 of those counties were heavily Republican counties. So we believe that the progress made in the count thus far indicated that we were clearly on a path for Vice President Gore and Senator Lieberman to make up the difference and to pull ahead had the count been fully completed. Secondly, we obviously believe, as we told the Supreme Court in our filing this morning, that the balance of harms here weighed against a stay and weighed in favor of allowing these counts to be completed. We believe that the court's decision to stay the counting of the votes was obviously one we disagree with, and we wished the court had ruled otherwise. But third, I think we remain very optimistic about the court, about us ultimately prevailing in the Supreme Court when it hears this case on Monday. We believe that this decision of the Florida Supreme Court was correct, based on state law, and was a faithful and traditional application of this state's statutes and precedents in dealing with election contests. And we believe when the Supreme Court ultimately hears this case, that will be their conclusion. The court's decision today, of course, as Secretary Baker noted, is not a ruling on the merits, and that will come later. And when that comes, we remain very hopeful that the court will rule with us and allow these counts to be completed. David?
I'd be pleased to answer a few questions if you have them. Sure. He also would be pleased to answer questions.
No, the 58 is a net number of all 13 counties. So yeah, he gained some votes. We gained more than 58, and in the end, 58. We gained as far as they got before they stopped. We gained a net of 58 votes in the 13 counties. As you should. That was the state of the counts when they were stopped. In partial counts or full counts, we gained votes, they gained votes. The net of all those results, based on the latest data, was Vice President Gore gaining a net of 58 votes. And again, some of those were from very Republican counties. In Escambia County, which is a very heavily Republican county, we net gained 3 votes. Which obviously is not a big gain, but it's in one of their counties. So we felt very good about the progress of the counts. And also, can I say one other thing? From a less partisan perspective, that we thought the counts were proceeding forward in a very orderly fashion, in a very thoughtful fashion. I thought it was heartening to watch the volunteers, the judges in there doing it in a very thoughtful and orderly way, and so we were very pleased with the nature and the tenor of the counts as well.
Ron, why would a justice who was inclined to believe in the merits of your arguments vote for a stay?
Well, I think that the justices obviously made a decision that stopping the counts now was the right decision for now. I think when they see the full briefing in the case, when they hear the oral argument, we believe they will agree with our position that the Florida Supreme Court accurately, correctly, and traditionally applied its statutes and its precedents to develop the remedy that it developed in this case. And we think that'll be their conclusion here, David.
I understand. I'm just saying, Ron, help me understand why a justice who might be inclined to move with you would vote for a stay.
Because the test in the court's precedents is a substantial probability, but not necessarily a certainty that they will prevail on the merits. And obviously it's a decision by the justices that there is some chance that Governor Bush will prevail. But that isn't a decision that he will prevail. Again, Secretary Baker himself noted this is not a decision on the merits. And we believe once the case is fully briefed and argued and presented to the court, they will affirm the decision of the Florida Supreme Court.
Well, I don't think the 58 votes has anything to do with what the Supreme Court decides, or at least directly. I think the 58 votes indicates that if this count continues to go forward, it looks like, right now, although nobody can be absolutely certain, that Vice President Gore and Senator Lieberman would win the popular vote in Florida, just as they won the popular vote outside of Florida. I think the thing that's important for the Supreme Court, and Justice Scalia, who is one of the justices who votes for the stay, and he explains why he does that in his opinion. And what he says is that he doesn't want to have, if President Bush is ultimately elected, he doesn't want to have the legitimacy of that presidency undercut by the fact that people will know that there were more votes for Vice President Bush, for Vice President Gore, than there were for Governor Bush in Florida. Now, we think that's wrong. We don't think that's the right way to look at it. But let me just finish the answer, okay? We think the right way to look at it is the way the 4 dissenting justices looked at it, which is that the legitimacy of any president that's elected is going to be impaired unless the American people understand that there has been a full and fair count of all the votes. However, accepting what Justice Scalia says, where that leads him is to say, I don't want to have that count go forward because a doubt has been raised about the adequacy of that count, the legality of that count. I don't want to have that count go forward until the court has had an opportunity to decide this on the merits. Now, we may agree or disagree, and obviously we think the dissent had it better, but the fact of the matter is that the basis for the stay is a basis that says we don't want this count to go forward and then have us overrule it, because that will be something that will cast in doubt the legitimacy of the presidency.
One thing that has been almost a mantra for the last couple of weeks now is time. Time has always been of the essence. We don't have oral arguments now until Monday.
Right.
We have December 12th is this Florida State Supreme Court deadline. How do you deal with the time issue now?
I think the timing issue is probably the single most disappointing thing about what the Supreme Court has done. I think that if we had whirled enough in time, the fact that they stayed the count until they heard the merits on Monday really probably would not make any difference. I think the reason that it makes a difference and the reason that we are disappointed is because it makes it much more difficult to get the count completed if the court rules that the count can go forward. Now, given the progress that was made today in just a few hours, I think we have some reason to be optimistic that if the court rules promptly after the argument that the count can go forward, the count could still be completed. But there's no doubt that by delaying it, it has created a very serious issue as to whether that count can fully be completed or not by December 12th.
But is that December 12th deadline that dropped dead now? Do you think December 18th is actually the real deadline?
I think there's no doubt that December 18 is the final deadline. We've all been trying to get it done by December 12th. I think that in the last week, everybody has recognized that at least under certain scenarios, it would not be done by December 12th. For example, the legislature said that if it acted, it probably wasn't going to act until December 13th, and that the December 12th deadline was not any magical end date. That's true. Nevertheless, I think because we have all felt that there was an advantage to the voters of Florida and to the assurance that Florida's votes would be counted, to have it completed by December 12th, that was highly desirable. We've been working very hard towards that goal, and I think that this decision imperils that goal to some extent.
But is it your belief then that December 18th is the real end game and not December 12th? Because it's been suggested that if the justices don't rule almost immediately on your arguments Monday, essentially that's the end of the line for Vice President Gore.
Well, I don't know about essentially immediately, but obviously, if the Supreme Court were simply to take this under advisement, leave the stay in effect, and not rule for a couple of weeks, that would, in effect, kill the ability to get the votes counted. I don't think the Supreme Court's going to do that. I think the Supreme Court is acting with expedition. They have set a hearing on Monday. This is, after all, only Saturday. They have accelerated the briefing schedule. So I don't think the Supreme Court of the United States is going to let the clock run out on this any more than the Supreme Court of Florida let the clock run out.
And can I add one other thing in response to that also, which is, I think the Supreme Court of the United States is very well aware of 3 U.S.C. 5 in the presence of December 12th. And I think that when they rule on this case, they are likely to provide guidance on that issue as well. They know the calendar. The calendar was briefed by both parties in the stay applications and stay oppositions, and I think we're likely to get some more guidance from the court on the relevance of that 12th in this decision.
Have you spoken to Vice President? What's his reaction?
Chief Justice Charles Wells, in his very strong dissent last night, talked about a constitutional crisis because of his colleagues. Your response to that, if this proceeds, the Chief Justice is concerned.
Chief Justice Wells had a point of view about the possibility of a constitutional crisis. That point of view was not shared by any of the other 6 justices, not even the other 2 justices that dissented. So 6 out of the 7 justices of the Florida Supreme Court did not see this as creating a constitutional crisis. We don't think it creates a constitutional crisis either. This is going to be resolved under the rule of law. Now, it may be a rule of law that ends up with a decision that we agree with. It may be a rule of law that ends up with a decision that we disagree with. But we believe that this is going to be decided by the rule of law. And we have always said that the courts were going to decide these cases that were brought. We think it is unfortunate that Governor Bush's campaign has taken this to the courts. We believe that the right way for this to have been resolved was to have the votes counted in the political electoral process, and not to try to bring in the courts to interrupt that process. However, every person has a right to take a matter to court, and once the courts rule on that, that's the decision that is going to be abided by.
What's the Vice President's reaction to all of this?
You'll have to ask the Vice President that. We have been, as you can imagine, trying to deal with the legal issues that we're faced with. If I'd come out here at this morning, mid-morning, I would have been able to say how pleased we were that the Florida Supreme Court had turned down the stay. If I'd come out around lunchtime, I could have said how pleased I was that the 11th Circuit had turned down the stay. I'm now out here saying how disappointed we are that the United States Supreme Court has granted that stay. There's been a lot going on today. We have been struggling to get our briefs, which are due on a very accelerated time schedule, fixed. I am sure that the Vice President of the United States is disappointed that the vote count has been interrupted. We have said from the beginning that our goal was to have all of the votes that have been cast counted, and that once those votes were counted, we thought that was the way elections in this country should be decided. And I'm sure he's very disappointed that that has been interrupted.
Two more.
I think there are three arguments, and I'm not sure which one's the best, and I probably won't be arguing it. And that person will have to decide what the best argument is. But certainly one argument that's very important is that there is no federal question here. This is a matter of state law. And the Supreme Court of the United States has not, at least for 100 years, and maybe going back further, ever stepped in to change the result of a national election by substituting its judgment as to how votes ought to be counted for the judgment of the local election officials. So I think one of the things that we would be urging the United States Supreme Court is that this is a matter of state law. State law is deserving of deference, and that the United States Supreme Court ought not to step in and substitute its judgment as to what the intent of the voter was for the judgment of the state officials that under law have that obligation. Second argument is this is a conventional application of existing Florida law. As the dissenting justices point out, there are a series of cases going back decades in which the Florida Supreme Court has ruled consistently with what the Florida Supreme Court ruled this week. So what you have is not any change in Florida law, but the consistent application of Florida law. The third thing that we would urge is that, as Justice Scalia indicates in his opinion, the standard is not whether they agree or disagree with the Florida Supreme Court, but was the Florida Supreme Court so unreasonable and arbitrary that there was simply no basis for what the Florida Supreme Court did. And we think not only can they not meet that standard, they can't even meet the standard that says the Florida Supreme Court was wrong. But the plaintiffs, Governor Bush's team, have a very heavy burden under established Supreme Court precedent. This is a situation, you've heard lots of people talk about changing the rules of the game. This is a rule of the game that has been set in Florida for decades. The rules of the game have been, first, that the people elect the electors, and they do so by a majority of their votes. The second principle is that all of the votes that have been cast are counted. And the third principle is that when you can't read a vote through a machine, you have a manual recount. There's a statutory provision for that. That statutory provision has been implemented in dozens of cases, most recently the Beck case 2 years ago. And Florida law is absolutely clean on this and clear on this. So that what you would be doing here is radically changing the rules of the game, right in the middle of the game. And what we're saying is, first, that shouldn't happen. And second, that certainly shouldn't happen by having a federal court come in and tell a state court, you've got to change the rules in the middle of the game.
David, that first argument seems like a strange argument for you to make, that courts shouldn't step in and substitute their judgment for the judgment of local election officials, because the local election officials in Florida and the state election officials in Florida believe that Gore lost.
No, I think that's not right, because right now what's going on around this state are counting of the votes by the local election officials.
Under a court order?
Yes, under a court order that says count the votes. The court has said you must count the votes. But what the voter's intent is, whether there is a vote there for Vice President Gore or Governor Bush, is something that is being decided in every case except one limited exception by the local boards. That one limited exception is the Miami-Dade undervotes, and even there, it's being done in conjunction with the supervisor of elections of Miami-Dade County. So that in every single instance, the votes that are being counted now are being counted by the boards that are given that responsibility. The courts have said, count the votes, because the courts have said that's Florida law. But what votes are counted and what votes are not counted, which is what the Supreme Court in Justice Scalia's concurring opinion says they're interested in, that is whether you're applying the right standard or not, that standard is the standard that is being applied by the local boards, the people to whom Florida statutes and Florida cases have given that responsibility for decades.
Last one. Ruled that you guys weren't allowed to be running tallies. Wasn't that part of the order? And now you gave us a number earlier of 52 or 58 votes. Didn't the judge actually say, and I think everyone agreed, those have to be running tallies?
That's our best information. It's not a running tally. It's our best information coming back as part of this process. And I don't think there's anything wrong with that under Judge Lewis's order last night. And also go back to one other thing in response to David. As I think David put it very well about changing the rules in the middle of the game, but one other rule to this game is that every game needs a referee. And in this process, the referee is the Florida courts and ultimately the Florida Supreme Court. And we think that's a very well-established tradition here in Florida and a very integral part of the Florida statutes. And we think ultimately the Supreme Court will recognize that and uphold the decision here. Thank you very much.
Thank you, everybody. I just want to follow up this question. You guys don't think you did anything wrong with this order?
Okay, we've now seen a news conference from James Baker representing the side of George W. Bush and David Boies and Ron Klain representing the side of Vice President Gore. Where we stand is the United States Supreme Court has issued a stay ordering a stop to the recount that had been ordered to go forward by the Florida Supreme Court. The U.S. Supreme Court is expecting written arguments, briefs, to be submitted tomorrow, Sunday of all days, at 4 p.m., and then we'll hear arguments at 11 o'clock Monday morning. We're going to take a break. When we come back, we have Tony Snow will be joining us from Washington. Judge Andrew Napolitano will be here with me in Washington. Joe DeGeneva, former U.S. Attorney for the District of Columbia, and Jim Portnoy, an election attorney. We're going to argue about the United States Supreme Court. Did they do the right thing, or have they done a very wrong thing? This is Fox News Live. We'll be back with more right after this.
ビデオになりました。怖がらないで。大統領に噛みつく骨のあるアニメ。あんたら一体何者？
FBI のモルダーとスカリーです。
わかりますね。
はい。
宇宙人だ。覚悟しろ。子供って残酷になれるものよ。ハッピー。ありがとう。
シンプソンズ始まった？まだ。ザ・シンプソンズ選び抜かれた傑作が4話。それで一つのビデオに入ってます。ビデオですから繰り返しご覧になれます。おい、俺のビデオが出るぞ。ザ・シンプソンズ。これを置いてないビデオショップはもぐりです。
親父見る気ある？
Fox News Channel Daytime. You want to make the right choices. We give you the power to decide for yourself. Fair and balanced. The most powerful name in news. Fox News Channel. We report, you decide. You Decide 2000. Exclusively on the Fox News Channel. Powerful coverage. From America's election headquarters. John Scott. Bridget Quinn. David Asman. Linda Vester. Shepard Smith. Neil Cavuto. Fair and balanced reporting from America's election team, giving you the power to decide. You Decide 2000. From the most powerful name in news, Fox News Channel. We report, you decide.
Channel V.
Channel V.
Channel V. Channel V.
Check it out now.
Channel V. 24時間 100% music. US, UK のトップヒット on air. Concert, music news, star 独占インタビュー and more. International music scene をそのまま catch.
What does the V stand for?
Channel V.
have seen it all today. The United States Supreme Court stepping in and stopping the recount that had been ordered by the Florida Supreme Court, putting a stay on that action. Joining me now in Washington, D.C., the host of Fox News Sunny, Tony Snow, and also in other studios somewhere in Washington, Joe DeGenova, the former United States Attorney for the District of Columbia, and Jim Portnoy, an election lawyer and a Democrat, but not necessarily representing the Democrats. And here beside me, Judge Andrew Napolitano. Tony, if you wouldn't mind, I'd just like to ask Joe DeGenova something to get things rolling. Joe, the Supreme Court is essentially said today, if I've got this right, better to decide if we're going to use the count before we take the count. Is that about right?
Well, that's what Judge Scalia said in his concurrence. But what the Supreme Court did today, John, was to just stop everything. But they have done so under a standard where you have to have 5 votes. And as Judge Scalia said in his concurrence, the way you get 5 votes is if you believe that the petitioner, that is Governor Bush, has a substantial likelihood of success. What they did today was do a body blow to Vice President Gore to stop the manual counts. And I must say, I think the fat lady has sung today.
You think that's it?
I think the Supreme Court is going to reverse the Florida Supreme Court. I think they will do so for the following reason. When the Supreme Court of the United States issued a unanimous decision instructing the Florida Supreme Court how to do its job, and embarrassingly for the Florida Supreme Court vacating, making null and void its 43-page opinion, and the Florida Supreme Court came back with the kind of ruling they did yesterday, with a dissent, an unbelievable dissent from their own Chief Justice. I think the Supreme Court, which probably had the same 5 votes the last time when they granted the petition the first time, decided that the Florida Supreme Court was out of control, legally.
So renegade. Tony?
Well, you know, I want to ask Mr. Portnoy. Now, you know, we've heard David Boies and Ron Klain say, well, we actually think the Supreme Court's going to vote with us. You've just heard Joe DeGenova say, the way this thing is written, it's a pretty clear indication that there are at least 5 votes. A lot of people even think that David Souter might join in such an opinion. Do you really think there is any real probability that the Supreme Court's going to give Al Gore what he wants?
No, not really. I think that Joe actually correctly alluded to the standard. The standard for granting a stay is that you find there be a substantial likelihood of success on the merits. That means at least 5 justices already have concluded that they think that Governor Bush is likely to win the case. So as a practical matter, I think that Joe's analysis is correct. This is probably coming to a conclusion. Now, if you're asking me whether I think they did the right thing, I'll give you a different answer. But I think it's pretty clear what they did.
No, go ahead. Give your analysis of that, because I'd like to hear it.
Okay, well, my analysis, it probably won't shock you, is pretty close to that you heard from David Boies and Ron Klain, which is that the Florida Supreme Court simply analyzed and interpreted Florida law. And interestingly enough, they analyzed and interpreted a Florida law which the Florida legislature passed. And it would seem to me that that legislative enactment is entitled to deference under Article 2, just the way the Republicans have been claiming. So, in fact, I think that if the Supreme Court were to be totally consistent in its view of Article 2, it probably ought to defer to the Florida legislature's enactment of the contest statute and to the Florida Supreme Court's interpretation of that statute.
Judge Napolitano, if I can ask a layman's question, it seems to me...
A pretty bright layman, Gibson.
Well, but it seems to me that the wild card in all of this was the Florida Supreme Court essentially saying 67 counties, make up your own rules, do a count, give us the final count, even though there's 67 different ways of doing it, and you may have all done it differently. We don't care. That'll be our final count. Is that reason enough for the U.S. Supreme Court to put the brakes on it and say stop?
Probably not. That, I don't think, is the argument that appeals to the Supreme Court. I think the argument that appeals to the Supreme Court is what Joe DeGenova mentioned. The Florida Supreme Court put its thumb in the eye, to use your phrase,
from yesterday,
of the United States Supreme Court when it did not address what was sent back to it in the mandate. They cited the federal statute, the Florida Supreme Court did last night, that prohibits changing the rules after 6 days before the election, and simply said, we are cognizant of this statute. Boom. and didn't say anything else about it. They never attempted to reconcile what the Supreme Court said they must reconcile, that federal statute, with what they were ordering.
So, Joe DeGenova, if you and Andrew are in agreement, the SCOTUS, the U.S. Supreme Court, is saying the Florida Supreme Court was a rogue court in its decision yesterday.
Oh, I don't think there's any question that they never thought, when they wrote that opinion, that the United States Supreme Court would bother itself again with this case. I think what happened was, and I think Chief Justice Charles Wells' dissent is a very, very interesting piece. It'll be studied in law schools for its not only its historical value, but for its prescience. Because remember, it was David Boies who misrepresented the ruling in the Illinois Supreme Court to that court. And I think Chief Justice Wells, when that case was remanded from the Supreme Court, first question out of the box from him to Mr. Boies, after Mr. Boies said, "My name is David Boies," Chief Justice Wells says, "Do we have any right to be reviewing this case?" And right in the back of his mind was McPherson versus Blacker from 1892, which Mr. Boies had failed to bring to the attention of the court. I think this was Wells' revenge.
Okay, Jim Portnoy, I want to get back to a point you were talking about, which is the difference between the contest and protest provisions in Florida law. You say that the Florida court was simply interpreting the law. You look at the statutes, they're entirely different. And the way they're adjudicated is different. And the contest provision says that the contests terminate in a circuit court, not the state Supreme Court. And it's very specific there. Now, one of the arguments that was made by Bush attorneys, not surprisingly not accepted by the Florida Supreme Court, was that they basically ignored that provision in law. Could it not be something that the U.S. Supreme Court would say is, now, wait a minute, you ignored state law, you therefore ignored legislative intent, therefore you violated federal law?
I suppose they could go there, but I don't really think that's going to be the end of it. I think it's perfectly reasonable for the Florida Supreme Court to take the view that the circuit court, even if the statute cites to the circuit court, that the statute contemplates review by the entire Florida judiciary. And interestingly enough, the Florida Supreme Court didn't it remanded to the circuit court for further proceedings not inconsistent with the opinion. So you could even argue that the statute, if you interpret it the way you're suggesting, has been complied with. I don't think that's going to carry the day.
Okay, let me ask you the question that's occurred to a lot of people, which is, okay, this Supreme Court of Florida first sets a new date, a new end date for counting ballots. People don't finish it, so it sets a new end date. And then it says, and by the way, undercounts in all counties, not full rate counts, but undercounts. That strikes a lot of people as just making stuff up on the fly.
I think that's a reasonable criticism, I suppose. but the bottom line is,
to see how you were going to answer that.
At least from the perspective of the contest statute, the statute expressly says that the court can render whatever relief it sees fit.
Yeah.
The legislature gave it that authority. You know, you may disagree with the relief that they've crafted. You may think that it was a bad idea, that it was impractical, but the statute very clearly says they can do pretty much anything they want. So
yeah,
I don't see why that becomes a legal dilemma.
Well, I'll tell you what the problem was, though, Tony. You're absolutely right. What happened here was when the Florida Supreme Court changed the date for certification from the one in the statute by adding 12 or 14 days, whatever it was, to it. You remember what Sandra Day O'Connor said in the oral argument? She said, gee, changing a deadline sounds like a pretty significant change in the statute to me. Because what the Florida Supreme Court was doing was fairly obvious to everybody. They wanted the hand recounts to go forward. So Al Gore would get enough votes so that when the certification occurred, he would be ahead. The problem was that even under the shifting standards and the manual recounts in selected Democratic counties, Vice President Gore still lost. And so what happened was they punished Vice President Gore because then the contest period had been compressed to a time period which made it impossible for Gore to do what he wanted to do.
A fine legal discussion. Tony, one more last point?
Yeah, one last question, actually, because it's one that's going to crop up in the next week, and I'll let Andrew Napolitano have first crack at it, which is, number one, how important is December 12th as a deadline? It was enshrined in statutes nearly a century ago. Is it fair for one Congress to bind another Congress in this kind of manner? Is this something that could arguably be construed as an unconstitutional provision binding future generations?
Looks like you're up on that one, Andrew.
Do you mean it would, I don't understand the question, Tony. So.
Okay, the question is, you know, you get this provision that says basically you got to have a state picket slate of electors by December 12th.
Right.
I'm wondering if that particular provision is all that important. And if somebody could argue that it's, you know, a prior Congress trying to tell every Congress when ultimately they're going to receive electors and count them and the methods by which they proceed, because as you know, Congresses cannot bind subsequent Congresses in matters of procedure.
Right. Well, this has only really been addressed once in 1876, because we have all assumed that if the electors were named by December 12, they were impervious to a challenge before the Congress between the 12th and the 18th, the so-called safe harbor period. So if for some reason the Supreme Court of the United States were not to grant Governor Bush's application and stop permanently the counting and allow the counting to continue, and a Gore slate of electors were to be sent to Washington after the 12th, that would be challengeable before this Congress, the one that's sitting now, the one that will be sitting on the 18th.
I got to say goodbye to Washington. Joe DeGeneva, thanks. Jim Portnoy, thanks. And, of course, Tony Snow. Tony, tomorrow morning, Fox News Sunday, we'll have all the latest on this, and I would guess not only the latest, but the greatest. Tony, thanks a lot. Talk to you a little bit later. We're going to take a break. When we come back, we're going to zip on down to Florida. Tallahassee, the Florida legislature is all teed up to name its own slate of electors no matter what the courts do. So, does that change now that the court has stopped the counting? We'll be right back. Stick with Fox News Live.
What, you got the tickets? You bet I'm there. I'll pick you up. Oh, wait a second. You know, I can't make it. No, I can't. Yeah, it's pretty important. I gotta go. Okay, I'll talk to you later. There's Daddy's little girl.
Fox News Channel Daytime. The whole story in context. Facts presented fairly. The issues balanced, so you have the power to think for yourself. Fair and balanced. The most powerful name in news. Fox News Channel. We report, you decide. Fox News Channel. Powerful all day. John Scott, Bridget Quinn, David Asman. Bringing the world to you. Making the issues clearer. Powerful hour to hour. Linda Vester, Shepard Smith, Neil Cavuto. Breaking stories, aggressive coverage. Powerful all day, fair and balanced. Fox News Channel, the most powerful name in news. We report, you decide. Power. You want to make the right choices. We give you the power to decide for yourself. Power. 24 hours, 7 days a week. Nobody gives you more original live programming. The power of news to keep you up to date. Shows that go in-depth. Issues in context. Topics that matter to you. The power of Fox News Channel. News and information, fair and balanced. The most powerful name in news. Fox News Channel. We report, you decide.
Fox Monday.
20年前国内を震撼させた男が帰ってきた。
犯人はもう次の獲物を狙ってる。
今度はインターネットで
現実の世界で襲う前に仮想の世界で接触している。
公開殺人が。
犯行を続けると思うか。きっとやる。
ミレニアム月曜夜11時 on Fox。
The United States Supreme Court has issued a stay in the hand recount going on in 67 counties in Florida, recounting the so-called undervote ballots which showed no vote for president. The U.S. Supreme Court is taking briefs tomorrow at 4 o'clock. That's Sunday, 4 o'clock, and then hearing the arguments at 11 o'clock on Monday. no vote counting until those arguments are heard and a decision made by the United States Supreme Court. Joining us now from Boynton Beach is Democratic State Senator, Representative, sorry, I was elevating your position there, Susan Bucher. Ms. Bucher, just your reaction to the U.S. Supreme Court stepping in here, essentially telling your Supreme Court, sorry, we're not going to let you proceed with yesterday's order.
Well, I think that we're all very disappointed at every juncture. I think the Gore campaign has worked very diligently in trying to follow a process to just count the votes. People went to the polls to vote on Election Day, and there has been, you know, vote counts. However, there are some ballots that have never been hand counted, and I think the statutes and the process, the judicial process, is very clear, and the Gore campaign is just...
Do you think it was unwise of the Florida Supreme Court to order a hand recount without dictating a standard by which every single Florida county could count ballots that had dimples or hanging chads or any of that? In other words, was it smart of them to say, go ahead and count this and make up your own rules, essentially having 67 sets of rules?
Well, obviously, each supervisor of elections should be prepared to handle a manual recount because it is a Florida statute. And I think that the intent was very clear. And in fact, there was no trouble in Tallahassee where the judges started counting Miami votes.
Yeah, but I mean, do you think it was, what I'm asking you is, it may be my opinion and my opinion only, I'll warn you of this, but it seems like the United States Supreme Court might have looked at this and said, what we've got going on in Florida is 67 different sets of rules, and there's something unfair about that. We're going to stop this now. If the Florida Supreme Court wanted to avoid that, they could have imposed a standard. Why do you think they didn't?
I really don't know, and that would have to come from the Supreme Court. But I did watch a little bit in Duval County where it was completely a stall tactic. They really didn't feel like they wanted to move forward, it seemed like, and we watched very intently. And all we want is to count the votes in a reasonable manner. Each supervisor has a responsibility to count the votes, and there is statutes that require manual recounts. And why don't they have standards in place in each county? Because the statutes are very clear.
But do you think there ought to be a uniform standard from county to county to county in Florida, or do you think that the supervisor of elections in each county should be able to make up their own rules? In this place we'll count a dimple, in this place we will not.
Well, certainly a standard throughout the state would be much easier to deal with. And I think the Supreme Court, the Florida Supreme Court, came down and was trying to be as fair as possible. I did watch the Florida Supreme Court argument, and the Bush attorneys argued that it wasn't fair just to count in Palm Beach and Miami. And so I think that the justices tried their very best to provide equity to the process. Unfortunately, they didn't provide a standard.
Susan Bucher, a Democratic representative in the state of Florida, thanks very much for joining us. We're going to take a break. When we come back, Jim Engel in Tallahassee has an interview with David Boies. We're going to find out what the Gore camp thinks from the center of the Gore camp. Stick with Fox News Live after a break. David Boies from Tallahassee.
You know, some mornings this is just too much. Especially when it's cold and nasty outside. But you're my pal. You're always there for me, unlike some people. And I'm not gonna let you down. Come on, man, let's go outside. So, Cosmo, got any big plans for today?
Come first to Fox News for breaking news, exclusive stories that impact the world, unique, timely interviews that shape our nation. First on the scene with breaking news, continuous coverage from over 70 bureaus around the globe.
We're the only ones here who still have live pictures out.
Reporters, anchors, and correspondents that are first, fair, balanced, powerful insight, powerful perspective, powerful news. Come first to Fox News for breaking news.
Power. 24 hours, 7 days. The most powerful name in news brings you the world. Fox News Channel, the power to bring you the people and places, from mega markets to emerging nations, reports that make a difference. Power to cover the events that shape the planet, the global forces changing your life. The power of Fox News Channel. News and information, fair and balanced. The most powerful name in news, Fox News Channel. We report, you decide. Fox News Channel. Powerful all day. John Scott, Bridget Quinn, David Asman, bringing the world to you, making the issues clearer. Powerful hour to hour. Linda Vester, Shepard Smith, Neil Cavuto. Breaking stories, aggressive coverage. Powerful all day, fair and balanced. Fox News Channel, the most powerful name in news. We report, you decide.
If making money were simple, we'd all be millionaires. Let's face it, money decisions are tough decisions. You need to know what's going on here and how it will affect your finances, your future, and your family. We cover the markets in plain English so that when the bell rings, you can understand what happened and decide what's right for you. We bring Wall Street to Main Street so maybe you can live on Easy Street.
No. You know, we agree on just one thing. A good argument's the best way to get to the core of an issue.
Wait a minute, I don't agree with that. A discussion's the best way. You have to explain, reason, justify your position.
Everybody on TV is discussing things, Alan. That's boring. If you want to find out what people really think, you need a good argument.
No, a discussion's
An
better.
argument.
A discussion.
We can agree on this. It's your turn to pick up the check today.
Well, I'll argue that one.
Alan, let's see if we can discuss this.
Handling.
Giant news today, the United States Supreme Court stopping the hand recount in Florida. They'll have hearings on Monday. Joining us now, Jim Engel in Tallahassee, who is joined by Gore attorney David Boies. Jim, take it away.
That's right. Thank you, John. Thanks very much, David, for joining us.
Sure.
Let me ask you first for your reaction to the Supreme Court decision today.
Well, we're obviously very disappointed that the Supreme Court stopped the counting. Governor Bush's lawyers had gone in and tried to get a stay from the Florida Supreme Court. That had been denied. They tried to get a stay from the 11th Circuit Court of Appeals. That had been denied. And then this afternoon, the United States Supreme Court stopped the counting. We think that was very unfortunate, but obviously we've got to respect that decision.
Now, one of the concerns addressed by one of the justices, at least, was over the standards and the fact that there might be different standards in all the counties. This is something you've argued about here in the courtroom, something you argued about with Judge Lewis when he set out the rules. Why is it, aside from the various legal arguments, wouldn't it be fair to have a uniform standard in all the counties to count all the votes in the same way?
Well, remember, there is a uniform standard, and that is the clear intent of the voter. And the Florida Supreme Court has said that's been the standard for decades, and they have given criteria as to how the intent of the voter is to be discerned. Now, if what you're saying, or what Governor Bush's lawyers are saying, or what the Supreme Court majority is suggesting, is that that ought to be done by a single authority, you'll remember we suggested that. That was our suggestion. It was the Republicans.
The Supreme Court do it, you mean?
Or that either the Supreme Court do it, or that it all be done in the Circuit Court. We had suggested that. It was Governor Bush's lawyers. It was Secretary of State Harris's lawyers. It was the Republicans who said, no, send it to the county canvassing boards.
But now you also had a problem with the way Palm Beach applied the standard as opposed to the way that Broward applied the standard.
Although we accepted. In the final analysis, we accepted what Palm Beach did.
Well, the court made you, didn't
absolutely,
they?
Absolutely. They said that's the rule. They said the rule is, under Florida law, you end up accepting what the local canvassing board does unless they make some kind of clear error. And we've accepted that. And that was the argument, after all, that the Republicans had made. And all we're doing is asking them to accept what they've been saying from the beginning was Florida law.
It seems like we're back where we started, with the question of recounts and the question of standards. Would you expect the U.S. Supreme Court to now address the issue of standards in a more specific way than the Florida Supreme Court has? As you and I were talking, obviously the clear intent of the voter is a subjective judgment that has been applied in very different ways here in Florida. Would you expect him to weigh in on that?
I'm not sure how different it has been employed. I think there are always differences on the margin. I mean, the reason you have appellate courts is that two judges may look at the same contract and they may interpret it differently, even though it's a question of law. So different people on the margin may make different choices. But that is part of the law. That's part of the political process. There isn't anything different here than in any other case. What's different here is that for some reason, people are preventing the local canvassing boards from doing their job of counting the votes. And there's a sense in which you're right. We're right back where we started. We're saying count every vote. This is America. Every vote counts. And the other side is saying, for a variety of reasons and a variety of different explanations, don't count these particular votes.
But when we were in the previous phase, you were arguing that we shouldn't accept the canvassing board's decisions about whether or not to go forward with the recount.
No, what we were saying is that once they made a decision to go forward with the recount, you shouldn't artificially stop it. Remember, the courts have repeatedly held that once a canvassing board makes the decision to go forward, you can't tell them to stop. Every one of the boards that we were relying on, Miami, Broward County, Palm Beach, Volusia, all made the decision to go forward. What happened in Miami-Dade was that for a variety of reasons everybody's familiar with, they stopped it prematurely.
Very, very quickly, December 12th, the drop-dead date, or no?
Well, I don't know if it's a drop-dead date. The legislature's been talking about acting on December 13th or December 14th.
So we're sliding toward December 18th.
So December 18th is probably more of a drop-dead date.
Okay.
But we all want it done by the 12th.
Okay. Thanks very much,
Thank
David.
you.
Boies, John, back to you.
Jim Angold, thanks very much. Let's go now. Jim, we'll talk to you a little bit later. Appreciate that interview with David Boies. This is New York Governor George Pataki giving the Republican side or the Republican view of what happened today. Let's listen to the governor.
To get an order to allow canvassing boards to begin to count hundreds of military ballots, military write-in ballots from overseas that had not been counted because of technicalities. The Gore campaign, for all its rhetoric, continues to hope and wish and seek to have those military absentee ballots not counted. And at the same time, their allies are continuing to appeal and try to disqualify more than 20,000 absentee ballots validly cast in Seminole and Martin County. This is not an effort to get a fair count. This is an effort to disqualify votes that may have been cast, and I believe were cast for Governor Bush, simply to try to help the vice president with the count. I also, as Governor Roscoe said, have had the opportunity now on different occasions to see the recount process underway in different counties. And it's simply a question of, is there a standard that is fair and in compliance with federal and state law? I can tell you from personal observation that the standards I've seen applied to counting ballots vary enormously from county to county and ballot to ballot. Now, I do not intend to impugn the integrity of any of those involved in the process, but with the absence of standards as to how one determines voter intent, it is inherently arbitrary, inherently flawed, and subject to dramatic differences from county to county, and in fact from counting table to counting table. As a result of this, the process has gone from counting votes to casting votes. And I can tell you, when I was down in Palm Beach County, I saw them holding up ballots to the light in the hopes that something could come through. Today I saw the judges of impeccable integrity, using not microscopes, but magnifying glasses to try to discern if there was in fact a mark on a ballot. That is not a fair system. That is certainly not the system that was in effect on November 7th as the federal law requires. And it certainly is something that has never, ever been done before in the state of Florida. It's a question of having objective, fair standards which do not exist from county to county and even from table to table here in Florida. And it's a question of applying the rules and the law as it existed at the close of the election on November 7th and not changing those laws, changing those rules after the balloting has closed. Those standards, those rules have changed time and again. And I believe, as the Supreme Court stated, that was one of the reasons why they have issued this injunction. It's not a question of trying to find every ballot that could possibly help Al Gore win the election and disqualify those legally cast for Governor Bush. It's applying the law in a fair and equal way. I believe when that's done, Governor Bush will be the President of the United States. Thank you.
Governors, are you saying that Ron Klain counsels for Vice President Gore flat out that you believe he's in contempt of court by giving those partial totals in his recount before it was stopped?
Well, that's a legal judgment, obviously, to be drawn, and the prerogative of which addressing is reserved to Judge Lewis. What we're saying is we're not going to get engaged in a process of debating those numbers or try to surreptitiously influence the process inappropriately. The language is plain and clear. No partial counts will be done or reported formally or informally. You can draw that conclusion as well as I can, and of course it's something that ultimately legally is reserved to the judge, and we're not going to invade his province in that regard. You are receiving here this afternoon from Secretary Baker and from the two of us, representatives of the campaign, official statements of record about these proceedings. And we are telling you plainly, we're not going to address those results, those partial results.
But you already have by saying that you're very pleased with the accumulation of those.
No, what we're saying to you in that regard is simply this, that we do not have agreement. And as a consequence of that, we're not going to get engaged any more explicitly in trying to bring any more definition because we believe it would be in violation of the judge's order. What I would tell you plainly is we do not have agreement. I don't think there's any finality to this process. We have different numbers, and we're not going to try to do anything surreptitiously that would violate the order.
Governor, you mentioned that the 4-3 court in Florida Supreme Court was very sharply split. The Supreme Court today was split 5-4. Would you not agree that they too were sharp?
I don't believe that you have yet received their opinion in such a way that you could call it a sharp split. Clearly, when you see the stinging and ringing dissents in the Florida Supreme Court's decision from 3 judges there, including the Chief Justice, I think you can draw that conclusion. Now, it may come to pass that you might have a sharply divided court at some point in time, but I don't think you can draw that judgment at this point.
Governor, do you believe that this hearing on Monday will be
I don't believe, as Secretary Baker noted, that in this unpredictable process that clearly has kept all of us with our attention focused can in any way ultimately you can say is going to be a process that concludes at any given moment. I don't think we know that. It'll depend upon what the Supreme Court says.
Well, to the American public who might be confused, how will the arguments differ in this coming hearing? How will they differ from the previous U.S. Supreme Court hearing?
We believe that there's an opportunity for significant resolution of a substantial portion of the issues that are involved in this case. But litigation, as you know, is subject only to the limitations of the imagination of those who are involved. And quite honestly, I don't believe anyone can say precisely that it will resolve every issue. And I think it would be foolhardy and folly to try to indicate that at this point in time. I believe that a clear reading of the law indicates that the 12th of December is the last date upon which those slates of electors can be submitted or determined. But there have been instances in the past where Congress has accepted a slate of electors that have been submitted thereafter. I think in order to make certain that it is as competent and as unassailable as possible, you must have them in on the 12th because there can be no question under that particular scenario. I understand that. I understand that. I just think that it obviously clears the cloud on any title. If it's done in time on the 12th of December, I believe that that's what the law provides, although ultimately this rests within the province of Congress.
Well, Chris, the problem is that there is no objective standard, and the standards vary from table to table, let alone from county to county. And as an example, in the early counting, recounting of Miami-Dade County, they not only counted using different standards, but they counted every single ballot, not just the non-vote or undervote ballots in Miami-Dade County, in the 20% of the precincts that voted most heavily for Vice President Gore. Now they are simply counting undervotes or non-votes and using a very different standard. That is not objective, that is not fair, and I believe it's a violation of equal protection for the voters of the state of Florida when their vote is counted differently within the same county, cast in the same county differently from one table to another or from one venue to another. What it comes down to is the process has to be fair and objective, and it has to be the process that was the law in the state of Florida on November 7th. This never happened before in Florida because it wasn't the law on November 7th, and in the absence from the Florida Supreme Court of their establishing standards and a process for all the different counties that are now or were engaged in this hand recount, it is inherently arbitrary, inherently unfair, and inherently subject to human error and other errors based on the absence of standards. That's the reason, I believe, one of the many reasons why it clearly is a violation of equal protection and inappropriate. It is not aimed at a fair count. It is aimed at trying to obtain, in my view, votes for Vice President Gore that were appropriately not cast on November 7th.
That is New York Governor George Pataki, accompanied by Montana Governor Mark Roscoe. The issue in this news conference, the Republicans are saying they will not address any partial recounts that have resulted from this hand recount before it was stopped by the United States Supreme Court, even though the Democrats are reporting results which give Al Gore a few more votes. Officially, George Bush has been certified as the winner in Florida by 537 votes. But we shall see. After the break, Wendell Goler from the Gore camp, Carl Cameron from the Bush camp, Andrew Napolitano still with me. We'll be right back.
Come on, NSN.
You Decide 2000, exclusively on the Fox News Channel. Powerful coverage from America's election headquarters. John Scott, Bridget Quinn, David Asman, Linda Vester, Shepard Smith, Neil Cavuto. Fair and balanced reporting from America's election team, giving you the power to decide. You Decide 2000, from the most powerful name in news, Fox News Channel. We report, you decide.
If making money were simple, we'd all be millionaires. Let's face it, money decisions are tough decisions. You need to know what's going on here and how it will affect your finances, your future, and your family. We cover the markets in plain English so that when the bell rings, you can understand what happened and decide what's right for you. We bring Wall Street to Main Street so maybe you can live on Easy Street.
Remember him? He was such a jerk.
A complete jerk, but so cute.
So wrong.
Yeah, but
everybody told you.
I know, but I didn't want to hear it.
You listen to me.
That's different. I trust you. When you tell me something, I know it's the truth.
Well, in that case, trust me. That was one ugly dress.
Hey, kid, come on over here. I want to show you something. I want you to listen to me now, okay? Because you got to get this ready, or else you're never going to make it. Now, if it goes over too much way this here, it's no good. If it falls over this way too much, it falls all over you. You got to make sure you got balance.
Balance?
All right.
Yesterday, the Gore team was up with a decision from the Florida Supreme Court. Today, the Gore team is down when the U.S. Supreme Court has stepped in and stopped the manual recount in the state of Florida. All 67 counties doing a manual recount of the so-called undervote ballots, which showed no vote for president. That has now been stopped dead in its track until hearings on Monday morning at 11 a.m. The Democrats are reporting that Al Gore, in the partial recount, the partial hand recount, is up a few votes. The Republicans are refusing to acknowledge any partial results, and they say simply that George W. Bush now stands as the certified winner of Florida at 537 votes, pending any further court action. Let's go now to Wendell Goler in Washington to tell us what is going on in the Gore camp. He will be followed by Carl Cameron in Austin to tell us what's happening in the Bush camp. Wendell, you go first.
John, the U.S. Supreme Court ruling stunned the Gore campaign, which had been heartened not just by yesterday's Florida Supreme Court ruling, but by a ruling by the U.S. Court of Appeals earlier today, in which George W. Bush's attempt to stop the hand recount was denied. You could say the Florida Supreme Court yesterday administered CPR to the Gore campaign, and campaign chair William Daley said last night, let the count begin, not just to try and get it done by a probable Tuesday deadline, but to get Gore ahead in votes for the first time this election. Gore advisor Ron Klain says in 13 Florida counties that either completed their hand recounts or reported partial results, the vice president had made up somewhere between a quarter and a third of George W. Bush's lead.
In partial counts or full counts, we gained votes, they gained votes. The net of all those results, based on the latest data, was Vice President Gore gaining a net of 58 votes. And again, some of those were from very Republican counties. In Escambia County, which is a very heavily Republican county, we net gained 3 votes, which obviously is not a big gain, but it's in one of their counties.
The Gore camp felt it was on the way to seizing the lead in this race, and they feel it was important to gain a lead, not only so that it would be difficult for the Florida legislature to certify a slate of Republican electors, but also because it would be difficult for a court to, in effect, repeal what looked like a Gore victory once he gained the lead and give the race back to George W. Bush. Now that may not be necessary. The Bush camp is certainly pleased with the Supreme Court ruling, as we hear from our own Carl Cameron in Austin. Carl?
Hiya, Wendell. Well, the Bush campaign basically says they are not going to discuss the partial recounts because when partial recounts are discussed, as we saw on election night, they can sometimes be misleading. I got a little bit of audio feedback here in my ear as we go forward, Wendell. The reality of this, for the Bush campaign's perspective, is that it has not been entirely Republican precincts that have been counted, as the Gore spokesperson has suggested, but that indeed in Miami-Dade County, one of the largest counties in Florida, it was in fact Democratic precincts that were counted first, according to the canvassing board members, and that they were about to move into the more Republican-leaning precincts of that particular county when Gore's lead had been up to about 150 votes net gain in Miami-Dade, and that they thoroughly expected, even some of the Democrats taking part in that process before it was aborted, that in fact George W. Bush would catch up and that whatever lead there was might be eradicated. So they are not talking about the partial recounts now because they ultimately think that they could prove meaningless. And we saw tremendous vacillations up and down during the Palm Beach County recounts, as well as in Miami-Dade and Broward County. Those recounts, of course, that were now some 2.5 weeks old. Texas Governor George W. Bush, pretty laid back, as he has been throughout this process. He is at his rural ranch in Crawford, Texas. He spent a little time with some friends driving around the ranch today, made a few phone calls, heard from his campaign manager, Don Evans, and was alerted by cell phone that, in fact, the recount process had been given a stay by the U.S. Supreme Court. The Bush campaign is downplaying their enthusiasm or excitement to all this, noting that it is what many people had expected, that it would end up in the highest court in the land for them to adjudicate. Let's go back to John in New York. Hi, John.
Hey, Carl, thanks a lot. Let me ask Wendell a question while we make sure that your audio problem is straightened out. Wendell.
It is.
Oh, it is now. Good. Wendell, the decision it came with a concurrence from Justice Scalia in which there's some indication from the legal experts we've talked to so far that there is presently a 5-4 a split on the court in Mr. Bush's favor. What does the Gore camp think about the current split of the U.S. Supreme Court?
Well, we heard the Vice President's attorney, David Boies, say that what this means is that there was a possibility, not even, he wouldn't even say a probability, that the plaintiff, in this case George W. Bush's argument, would prevail. The person, of course, that we feel represents the swing vote here is Justice Sandra Day O'Connor. And the attempt will be made to persuade her that counting the Florida votes, manually counting the undercounted Florida votes, we should be specific, represents an attempt to get at what the machines could not, and that is the intent of the voters. That was, however, the toughest bit of news in this ruling, Justice Scalia's assertion that in this separate opinion, or concurring opinion, that it looked like George W. Bush would prevail on Monday when the Supreme Court hears the arguments. John?
Wendell, Goler in Washington and Carl Cameron in Austin. Gents, are fresh run out of time, and I've got to go to a break. When we come back, we will go to Florida and Republican State Representative Mario Diaz-Balart about what the Florida legislature is going to do now that the recount has been stopped. We'll be right back.
No. You know, we agree on just one thing. A good argument's the best way to get to the core of an issue.
Wait a minute, I don't agree with that. A discussion's the best way. You have to explain, reason, justify your position.
Everybody on TV is discussing things, Alan. That's boring. If you want to find out what people really think, you need a good argument.
No, a discussion's better.
An argument.
A discussion.
We can agree on this. It's your turn to pick up the check today.
Well, I'll argue that one.
Alan, let's see if we can discuss this.
Grandpa, that's the whole story. That's what happened.
Okay. Katie, now you tell me what happened.
Well, but Grandpa, I just told you.
Well, it's only fair if we hear her side.
What, you don't believe me?
Oh, now wait a second. It's important to hear both sides of the story so that we can understand everything that happened.
Grandpa, can I tell you my side?
Oh, yes, go ahead.
When I was playing, Greg just came over and pushed me. I wasn't doing anything.
Okay, Greg, now what about...
Remember him? He was such a jerk.
A complete jerk, but so cute.
So wrong.
Yeah, but
everybody told you.
I know, but I didn't want to hear it.
You listen to me.
That's different. I trust you. When you tell me something, I know it's the truth.
Well, in that case, trust me. That was one ugly dress.
Come first to Fox News for breaking news, exclusive stories that impact the world, unique, timely interviews that shape our nation. First on the scene with breaking news, continuous coverage from over 70 bureaus around the globe.
We're the only ones here who still have live pictures out.
Reporters, anchors, and correspondents that are first, fair, balanced, powerful insight, powerful perspective, powerful news. Come first to Fox News for breaking news.
That can always give you double miles at these places every day. Just watch how quickly those double miles add up to your free vacation travel. Always double miles from Delta.
Come first to Fox News for breaking news, exclusive stories that impact the world, unique, timely interviews that shape our nation. First on the scene with breaking news, continuous coverage from over 70 bureaus around the globe.
We're the only ones here who still have live pictures out.
Reporters, anchors, and correspondents that are first, fair, balanced, powerful insight, powerful perspective, powerful news. Come first to Fox News for breaking news.
Fox News Channel Daytime. The whole story in context. Facts presented fairly. The issues balanced so you have the power to think for yourself. Fair and balanced. The most powerful name in news. Fox News Channel. We report, you decide.
A little bit earlier, and we've been telling you all day, the United States Supreme Court has stopped the hand recount in Florida. Now, Fox Fair and Balanced. A little while ago, we talked to Florida Democratic State Representative Susan Buchter. Now we talked to Republican Mario Diaz-Balart of the Florida State Legislature. Mr. Diaz-Balart, now that the U.S. Supreme Court has stepped in and stopped this hand recount, what happens in the Florida legislature with this notion that you and your colleagues will be naming a set of electors for Mr. Bush? Do you go ahead or do you hold your hand?
No, I think we need to continue, and we need to go ahead. We need to follow the Constitution of the United States. The only thing that's happened a little different, and quite a bit different, is that the Supreme Court of Florida, in a what, again, its own Chief Justice said was a decision not based at all on law, they have once again muddied the waters even further. They have once again changed the rules of the election after the elections. They have once again stampeded the rights and the powers of the legislature. So we need to make sure that the 6 million votes in the state of Florida are counted. That only happens if our delegates are counted. And despite the fact that others, like the Supreme Court of Florida, may be making decisions that are in violation of the United States Supreme Court and the United States Constitution, I think we clearly need to follow the Constitution, because we all swore an oath to protect and defend the Constitution of the United States. And we need to proceed and make sure that we fulfill that oath and make sure that all of the votes of the state of Florida are counted. That only happens if our delegates are seated when it's time to count them.
Mr. Diaz-Balart, if you would, please stay with us. I've got to take a quick break. When we come back, more on the United States Supreme Court decision. The hand recount in Florida has been stopped. Hearings in the U.S. Supreme Court on Monday at 11 o'clock. Which way will this go? We'll talk about it right after this quick break. You are watching Fox News Live with John Gibson. When we come back, more from Mr. Diaz-Balart, more from our correspondents. The U.S. Supreme Court has jumped in. We're going to figure out how deep they have got us in. A quick break, and then we will be back. Stay with us.
Come first to Fox News for breaking news, exclusive stories that impact the world, unique, timely interviews that shape our nation. First on the scene with breaking news, continuous coverage from over 70 bureaus around the globe.
We're the only ones here who still have live pictures out.
Reporters, anchors, and correspondents that are first, fair, balanced, powerful insight, powerful perspective, powerful news. Come first to Fox News for breaking news.
Fox News Channel Daytime. The whole story in context. Facts presented fairly. The issues balanced, so you have the power to think for yourself. Fair and balanced. The most powerful name in news. Fox News Channel. We report, you decide.
Hey, kid, come on over here. I want to show you something. I want you to listen to me now, okay? Because you're going to get this read or else you're never going to make it. Now, if it goes over too much way this here, it's no good. If it falls over this way too much, it falls all over you. You got to make sure you got balance.
Balance?
All right.
邪悪な魔力と戦うために選ばれた一人の戦士、フォックスが放つニュータイプのエンターテイメント、キュートでクールなスーパーヒロイン
お待たせ。
バフィー、恋する十字架。彼女は高校生、彼女は恋する少女、彼女はヴァンパイアスレイヤー。
I'm Sarah Michelle Gellar。
ヴァンパイアと戦うことが彼女の使命。
運命だったのよ。
信じますね。
信じますよ。
運命の人がいたらいいな、見てほしいです。
頭がぶっ飛ぶのが愛。
君とは戦わない。切ない恋の行方はフォックスが放つニュータイプのエンターテイメント、キュートでクールなスーパーヒロイン。
Supreme Court thought he was wrong and stopped it dead in its tracks, at least pending a hearing on Monday. We are joined now in Florida by Representative Mario Diaz-Balart, a Republican of the Florida State Legislature. Mr. Diaz-Balart, the governor, George W. Bush, has said that he hopes to get a clean win in the courts without having to rely on the Florida State Legislature to name a slate of electors in his favor, without having to rely on the United States House of Representatives to approve that slate of electors. At this point, could your action actually undermine Mr. Bush's legitimate claim to the presidency?
We are not here to help Bush or help Gore. What we're here to do is to protect the Constitution of the United States of America. And under Article 2, as the United States Supreme Court recently ruled, we have an obligation to make sure that our delegates are counted, that those 6 million electors are not disenfranchised. So, again, we have a constitutional obligation, which we take very seriously, and we're going to proceed to make sure that those delegates are seated, that they're not subject to challenge. And I think the only way to do that is by us doing our job, unless, of course, the United States Supreme Court intervenes.
Well, Mr. Diaz-Balart, I'm quite sure that you want to make sure that the Constitution of the United States is upheld. And I am talking about a situation that is a little less lofty than the United States Constitution, and that is the political realities of the fact that this is a razor-thin win, whether it is Al Gore or George W. Bush. It is by the smallest of margins. And that the legitimacy of the person taking the office, taking the Oval Office under those circumstances would be questioned anyway. What George W. Bush is saying is he doesn't need it to be any worse by the Florida legislature taking action that it doesn't need to take.
Well, I understand that, but with all due respect to those that might question whether we should be going forward or not, they don't have a bone to pick with the Florida legislature, as our speaker has said. They have a bone to pick with Madison and Hamilton and our founding fathers who wrote the Constitution of the United States. And we are here to protect and defend the Constitution of the United States, and that's what we must do. Clearly, what the Supreme Court of Florida has done is in an opinion that even its Supreme Court, the Chief Justice of that Supreme Court has said is not based on the law. What they have done is they have muddied the waters even further, which I think then means that we need to continue to do what we're going to do. We need to protect and defend the Constitution of the United States of America. When we took that oath of office, we didn't say we're going to protect the Constitution of the United States except for Article 2, Section 1, Clause 2. No, we said we're going to protect and defend the Constitution of the United States of America. That's all we're doing. And again, if somebody has a problem with us protecting the Constitution of the United States of America, they need to take it up with Hamilton and Jefferson and Franklin and Madison and those that founded our great nation.
Representative Mario Diaz-Balart, recognizing that Madison et al. Aren't around to take it up with, they may have to come to you anyway. We thank you for your time, and good luck this week as events unfold in Tallahassee. Joining me now, not only my good friend Andrew Napolitano, our Fox News legal analyst, the former judge of the State Court of New Jersey, but Susan Bloch. Susan, where are you? Are you in Washington?
Yes. I'm in your studio in Washington.
Fabulous. So what do you think about today's decision from the court, evidently a 5-4 split on this stay, stopping everything right where it is pending Monday's hearings? There's been considerable legal opinion expressed today that today's decision kind of tips the hand of the court, and that it appears the court is teed up to go Mr. Bush's way.
Well, you only need 4 votes to grant cert, but you need 5 votes to grant the stay. So they clearly had 5 votes to grant the stay. And in order to grant the stay, you have to decide both that there's irreparable injury in continuing the count and that there's a substantial likelihood that Bush will prevail on the merits. So, yeah, we have 5 people on the court saying that Bush is likely to succeed.
Judge Napolitano, is it possible that part of the reason the court did what it did is, as Ms. Bloch and others have commented, it appears there's a 5-4 split on the court in Mr. Bush's favor, and that to allow this count to continue and then later say, don't tally this count, would undermine the authority and the authenticity of the court itself.
Oh, that's the exact argument that the Bush camp made, because, as was just quite properly explained to us, the first requirement before you can intercede like this is to show the substantial likelihood of immediate and irreparable harm. That's the key to your question, irreparable harm. Would George Bush's presidency be undermined in the minds of the American public if the count proceeded and Al Gore prevailed at the end of the count, and then the court invalidated this counting that was to have gone on this weekend? That's what would be, in the minds of the court and the Bush lawyers, the harm that was irreparable by any means.
Susan Bloch, I know the court doesn't always act in its own interest, but in this particular case, is it possible the court was trying to protect its own reputation? That in the face of a hand recount that showed Al Gore ahead, it would be in no position to say that count doesn't count?
Well, I think there may be something to that. But I was hoping that the court in all this would act as close to unanimously as possible, because I think they risk a bigger risk here in effectively deciding who's the president by a 5-4 vote. I think that there's the risk that they will look partisan. And I was very sorry when the Florida Supreme Court was tarred with that label, and I really would hate to see the U.S. Supreme Court tarred with that label.
But do you really think, Professor, that the U.S. Supreme Court could allow this Florida decision to stand when they had earlier this week said, we want you to address two things. One, where does your authority come from? And it's got to come from the legislature. They spent 40 pages justifying that. But two, how do you reconcile these changes you've made with a federal statute enacted by the Congress which says you can't change the manner or the time or the method of counting votes after 6 days before the election? Now, you've read this opinion, as have I. The federal statute that prohibits those changes is cited in the opinion, and they simply say we're cognizant of that. That's the end of it. They don't attempt to reconcile that federal prohibition in changes with the changes that they made. Do you think the U.S. Supreme Court would just let that stand?
Well, actually, I disagree with your reading of the federal statute. The federal statute does not say you can't change things. It says it's a safe harbor provision, which means that if within 6 days, before 6 days of the December 18th date, you have certified voters, electors, and in accordance with prior law, then that will be the presumed correct slate of electors. It doesn't say you can't change things. Also, as I read Justice Scalia's opinion issued today, he's now moved off the Article 2 issue that he was concerned about last week. Now he's more concerned with an equal protection argument. So I think the Florida Supreme Court actually effectively answered the U.S. Supreme Court, and they've insulated that part of their opinion. Now it's a question of whether there's an equal protection violation, which is a wholly new
Susan
concern.
The equal protection question would be, let me put it this way, is it that the Florida Supreme Court ordered a recount and at the same time issued this vague instruction on how to look at ballots, how to count them by hand, and issued no statewide standard? Is that the equal protection violation you're talking about? In other words, that some votes would be counted differently than others?
That's what Scalia seems to be concerned about in today's ruling. But the Florida Supreme Court yesterday said they were in accordance with Florida law, Florida statutes, saying you take what the voter's intent is. Now, I realize that's
vague
subjective.
At best.
Right. But it is what Florida law provides. So they're not creating anything new. And the argument that for different counties to count voters' intent differently is an equal protection concern is a problematic argument, because Florida law allows all the different counties. They use different voting techniques. Some use the punch ballot, some use the whatever you call the thing where you write it in. So no one I don't think, in this country demands that a state use the same techniques in all counties. That would be a new requirement, and I think states would have to conform to it, but that would be new.
Susan Bloch, thanks for joining us. Susan Bloch of Georgetown University Law School. Andrew Napolitano is going to remain with us. We're going to take a break. When we come back, we'll continue to talk about the United States Supreme Court stopping the hand count in mid-count in Florida. The Dems say that Al Gore gained 54 votes. The Republicans say we're not going to discuss any partial recounts. George Bush has won by 537 votes. That's that. Hearings on Monday. We'll be right back.
Come first to Fox News for breaking news, exclusive stories that impact the world, unique, timely interviews that shape our nation. First on the scene with breaking news, continuous coverage from over 70 bureaus around the globe.
We're the only ones here who still have live pictures out.
Reporters, anchors, and correspondents that are first, fair, balanced. Powerful insight, powerful perspective, powerful news. Come first to Fox News for breaking news.
Fox News Channel Daytime. The whole story in context. Facts presented fairly. The issues balanced, so you have the power to think for yourself. Fair and balanced. The most powerful name in news. Fox News Channel. We report, you decide.
Fox presents.
邪悪な魔力と戦うために選ばれた一人の戦士。フォックスが放つニュータイプのエンターテイメント。キュートでクールなスーパーヒロイン。
お待たせ。
バフィー、恋する十字架。彼女は高校生。彼女は恋する少女。彼女はヴァンパイアスレイヤー。
I'm Sarah Michelle Gellar.
ヴァンパイアと戦うことが彼女の使命。
運命だったのよ。
信じますね。
信じますよ。運命の人がいたらいいな、いてほしいです。
頭がぶっ飛ぶのが愛。
君とは戦わない。切ない恋の行方はフォックスが放つニュータイプのエンターテイメント。キュートでクールなスーパーヒロイン。バフィー、恋する十字架。毎週木曜夜10時。宿命の対決か、運命の恋か。Only on Fox。
Yeah, I know. We want to get you updated on the very latest in the presidential elections, and for that, we go now to Carol Iavana at the Fox News desk. Hi, Carol.
Hello, John. Thanks very much, and hello to all of you. And here is the very latest. The U.S. Supreme Court has ordered an emergency stay to stop the new Florida hand recounts. The ruling came in response to a motion by the Bush team. Bush lawyers had filed an appeal last night challenging yesterday's surprise ruling by Florida's state Supreme Court that hand recounts over so-called undervotes begin immediately in all 67 Florida counties. Today's order from the U.S. Supreme Court came on a 5-4 vote split along conservative and liberal lines. The nation's highest court has agreed to hear 90 minutes of oral arguments on the issue on Monday at 11 a.m. Eastern Time. In the meantime, the Texas governor has put planning for his Republican administration on hold. Bush had planned for a victory celebration in Austin this week. Instead, he and his wife, Laura, are back at their ranch north of Austin. His running mate, Dick Cheney, is spending the day at the Bush transition office in suburban Washington. Gore's lawyers had filed a reply to the U.S. Supreme Court this morning, asking the court to let the counting continue while the federal justices decide whether to take up Bush's appeal. Gore's lawyers argue that a halt in the vote counting process would only serve to delay the election's ultimate resolution. Early returns from several of the counties had found Gore picking up a couple of votes and trimming Bush's lead to 191. But as word spread of today's U.S. Supreme Court decision, recounts came to a stop in Florida. In a conference call earlier today, Gore told about 36 supporters, quote, "Despite great pressure, you fought valiantly for our democratic values." And the battle goes on over the sanctity of overseas ballots. Federal Judge Maurice Paul has rejected a challenge to more than 2,000 overseas ballots that were counted after Election Day in Florida. Judge Paul says a Florida regulation allowing 10 extra days for overseas votes to arrive is valid. Most of the votes in question were cast by soldiers and sailors. The case was originally filed in state court, but Florida Governor Jeb Bush successfully fought to have the case heard in federal court. I'm Carol Iavana in Fox Central. Now let's go back to Fox News Live with John Gibson for more of our coverage of the ballot battle in Florida. John?
Okay, Carol, thanks a lot. I should tell everybody in this weird election court drama we've been watching now for God knows how many weeks, probably the weirdest situation of all is about to come up. In the Leon County courtroom of Judge Terry Lewis, there is a hearing coming up in a few moments about what we're not quite sure. The judge will not be present. He will be on the speakerphone. The attorneys will be in the courtroom arguing something. What this could possibly be about, since the United States Supreme Court has stepped in to stop the recount, we don't know, but we'll bring that strange little court drama to you when it occurs. Meanwhile, two newly re-elected congressmen are here to talking about this continuing drama. Congressman Anthony Weiner, a Democrat from here in New York, and Congressman Roy Blunt, a Republican from Missouri. Thanks to both of you for joining us. Congressman Weiner, first of all, yesterday the Democrats were going, oh, thank God the Florida court has jumped in and saved us. Today, it's from high to low, right?
I tell you, it's like the boxer who's been hit with so many rights, he's begging for a left. You know, I don't know what's going to happen next, but this is definitely a bad blow because we had finally reached the point where we were counting votes. And I think that the Gore campaign, and frankly, a lot of Americans were saying, let's just see what's in those votes. Now I fear that the Supreme Court has sent a signal that they don't really want to know what's in those votes for fear that they're going to have to overturn an election. I mean, the bottom line is what happened today was the Supreme Court said, don't count votes. And I think that's a bad thing for America, but certainly a bad thing for Al Gore.
Roy Blunt, isn't it true that what the Supreme Court said, not to argue with the congressman too much, but that the Supreme Court said don't count votes until we have a hearing about whether we're going to count them?
They said that, and I think they also probably in their mind are thinking, don't count votes until you explain to us how you're getting the authority to do all these things judicially that haven't been done legislatively, and why do you want to count votes? How can you count votes consistently, and how can you count votes differently that they've been counted in Florida for the last 10 years?
Congressman Weiner, yesterday the Florida Supreme Court said, okay, begin the recount, but what they didn't do was articulate a precise way to recount. And that did seem to bother Justice Scalia in his concurring opinion today. Do you wish that yesterday the Florida Supreme Court had said, do count dimples, don't count hanging chads, something that would at least have set a standard for all 67 counties in Florida? Well,
if Scalia has a beef, it's with the Florida legislature, whose language of their law says that when doing a recount, you try to determine, quote, the intent of the voter. I think the Florida Supreme Court was so concerned about not overreaching and not writing new law, they left that same standard. And if you saw today as the recounts were starting all across the state of Florida, everyone was reading back like a mantra, do your best to determine the intent of the voter. They were saying that because that's what the Florida legislature said the standard should be. That is the standard. I'm not crazy about it either, to be honest with you. But the Florida legislature left that standard, and that's what the Florida Supreme Court said. And that's why I think that as a reviewable matter, the Supreme Court's going to have a tough time quarreling with that aspect of it, because that really is what the Florida legislature said.
Congressman Blunt, did you want to say something about the standard?
You know, I used to be the Secretary of State in Missouri. I was the chief election official there, and the Florida legislature also said, as most legislatures do, that the election authorities with automatic equipment have some ability to prescribe the way votes are counted. And in these counties where dimpled chads and whatever other kinds of things were now counted in some of these recounts that had never been counted before, they consistently had never been counted in those counties for a decade. You can't come in after the election and say we're going to change the rules, because there's actually a federal law that prohibits that.
Congressman Weiner, none of this is going to satisfy everybody at this point, whatever the result is. If it comes down to a choice between 100 votes in Florida that were counted with some sort of dimple or hanging chad, or one vote in the United States Supreme Court, which of those scenarios better legitimizes either man for president?
I think the United States Supreme Court does a service to the country by looking at these issues. They do a disservice by saying, let's look at them without having counted and looked at all the evidence, essentially, in the case. I have been perhaps a minority among my Democratic colleagues in thinking the Supreme Court can serve a very valuable role in legitimizing whatever result emerges from this. And unlike Secretary Baker, I'm not going to do court bashing. I think they made a mistake today, but I respect their view, and I'm going to respect it whatever they decide next week. But I think the best way to determine this is to have this count done under Florida law, as the Florida Supreme Court
But you would
laid out.
accept 67 different standards?
67 different standards. I would accept the one very vague standard the Florida legislature came up with. You know, we here in New York have crummy election laws, but they make Florida look, look even worse. I have to say that the quarrel that many people seem to have about the different standards is a product of Florida having many different standards throughout their state and having an election law that is vaguely written. The court quoted, part of the election law that says that the court can, in a contest phase, provide any relief appropriate under the circumstances. Well, a recount is relief.
Congressman Blunt, when you were a Secretary of State in Missouri, do you consider it, I guess I should say what I think to preface this question. It seems to me that it is the height of ego for either one of these candidates to think that someone entered the booth, voted the bottom of the ticket, and had to have voted for the top of the ticket. That somehow these undervotes must be a vote for somebody. It seems to me perfectly logical that somebody could have voted all the bottom of the ticket, got up to the top and said, you know what, I just can't vote for either one of these guys. I'm not going to vote. If that is the case, how is it conscionable to turn that no vote for anybody into a vote for somebody?
Well, not only could that happen, John, but I know people that did that, and I suspect you do too. Said I can
name 2 or 3 presidential elections where I know I did it.
Well, and people who did it this time who told you, I got there, I thought I was going to vote for one of these 2 people. I just couldn't do it, but I couldn't quite vote for the other guy either, and may have even started to vote. And then they clearly vote the rest of their ballot everywhere else. That's why this, Anthony's point is the one very vague standard that the Florida court advanced again is really not the kind of standard we ought to be using here. We ought to be using a consistent standard, at least the standard that was used on Election Day or would have been used in past elections to count these ballots.
Anthony, looking ahead to Monday, use your crystal ball. What do you think is going to happen before the U.S. Supremes?
Well, you don't need much of a crystal ball. When you read the decision today by the court, you see a very stark contrast. I have to say, given the fact that 5 justices, I figure Scalia went to his buddies and said, listen, do you have 5 votes here? They would not have stopped the vote if they were going to rule for Gore. They would want the bolstering of the full count if they were going to rule for Gore. I think it's a very troubling sign for Al Gore. I think these votes are going to get counted. Unfortunately, they may get counted after the election. Some politician or some political science professor or some reporter is going to go in there and take a look at them and say, never mind the ones that are blank like you described, the ones that are hanging, there's going to be a Freedom of Information Act within weeks after this thing. Someone's going to tally these votes.
No. The Freedom of Information Act specifically does not extend to ballots. In virtually every state, and surely in Florida, the ballots are sealed after the final count, and they are destroyed sealed. The Freedom of Information, I've heard this on the floor of the House a number of times, the Freedom of Information Act does not apply to ballots. There have never been any ballots recounted anywhere ever or reviewed anywhere ever under the Freedom of Information
Act. So long as there's no personal information attendant to those ballots, those things can be counted. I got to tell you something.
I will have to leave this debate in the We Shall See department. Thanks to Anthony Weiner and Roy Blunt for coming in. Just around the corner on Fox News Live, open phones time. What is on your mind? What do you think about what the United States Supreme Court did? Give me a shout, 1-888-TEL-FOX. And if you can't get through, it is time to email. The internet address is live@foxnews.com. We'll be right back.
You know, some mornings this is just too much. Especially when it's cold and nasty outside. But you're my pal. You're always there for me, unlike some people. And I'm not gonna let you down. Come on, man, let's go outside. So, Cosmo, got any big plans for today?
Decide 2000, exclusively on the Fox News Channel. Powerful coverage from America's election headquarters. Review: Shepard Smith, Bill O'Reilly, Hannity and Colmes, Paula Zahn. Fair and balanced reporting from America's election team, giving you the power to decide. You Decide 2000, from the most powerful name in news, Fox News Channel. We report, you decide. Power. 24 hours, 7 days. The most powerful name in news brings you the world. Fox News Channel, the power to bring you the people and places, from mega markets to emerging nations. Reports that make a difference. Power to cover the events that shape the planet, the global forces changing your life. The power of Fox News Channel. News and information, fair and balanced. The most powerful name in news, Fox News Channel. We report, you decide.
What, you got the tickets? You bet I'm there. I'll pick you up. Oh, wait a second. You know, I can't make it. No, I can't. Yeah, it's pretty important. I gotta go. Okay, I'll talk to you later. There's Daddy's little girl.
There's nothing new going on in Washington. No new issues, scandals, or controversy, because Washington has always been a hotbed of egos, emotions, and intrigue. The only difference now is that the press and media are all over it, with more cameras and more reporters than ever before. But how can you be sure you're getting the whole story, fair and balanced? Well, watch the political fireworks here and catch the best show around.
Come first to Fox News for breaking news, exclusive stories that impact the world, unique, timely interviews that shape our nation. First on the scene with breaking news, continuous coverage from over 70 bureaus around the globe.
We're the only ones here who still have live pictures out.
Reporters, anchors, and correspondents that are first, fair, balanced, powerful insight, powerful perspective, powerful news. Come first to Fox News for breaking news.
Handling.
So we are waiting for an emergency hearing in the courtroom of Judge Terry Lewis, Leon County Court in Tallahassee. What it's about is the Republicans complaining to the judge that the Democrats violated judicial order by discussing partial recount totals in the recount that was underway when the U.S. Supreme Court stopped it. Judge Terry Lewis will not be present in the courtroom. He will be on a speakerphone, but the lawyers will be in the court, and we will bring you that hearing when it happens. Meanwhile, it's open phones time. We're taking your calls. 1-888-TEL-FOX. Lucy in Massachusetts. Lucy, are you there? Lucy, stand by just a second. I'm hearing that the hearing has begun in Terry Lewis's courtroom in Tallahassee. Let's listen in to the hearing.
Formally or informally, end quote. We have respected and abided by the court's order, and we have not released or reported on partial vote totals that we found to be very encouraging. Unfortunately, Your Honor, Vice President Gore's campaign has released and reported on partial vote counts. And not only that, but the numbers that they released, when they released them, were inaccurate from earlier in the day and did not reflect what had happened later in the day. Your Honor, what I'd like to do is quote, this was a spokesman for the Gore campaign, Ron Klain, who is the head of the Florida Recount effort for Mr. Gore. He was standing next to David Boies at the time he made this statement at 4:05 p.m. on CNN, and I'm quoting him now. First and foremost, we are actually quite pleased with the progress being made at the counts underway here in a number of counties. Our latest information shows that 13 counties had completely or partially completed their recounts, and in those counties, Vice President Gore and Senator Lieberman had gained a net of 58 votes. 5 of those counties were heavily Republican counties. So we believe that progress was made in the count thus far, indicated that we were clearly on a path for Vice President Gore and Senator Lieberman to make up the difference and to pull ahead had the count been fully completed. As I said, Your Honor, the information that they gave was inaccurate at the time, but setting that aside, we think that it is in violation of the court's order. And also, Your Honor, in this regard, when the United States Supreme Court stayed the recount, Justice Scalia noted, and I'm quoting him, "The counting of votes that are of questionable legality does, in my view, threaten irreparable harm to petitioner," that is George W. Bush, "and to the country by casting a cloud upon what he claims to be the legitimacy of his election." And Your Honor, those were the same concerns that the counsel for the Secretary of State and I articulated last night when we asked you for this order, that neither side should be using partial, incomplete results, which all results would be until Your Honor passed on them, in order to somehow undermine and cast a cloud over the legitimacy of the presidency of the person who is, in fact, going to be elected. So we would ask Your Honor for instructions to the Gore legal team and campaign staff that henceforth they abide by the court's order on remand and that no further discussion and release of partial vote counts should take place.
Who's there for the other side? Your Honor, Mitchell Berger, and I'm here with my colleague Jeffrey Robinson on behalf of Vice President Gore and Senator Lieberman. In terms of your order, Your Honor, we did not understand it to be a gag order. If that's what the court.
Mr. Berger, I can barely hear you. Can you get closer to the phone?
Yes, Your Honor. In terms of your order, we didn't understand it to be a gag order. We understand that there are certainly reports both from the press and from the other side about the vote tallies to this point. What we understood your order to be was that the canvassing board should not release totals until the end. If we were in error, we certainly are. We certainly don't want to incur the court's wrath. But right now, we didn't see anything in this order that required the parties or the press to be gagged.
Your Honor, this is Phil Beck again. We certainly haven't asked that the press be gagged. We haven't complained that the press reported the comments made by the Gore staff, but we think that pretty clearly the court's order, if it bound anybody, it bound the two campaigns and their lawyers not to be releasing and reporting on fragmentary information because the purpose that Your Honor ordered the recount was not to give one side political ammunition to kind of undermine the presidency of the other, but was to fulfill the mandate of the Florida Supreme Court. But we don't think that these numbers, especially inaccurate and partial ones, ought to be misused in that way, and we ask the court to instruct the parties. We have not asked that anybody be held in contempt. We've not asked that any sanctions be imposed, but rather we've asked that the court reiterate to the parties precisely that they should not be misusing this information in this way.
Your Honor, if I might be heard just briefly, again, I haven't watched much TV in the last 4 or 5 weeks. It's my understanding that Secretary Baker was also commenting upon the results to this point, and others were too. I have that on information and belief. I've only been here, I've heard about this 10 minutes ago.
Still, you're breaking up a little bit.
Yeah, I'm sorry, Your Honor, that Secretary Baker also commented upon the results in his news conference, although maybe not as specifically as Mr. Klain. And certainly, if the court wants to instruct us further on that, we will certainly hear further instruction for both sides. However, I think it's clear that both sides might be under a misunderstanding as to what the court intended.
What I had in mind when I put that in the order was I wanted the counts to go smoothly and without the kind of circus atmosphere that I feared might result if there was a lot of people objecting, a lot of people going out and reporting on what was happening and what the counts were. And I think given Judge Scalia's remarks in the stay, that is a concern that people speculate on what may or may not have been in the votes before they're all counted. I don't know practically how I could keep people who can find out. These are public records. Eventually somebody will do that, and somebody will, a counter somewhere will say, well, there was more Bush or there were more Gore votes when I was there, and suggest some number, and who knows whether it's accurate or not. It's going to be very hard to put a blanket order on anybody, but I think the parties, at least, in light of the fact that this is going to be before the U.S. Supreme Court, apparently on Monday, would be wise not to cross the Justice Scalia's line that he drew there. So my concern is a little bit dissipated now that my order, essentially I vacated, or the Supreme Court's order is what I was following. It told me to do a manual recount, so I was doing my best to do it. And now that order's been vacated, so I said, well, stop doing the recount. But to the extent that that order applies, it applies to the people who were going to do the count, so that there wasn't a confusion, there wasn't this sort of endless speculation about what was going to happen. I'm not quite sure what I can do further than what I've done to enforce that order, but if somebody at this point needs clarification, that's what I meant by that. Can you, Mr. Berger, can y'all...
Judge Terry Lewis trying to figure out what to do about the fact that one party, the Democratic side, has released partial results when both parties were to remain silent about the partial results of the recount that was stopped in mid-count by the United States Supreme Court. We're going to take a break. When we come back, we'll find out what lots of other experts think about the United States Supreme Court stopping the hand count in Florida. Hearing on Monday. More after this quick break. Stay with us.
Hey, kid, come on over here. I want to show you something. I want you to listen to me now, okay? Because you got to get this read or else you're never going to make it. Now, if it goes over too much way this here, it's no good. If it falls over this way too much, it falls all over you. You got to make sure you got balance.
Balance?
All right.
What, you got the tickets? You bet I'm there. I'll pick you up. Oh, wait a second. I can't make it. No, I can't. Yeah, it's pretty important. I gotta go. Okay, I'll talk to you later. There's Daddy's little girl.
Mother Nature takes her toll, raging against the elements. Fox News Channel is there, bringing you the updates. From the eye of the storms to the aftermath of destruction. Make Fox News Channel your only source for complete...
With Neil Cavuto and Brenda Butner, as usual, so be sure to tune in there. Meanwhile, what a day, what a day. First, Florida goes into high gear to count all those uncounted ballots. Then, the United States Supreme Court brings it all to a screeching halt. Joining us now, Fox News correspondents Jim Engel in Tallahassee, William LaJeunesse in Clearwater, David Lee Miller in Jacksonville. I'm going to start with... back to Jim Engel at the top. Jim Engel in Tallahassee, bring us up to date on where we stand. I believe it could be safely said we are at a full stop.
We are at a full stop now, but getting there was a dizzying turn of events, John. I mean, first, as Secretary Baker, James Baker came out today and said, one day you're up and one day you're down. It actually, in this case, it's 1 hour you're up, 1 hour you're down. We started with the Supreme Court here in Florida on Friday, ordering the recount. The Gore people were jubilant to start off on this. The judge orders the recount to go forward, sets a target of 2 p.m. Sunday. Today, the U.S. Supreme Court steps in and halts the recount and says it will hear the case on Monday at 11, so that both sides will be going in, arguing over whether or not the recount should go forward. One of the key issues, of course, whether or not there should be uniform standards and whether or not the Supreme Supreme Court should speak to that issue. In the meantime, you've got the partial recount that had been going on here and in many other counties around Florida, some of which had completed their recount, some were part through. Here in this county, for instance, they got about 4,000 of the 9,000 votes from Miami-Dade County, the undervotes, those that did not have a clear choice for president marked, though they got about 4,000 of the 9,000 counted. Now, what happened is that the Democrats came out, Ron Klain of the Gore campaign, and boldly announced some numbers, saying that in the partial and full recounts in 13 counties, that Al Gore had picked up 58 votes, and as he put it, was clearly on a path